We're live.
Okay. It is February the 15th, 2022. This is the House Judiciary Committee. We have a range of different bills today that we're going to be hearing. We will have 5 of those bills will be bills that we've heard in the past. So they're going to be 2 minutes for the sponsor and 1 minute for the witnesses. Those bill numbers are 560, 645, 606. And so that's 560 is Delegate Hornberger's bill, 645 is Delegate Jackson's bill, 606 is Delegate Cox's bill, 604 from Delegate Davis, and 481. These are bills that are in virtually the same form as they were before. 481 is Delegate Moon's bill. Everybody else's bill is working on a 3 and 2 rule, the 3 minutes for the sponsor and 2 minutes for everybody else. With that, we'll get on with it. And we'll go to House Bill 692, which has just one witness, the Carroll County Delegation Bill, and I believe that's Delegate Rose, correct? All right,
Yes.
That's fine.
Yes.
Delegate Rose on House Bill 692.
Thank you so much, Mr. Chair, Vice Chair Moon, and members of the Judiciary Committee. I thank you. I'm Delegate April Rose, current Carroll County Delegation Chair, here today to present House Bill 692, a local delegation bill. The intent of the bill is fairly simple. It is clarifying that the Office of State's Attorney is prohibited from private practice. Currently in law, in statute, it says shall serve full time. This will be to clarify that the state's attorney shall serve full time and may not engage in the private practice of law. Currently only Carroll, Garrett, and Baltimore City do not explicitly prohibit the practice, but we felt as a policy decision that it was important that this should be clarified. I would like to note in 2017, the salary of our state's attorney in Carroll County was tied to that of a district court judge via Senate Bill 456 and currently sits at $161,333 per year. At that time, the delegation did not realize that the private practice of law was not prohibited by statute. In 1990, the sitting state's attorney at the time was given a raise on the condition that he discontinue his outside practice. It was made an official office policy in 1994, is it written policy in the handbook, and it does prohibit outside practice for both this position as well as the assistant state's attorney. And this bill will enshrine that current best practices go into statute, which the delegation assumed was already in place decades ago. The current staff of the state's attorney's office stands with 20 attorneys, 32 support staff, and holds approximately 15,000 hearings per year. With all of that being said, and the fact that we have tied this salary to a competitive salary in order to attract the best talent for the position, we feel that it's important to make this change, and I ask for your consideration and a favorable report on House Bill 692.
All right, are there questions for Delegate Rose? All right, seeing none, we thank you very much. That'll conclude the testimony for House Bill 692, and we appreciate you coming by. Thank you.
Thank you.
All right, now we're going to go to Delegate McKay, who apparently has twice as many witnesses as the previous bill. House Bill 549 has 2 witnesses. We'll hear from Delegate McKay for 3 minutes, and we'll hear from Melanie Shapiro for 2 minutes. So we can bring Ms. Shapiro in, that would be fine. Delegate McKay, if you're ready to go ahead. We'll start your 3 minutes.
Well, thank you there, Chair Clippinger and Vice Chair Moon and members of the Judiciary Committee. Yes, my name is Delegate Mike McKay, and I am here to present House Bill 549. Now, the purpose of this bill is to increase from $10,000 to $45,000 the maximum compensation that may be awarded to the CICB per claimant in specified psychiatric, psychological, or mental health counseling. It also does prohibit the CICB from setting maximum compensation award thresholds that are lower than the specific thresholds in the statutes. Now, corrections, fire, police, and EMS men and women risk their lives each and every day for you and for our families. However, injuries do occur on the job that are a result of criminal actions. This bill is being brought to you forward, not so much to help someone now, but help somebody in the future. Not so long ago, an unnamed EMS paramedic unfortunately was raped on the job. The chaplain of the fire company tried to help her with her mental health treatments needed for this particular paramedic. And unfortunately, the cap that is currently defined in the CICB is limited, and this EMS paramedic had to cover her mental health treatments out-of-pocket expenses. Now, fortunately, they had loved ones and those in the member of their fire service to help her out, but at the end of the day, mental health matters. So what is more important, mental health or physical health? The link between physical and mental health is complex, but the simple answer is that your body needs both mental health and physical health too, to function properly and live a happy and healthy life. Please note that the fiscal note states that the bill can be implemented with existing budget resources. Therefore, I urge you a favorable vote on House Bill 549 because there should be equity or equality, I should say, when providing physical and/or mental health services when the victim compensation claim arises. Thank you.
All right, we'll hear now from Melanie Shapiro for 2 minutes.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. Melanie Shapiro with the Maryland Network Against Domestic Violence, testifying in support of House Bill 549. I'd like to thank Delegate McKay for bringing this bill. Victim compensation is an important part of the recovery process. And as Delegate McKay has indicated, that the psychological injuries and psychiatric injuries, they often outlast sometimes the physical injuries that occurred. And it sometimes is a lifelong impairment that people must learn to live with. So we are in full support of increasing this amount. While there are challenges sometimes for victims seeking compensation, we definitely support the increase. And as the delegate has noted, there is no fiscal impact. So we are urging a favorable report. Thank you.
Thank you very much. Are there questions for this panel? All right, seeing no questions for the panel, we thank you all very much. That concludes the testimony for House Bill 549. Thank you. And we will move on then to a bill that is a 2-minute, 1-minute bill. We're looking for Delegate Hornberger. Oh, no, we're not. Well, wait a minute. What am I looking at here? It says 560 is next. No, I'm told I'm wrong. So we're going to Delegate Jackson next. And I see him, so that's fine. So House Bill 645 is a bill that is in the same posture which it was introduced last year. We'll have 2 minutes for Delegate Jackson, 1 minute for the one witness he has, and we'll go from there. So Delegate Jackson, please, for 2 minutes.
For 2 minutes. All right. Good afternoon, Mr. Chair and members of the Judiciary Committee. Thank you for having me here today. I am proud to again offer HB 645, which would add making a false statement to a police officer to the list of hate crimes if it is done so based on a person's race, color, religious beliefs, sexual orientation, gender, disability, or national origin. Last year, I introduced this bill in response to an unfortunate situation that occurred in New York City Central Park that was widely reported on national news, but since that time, we have seen innumerable examples of this same sort of behavior. In the Central Park case, a Black gentleman named Christian Cooper was out bird watching when he came upon a white woman named Amy Cooper, no relation, and her dog, who was not on a leash. He politely asked her to abide by the park rule that dogs must be leashed in that area. Rather than comply with this simple request, she told him that she would call the cops and tell them that there was an African-American man threatening my life, quote unquote, which she then proceeded to do, clearly trying to use his race in a false police report to intimidate him. Christian Cooper was videotaping the encounter at the time, which proved her to not only be falsifying that report, but also pretending to be attacked while on the phone with the operator. Her intent was clear, though, to escalate the situation and use the fact that he was a Black man to somehow get him in trouble with law enforcement. Thankfully, the situation was not escalated because Mr. Cooper calm demeanor and his foresight in taking the video, but it could have ended in tragedy and in the imprisonment of an innocent man or worse. As I had said, this is just one of many high-profile instances where law enforcement was called based on someone's race. The prevalence of cell phone cameras is bringing this problem to the public notice in a way that was unheard even 5 years ago. Maryland, as a state, must be proactive instead of reactive in discouraging this racially motivated behavior. With the hate crime legislation already law in Maryland, I think that adding making a false statement to a police officer to that category makes, let me start over. With hate crime legislation already law in Maryland, I think that adding making a false statement to a police officer to that category of crimes just makes sense. For the record, last year.
Yeah, if you want to wrap it up a little bit, we'll get there.
Oh, okay.
That's right.
I forgot, sorry.
No, you're right.
You want me to finish?
If you wouldn't mind just in a couple
wrapping
sentences.
it up. Okay, wrap it up. For the record, last year, this bill was voted out of committee and passed the House of Delegates. With that being said, I respectfully request another favorable report. Thank you for your time.
All right, thank you. We're going to hear now from John Cox from the Baltimore County State's Attorney's Office. Go ahead, Mr. Cox.
Thank you, Chair Clipping, Vice Chair Moon, and members of the Judiciary Committee. I am John Cox. I'm Deputy State's Attorney in Baltimore County, here to support Delegate Jackson's legislation. I'm happy to hear that it went through the House last year, and hopefully I don't need to say much. But I want to express Mr. Schellenberger, unfortunately, could not be here because he's working on the budget for our office in a meeting. But it's extremely important to him also. This is something that it is, I shouldn't say vital, but extremely important to demonstrate that activity of this nature is not going to be tolerated. Delegate Jackson gave the classic example that we all know about in Central Park. I remember another one that happened shortly thereafter in which a young African-American man was accused of stealing an iPhone. I think that was also in New York City. But this is something that we think and feel strongly should be something that should be tagged. Somebody motivated by racial hatred and trying to report a crime unjustifiably about another individual ought to be addressed and ought to be called exactly what it is. Thank you.
All right, thank you very much. Are there questions for this panel? Seeing none, we thank you very much for your testimony today on the bill, on House Bill 645. Appreciate your time. And that concludes the testimony for that legislation. Thank you very much.
All right, thank you, Mr. Chair.
Thank you. I just was asking staff if I've got this right. I believe that the next bill is Delegate Cox's bill because that's the next bill in my stack, but I'm just making 100% sure. I'm wrong again. It's actually Delegate Hornberger's bill. So why don't we do that? And then I'll figure this out someday. Let's go to House Bill 560. This is Delegate Hornberger's bill.
Thank you, Mr. Chair and Vice Chair Moon. For the record, Delegate Kevin Hornberger on behalf of HB 560. This is a consumer safety firework bill. Some of the members of the committee may remember this bill from previous years, and we've actually strengthened it with some input from the State Fire Marshal's Office for this year's presentation. What this bill seeks to do is that currently in Maryland, there are 2 tiers of fireworks. This bill would create a 3rd tier. It would beef up the regulation for the use and display of that 3rd tier. These are for your large aerial displays that you might go to and visit with your family on the 4th of July. And it would also create more opportunity for consumers to buy fireworks in a more stringently regulated market, as well as where those fireworks are sold. If you look at your packet, you will see a letter from the Maryland State Firemen's Association in support of the bill. Because it does have so many safety measures included. We've also got an amendment that is still being drafted that will further strengthen based on NFPA guidance, how these are regulated. But just some background, currently those 3 tiers that exist, where your first tier is your sparklers, et cetera. Second tier being handheld and ground-based fireworks, which there are current restrictions in some counties on, others do not have. And this bill passage would not impact any local regulations that are placed, nor would it impede future local legislation on fireworks. So we feel that this is a good consumer and safety bill, and we'd ask for a favorable report, and I'm love to take any questions.
All right. Let's go now to Robert Phillips from the State Firefighters Association. Robert Phillips, if you're there. Mr. Phillips?
Yes, sir.
Go ahead. You have
I'm very sorry. I was on another call.
That's all right. A minute to testify. Go ahead.
Yes, Bob Phillips. I am the chairman of the MSFA Legislative Committee. And we're here to speak in favor of House Bill 560. We feel that this bill does clarify legislation here in the state, takes it in line with other legislation and other definitions of what fireworks are, so that someone coming into our state, if they're coming from another state or a federal jurisdiction, we will have the same definitions with them. It does define who can buy them, who can display them, can they possess them, where they can use them, and it has a definition that crosses many lines, where before we had our own definitions that I think was somewhat confusing. On behalf of the Maryland State Firefighters Association, I would ask that the committee do favorably report on this bill.
All right.
That is it,
Thank
sir.
you very much.
Thank you, sir. I appreciate
All
your
right.
time.
Hang on there and we'll see if there are any questions for you. Are there any questions for Delegate Hornberger? Mr. Phillips. Delegate Shoemaker.
Thank you, Mr. Chair. I get this is for my friend Delegate Hornberger. So, you know, we Appalachian American folks, we like our fireworks. So, I mean, could you give us an example of what type of fireworks would be in this third tier that's before us in this bill?
Sure, and thank you for that question. The third tier, which is also referred to as Class C, would include firecrackers, Roman candles, bottle rockets, and similar fireworks that contain a maximum of 50 milligrams of explosive material. And this would move those into a more clearly defined class to where the folks that could purchase those and use those, and then we'll also set up strict standards on where they can use those. Right now, Maryland kind of exists in a gray area. And that's why oftentimes, I'm sure you'll get constituent concerns. My neighbor's setting off fireworks, the kids are in the streets setting off fireworks. Police are reluctant to arrest those because we have such an ambiguous interpretation of fireworks. So again, pro-safety and pro-consumer, but great question and happy to answer any others.
Thank you.
Are there any further questions for the panel? Seeing none, we thank you all very much.
Thank you, Mr.
And
Chair.
that concludes the testimony for House Bill 560. Moving right along. Now we're going to Delegate Cox's bill, House Bill 606. This is a reintroduction from last year. Set to testify as Delegate Cox, Andrew Pallara, and Amanda Long. Delegate Cox will get 2 minutes. The two witnesses will each get 1 minute. There are people to testify in opposition. So Delegate Cox, for 2 minutes, please.
Thank you, Mr. Chair, and my esteemed colleagues. This bill would require sex offenders to not live within 1,000 feet of a school or other facility where children congregate. And You might recall from last year that one of the incidences that occurred was an individual in the constituent neighborhood that was using his cameras to point them at a playground next to his house and to watch children. He was a registered sex offender. This created great alarm, and upon investigation, the police determined that because there was no residency restriction for the area, then they could not do anything about the concerns. The important thing to note since last year is that now there's over 30 states that have residency restrictions for registered sex offenders to be away from areas where children congregate, particularly playgrounds and schools. You might remember last year we passed a bill as a body to prevent sex offenders from entering school property. So in a sense, this is not much different in that it allows for protection from predators who would point their cameras and be in close proximity and able to build relationships with people, with children as they walk to school or as they are at a playground. These are the things that have demonstrated a problem with the recidivism rate, that proximity to children does increase recidivism and obviously endangers children. And when you look at the constitutional questions that some of the opponents may discuss, they are without merit because, like I said, over 30 states have these laws now, including the great conservative bastions of California and Illinois and many other more diverse states across the country. So the Supreme Court has dealt with this issue as have federal courts, and they have consistently upheld the standards as lawful under the Constitution. And so I would urge a favorable report. And I thank you for your time and listening to the advocates.
Thank you very much. We'll hear from Andrew Pallara, please, for 1 minute. Andrew Pallara.
Yes, thank you, Chairman and members of the committee. Just want to take this opportunity to discuss House Bill. Maryland Statute 11-722 restricts registered sex offenders from being on public school properties as well as elementary schools and other child care facilities. So this bill just kind of extends that current border to 1,000 feet. Another item to consider is also the majority of child sex abuse victims happen with someone that they know, that the child knows. So children are going to know their neighbors. So by not allowing registered sex offenders living within these areas, helps expand that border, helps expand that protection to them, helps add another layer of protection for our children while they're at school and child daycare centers. Thank you.
All right, thank you. We'll hear now from Amanda Long, please, for 1 minute.
Hello. The primary concerns raised in opposition of this bill last year were grandfathering in existing residents, which the amended bill does, and the belief that restrictions result in an increase in homelessness. There's no data that proves a correlation between residency restrictions and an increase in homelessness. In fact, when you examine the data on homelessness per state, you'll find that the states with the strictest restrictions have a lower rate of homelessness on average versus the states without restrictions. Alabama, for example, precludes sex offenders from living within 2,000 feet of schools or childcare facilities, and they're ranked 49th in homelessness, compared to just about every state on the top 10 for homelessness: DC, New York, Hawaii, California, Oregon, Washington, Massachusetts, Alaska, Nevada, and Vermont. 7 of these states have no restrictions, while 3 have very loose and unenforced restrictions. I'm not suggesting that these restrictions result in less homelessness, but at the very least, there is no increase in homelessness when you examine the raw data from 2019 published by the U.S. Interagency Council on Homelessness. I'm hopeful that with these amendments and additional information, you will reconsider your position and vote in favor of this bill. Thank you for your time and your dedication to keeping our community safe.
Thank you very much. Are there questions for the bill's sponsor or the panel? Delegate Cox, what bus system do Baltimore City Public School students use?
I'm sorry, Mr. Chair, did you say what bus system?
Yes.
That's a great question that you would be the expert on since you represent that area. So
They use the Mass Transit Administration's bus stops all across the city of Baltimore. So with this bill, no one could live within 1,000 feet of a bus stop in the city of Baltimore. Are there further questions for this panel? Seeing none, thank you very much. That concludes the questions for those in favor of the legislation. We're going to go to the people who are opposed to the legislation. Louis Berman, Gary Kleiman, and Michael Gross, and Mikhail Gross, that's right. And Brenda Jones, I'm sorry, I missed that one. Brenda Jones. We'll go to Brenda Jones first.
Hi, I am here. Sorry, I was listening and I have to get my feed turned off real quick.
All right, well, you're on now, so we'll
Yes,
hear you
sir.
for a minute, okay?
Yes, I'm good. I've just got to get over to my browser and turn the dang thing off. Sorry about that.
Okay,
All right. Thank you. Very good. I had Brenda Jones with FAIR. And did you say how many minutes I had, sir? I missed-
1 minute.
1
Go
minute.
ahead.
I better get going then. I just want to point out very quickly then, you have our full testimony with FAIR there in your folders, virtual or otherwise. And I do want to mention that in terms of the idea of homelessness, I thought it was interesting that they're mentioning homelessness in general, not homelessness in specific, as far as I can tell. People are going to get banned at 1,000 feet from entire communities. There are maps of a couple of spots. One is a tiny town, one is a chunk of Baltimore, and they would get banned from entire towns. This would indeed cause homelessness, and there is research to support that in the event that persons who are restricted from being able to live in a stable environment, that they actually are more likely also to wind up going off grid. So if the idea is to track people, you can actually have more trouble with that. There was also a mention of the Constitution. I do want to point out that while it may be true in some other states that there's been some case law going, we have case law here in this state that—
Ms. Jones,
Yeah.
that is your minute.
That is my minute. All right. But there is
All
a case law here. The Constitution would
Thank
be
you.
violated in Maryland. Thank you, sir.
Thank you very much. Louis Berman, please, for 1 minute.
Yes, can you hear me?
Yes.
Good. Thank you. Well, I am Louis Berman. I'm with FAIR, and I'm opposed to this bill. I think it's a very badly written bill. There's still, even with the so-called improvement. One problem with it, Delegate Cox said would be banned from places near schools and whatever, and there's a big problem with whatever. It's the language is vague. It's open to different interpretation. What's a designated school bus stop? We just brought that up with the city buses. What's a child care facility? Is it only marked child care facilities? Is it home daycare? What's a park? What is especially a place where children congregate? Is that some next door neighbor's yard? You can't move in because 2 houses down there's a bunch of children that play in the backyard every once in a while. The other thing, the churches, synagogues, etc. You also have the idea that it's very impractical and difficult and expensive to enforce. They would have to make, law enforcement would have to maintain lists of all these zones and bus stops and everything else. Yes.
I need you to wrap up quickly, please.
Okay, difficult and expensive to enforce, and also it's redundant because people are already, violators are already subject to on parole and probation, distancing from their victims, etc.
Thank you very much. Gary Kleiman, please, for a minute. No Gary. All right, from the Office of the Public Defender, Ms. Gross, please.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland. I'm testifying today in opposition to HB 606. This bill won't actually achieve the goal of making people safer, and instead this misguided legislation is unnecessary and harmful to individual registrants, to their families, and to the community. Research shows that those convicted of sex offenses are unlikely to reoffend, and the recidivism rates discussed by the sponsor are nearly non-existent. But registration laws don't recognize that. Registrants are already barred from housing, jobs, and services, and they're prevented from going to schools and childcare, even when their children attend those schools. They are already dealing with onerous registration requirements that come at a great cost to taxpayers. And this bill would just further ostracize not just them, but their families. As to specific problems with the bill, I know others have mentioned, as both Mr. Berman and the chair have mentioned, language is vague. And what are we saying to the children of those who are on the registry? They're already bullied at school. This bill would prevent them from living near a school bus stop or from within walking distance so that they can go to school on their own, which is necessary because their parents are prohibited from taking them to school. This bill goes against the goal of rehabilitating people, ostracizing those who are integral parts of our community. This is demonstrated by the story of so many stories of clients of ours. Yes, I am wrapping up. So many stories of clients of ours, including what we included in our written testimony, a story of a client we referred to as William. That's in our written testimony. I won't go into that story here because of the lack of time. And I will end by saying that sex offender registries are contrary to public safety and they're harmful to our communities. And for these reasons, we urge an unfavorable report.
Are there questions for the panel in opposition? All right. We thank you all very much for your testimony. That concludes the testimony on House Bill 606. Now, I believe we are going to House Bill, 822. That's right? Sure. House Bill 822. This is Delegate Williams. We're going to hear from Delegate Williams, Lisa Jordan. This is a new bill, so 3 minutes for Delegate Williams, then 2 minutes for Lisa Jordan, Melanie Shapiro. There is one person in opposition, so we'll just hear from the favorable panel first. Delegate Williams, please, for 3 minutes.
Yes, good afternoon, Chair Clippinger, Vice Chair Moon, and members of the House Judiciary Committee. I'm Delegate Nicole Williams and testifying today in favor of House Bill 822, also known as the Criminal Procedures Victims' Rights Dismissal of Charges. This bill pertains to defendants who are deemed incompetent to stand trial and the rights of victims in the judicial process. As the law currently stands, charges can be dismissed after a certain period of time against defendants who are considered to be incompetent to stand trial upon motion by the defendant. The prosecutor can file a motion or petition the court to extend the time of the dismissal of the pending charges for extraordinary cause. However, a victim cannot request that a court extend the time of dismissal of the pending charges for extraordinary cause under the current statute. This issue was highlighted by the Maryland Court of Special Appeals in the case of MO versus the state of Maryland, which were an appeal of a case originating from Washington County. In that particular case, the defendant was found incompetent to stand trial, and upon 5 years after the charges had been pending, filed a motion to dismiss the case because the requisite amount of time had elapsed. The state did file an opposition in that case, but did not request denial of the defendant's request, did not file a request to deny the defendant's request for extraordinary cause. The victim in that case, however, did request that the charges not be dismissed for extraordinary cause. However, the court did not consider the victim's argument. The lower court then granted the dismissal of the charges. In the opinion by the appellate court, they stated that it's undisputed that the state did not petition the court to extend the time for extraordinary cause. And while it's not dispositive, it's also undisputed that the victim, through his representative, was allowed to present his views on whether the facts demonstrated extraordinary cause. However, the court acknowledged that those views they were unable to go over those views simply because of the plain language of the statute. This bill simply modifies the plain language of the statute to allow for a victim to present his view on whether or not the facts demonstrate extraordinary cause. At the end of the day, the court is still the final arbiter of whether a victim's request should be granted based on the circumstances of the case, and does not prevent the defendant from still seeking dismissal of the charges. However, this bill is simply to allow the victim the right to bring forth such a motion. And for these reasons, I urge this committee to give a favorable report to House Bill 822.
Melanie Shapiro for 2 minutes, please.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. Melanie Shapiro, Public Policy Director with the Maryland Network Against Domestic Violence. I'd like to thank Delegate Williams for bringing this bill. And as Delegate Williams has already stated, this is not to suggest that there should be an extension of time. What this bill is really about is victims' rights and victim standings. And I believe that in the underlying case, the Delegate Williams referenced, it's an unreported opinion, but the court indicated that there are 12 circumstances already existing in law when victims can appeal. And what we are seeking and what this bill would accomplish is allowing a victim the right to appeal. That does not currently exist in circumstances of a person being found not criminally responsible. Victims' rights are enshrined in Maryland's Constitution, as well as throughout both case law as well as statutory law. And if an individual is found not criminally responsible, if the individual is charged with a felony or crime of violence under 14101, the court must dismiss the charges after whether the lesser of either 5 years or the maximum sentence for the most serious charge. And in misdemeanor cases, it's 3 years or the maximum sentence for the most serious charge. And this is merely an opportunity for a victim with extraordinary cause to get a case back before a court to determine if that is an appropriate length of time. So for all of those reasons, we urge a favorable report on House Bill 822.
Thank you very much. I have Lisa Jordan on here as well. Now Lisa is here, so we'll, yes.
Thank you, Mr.
Our brave new normal, I think, is being demonstrated right here. I believe Ms. Jordan is across the street. 2 minutes to Lisa Jordan, please.
Yes, thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault, testifying to you live from the hallway outside of the Judicial Proceedings Committee. We are here in favor of House Bill 822. You've already heard from Delegate Williams and from my colleague, Melanie Shapiro, about the reasons for this. I will say, just for history, if it wasn't given before, that this is a very important piece of the law. There were people who were being unfairly detained for many years with an NCR. And I think that this was really just an oversight that survivors of the crimes were not allowed to participate and bring to the court the extraordinary circumstances that might mean that you should keep the offender under supervision for a longer period of time. The case that prompted this is attached to my testimony. I hope you have a chance to look through this. It really is a very horrifying case involving a sex offender who offended several times, contacted this victim, contacted the family, and the court was simply unable to continue the supervision of the NCR defendant because of this deficiency in the code. So for those reasons, we urge a favorable.
Okay, we'll now take questions for those in favor, and we'll hear first from Delegate McComas.
Okay, I apologize, but real quick question. If the person is, let's say, very, very dangerous, okay, and the victim does not ask to be extended and we don't pass this law, is there any right now on the books protection for society because the person's just really, really dangerous?
I mean, the prosecution can always file a motion in, requesting that the defendant's request be denied.
Okay. Do you know how successful those are?
Quantitatively, I don't know off the top of my head.
I think it's a good bill. I really do. So, But I was just, I would guess I was worried about the really serious person that's, you know, just dangerous to the general public as well as the victim. So thank you.
Delegate Davis.
Thank you, Mr. Chair. My question is regarding the standard that you're using. I'm sorry, I forgot it. The extenuating cause or something. Can you
Extraordinary cause.
Extraordinary cause. Can you give me another example? Not the one Ms. Jordan spoke of, but just another couple of examples of what an extraordinary cause might be.
And I don't have the statute directly in front of me, but the statute kind of lays out the different factors that the court has to look at in order to determine whether or not extraordinary cause currently exists. This bill does not change those standards in any way, fashion, or form. It just simply allows the victim to bring forth that request in their motion to the court. But usually it's a very high bar. It is a very high bar, Delegate Davis, in order to meet that standard. It's not, from my understanding, it's not something that's granted that often because it is such a high bar to meet.
And this bill would do, how would that change it?
It doesn't change the standard at all. It just simply allows, so right now, only the prosecution can request that the defendant's request for dismissal of the charges be denied for extraordinary cause. This bill simply would allow either the prosecution or the victim to basically state that the defendant's request should be denied based on extraordinary cause.
Thank you.
Delegate Cardin.
Thank you very much. Just real quick, Ms. Williams, Delegate Williams, or to your witnesses. So is this so that if the prosecution decides not to file, that the victim can file, or is it because you want to have both the prosecution and the victim both filing to give the prosecution more weight?
It just really allows the victim the ability to raise it if the prosecution fails to raise it, or yes, both the prosecution and the victim can both raise it.
I would just be interested. I don't know if you can answer this now, Ms. Shapiro or Ms. Jordan, or you can get me information. I would be interested to know, are there cases besides this one Washington County case where the prosecution just chose not to raise it, where the victim would? I mean, is this an issue that we're just trying to protect for the future, or is this been happening in the past?
You know, Delegate, I'll take a shot at that. I don't know that there's data that's being collected, and you would kind of be collecting data on a negative. So I'm not sure we'll be able to give you numbers on that. Certainly there are situations where prosecutors either don't file because they don't have time, or there's a disagreement with the family or with the victim. And all this really does is it allows it to then go in front of the court. It's absolutely not automatic. I think that people are very concerned with making sure they're not detaining people for a long period of time in these cases, as happened in the past. So it really is just giving crime victims' rights, which are protected by Maryland's Constitution and statute, a little bit more ability to be enforced by either the prosecution or by the victims.
I have a couple questions. So in these cases where someone has been found to be incompetent, I guess we're talking about incompetent but not a threat to themselves or others, or are we talking about incompetent and a threat to themselves and others? I think
so. Chair Cohen, you're asking to know if they were a threat to themselves or others and they had a major mental illness, then they would be subject to civil commitment. If they don't have all of that, including the major mental illness diagnosis, then they wouldn't be subject to civil commitment. From the facts of this case, it looks like there was not a major mental illness. It was a question of intellectual disability.
So this is just that the person was found incompetent to stand trial. I mean, there are hearings that courts will routinely have as someone's being held throughout the process, where they've found them to be incompetent, and so now we have hearings. We regularly have hearings to do updates on, to say, okay, is the defendant still incompetent to stand trial? Yes, they're incompetent to stand trial. Do we need something where the victim can almost intervene, or is it better to have a requirement that when you're at the end of the 5-year process that the victim be present at whatever hearing would be most proximate to the 5th year prior to the judge having the ability to dismiss the case? And I'm not sure if I'm totally expressing that right, but it feels like there would be a hearing close in time to the end of the 5 years. Should there be some requirement there that a victim receive notification of the hearing and be given the ability to speak?
Well, they do have the ability to speak, so it wasn't a question of input, and that was put into the law when all of this was revised. What Delegate Williams' bill really does is it gives you not only the right to speak, but the right to initiate this action. I have not spoken to the prosecutor in this case, so I'm not sure if it was simply an oversight that they didn't file the motion for extraordinary cause, but there was a crime victims' rights attorney involved. They did file something, and then the court found that kind of the wrong party or wrong person had filed the motion, and that's why this particular defendant was set free and appears to be fairly dangerous to the community. So we have the right to be there. We just want the right to file and ask the court to consider this issue.
Okay. All right. Are there further questions for this panel? Thank you all very much. That concludes the panel in favor of the legislation. We'll now hear from Mary Pizzo from the Office of the Public Defender in opposition to the bill. We'll hear from her for 2 minutes, waiting for her to come on the screen, and there she is. So we'll hear from her for 2 minutes. Mary Pizzo. Mary Pizza, please. I see you. Oh boy. There we go. All right, great. You're muted.
There I go.
That's better. For 2
Hear
minutes.
me and see me? There we
Yes.
go.
2
Good
minutes.
afternoon. My name is Mary Pizzo. I'm with the Forensic Mental Health Division of the Office of the Public Defender, and we respectfully request the committee issue an unfavorable report on this bill. The bill reflects a misunderstanding of the intent of the law regarding competence to stand trial and conflates the provisions regarding competency and criminal responsibility laws, which are distinctly different. Section 312 refers to commitment after a finding of not criminally responsible and has nothing to do with competency to stand trial. And we believe these would really lead to unnecessary legal proceedings that already could be addressed within the confines of the structure. The purpose of laws on competency are to ensure that due process is concerned, not intended to provide for indefinite care and treatment of unadjudicated mentally ill individuals. It is unconstitutional to try a person who is not competent. That's why these proceedings are in place. The judges make competency decisions based on input from clinicians. Victim input may offer a perspective of the impact of an alleged crime, but it has nothing to do with whether the individual has a present ability to participate in the proceedings, which is the due process issue. Dismissal does not mean that a dangerous individual is summarily released. If the individual remains dangerous, the court may civilly commit the person to protect the public, and I believe that is they can do so when somebody is intellectually disabled as well. Also, dismissal is without prejudice. So if there is some likelihood that they may become competent in the future, that they could be re-indicted on those charges. Additionally, Criminal Procedure 3123 currently provides an opportunity for a victim to provide to the state's attorney and to the health department any information that the victim considers relevant. That is, if they have requested that they be notified as a victim under the law. And the court and the department must consider that information in the preparation in making any decisions. Furthermore, extraordinary cause has not been specifically defined. And while it might be expected that victims are concerned with ongoing danger, the Court of Appeals has made clear in a series of cases, and I alluded to them in my written testimony.
Ms. Pizzo, I
Yes.
need you to begin to wrap up, please.
Okay, it's just that the court made clear that dangerousness and restorability are not extraordinary cause for the purposes of extending dismissal. So for that reason, we believe there's already a mechanism in place, and this would just cause further unnecessary litigation. So we would request an
Thank you.
report. Thank you.
Thank you. We'll go, any questions? Seeing none, we thank you very much. And that concludes the testimony on House Bill 822. We're going now to House Bill 817, I think. This is Delegate Shetty's bill. All right, and it's a new bill, so 3 minutes, 2 minutes. We're going to hear from, looks like just the one panel. Yep, just the one panel. Delegate Shetty, Melanie Shapiro, Lori Ruth, and Jessica Garth. And yep, that's fine. So Delegate Shetty, if you want to begin for 3 minutes, that'd be great.
Thank you, Mr. Chair, Vice Chair Moon, members of the esteemed House Judiciary Committee. For the record, Delegate Emily Shetty here to provide testimony in support of HB 817, a bill that will prohibit a conviction for the violation of a protective order from merging with a conviction for certain other crimes when the underlying facts of the case are the same. So the idea for this bill was brought to us by several advocates who are here with us today or have provided written testimony to the committee. Then it came as a result of a recent Court of Special Appeals decision in Morgan v. State. In this case, a defendant was found to have violated a protective order by committing a second-degree assault. I would direct you to take a look at the fiscal note, which provides a great summary of the case's findings and the court's open call to the legislature to address the rule of lenity in this case. The rule of lenity requires that a court examine whether two charged offenses arose out of the same criminal conduct and whether the legislature intended to impose multiple punishments for the separate crimes. Absent specific guidance from the legislature, if a court deems that two offenses have arisen out of the same criminal conduct, then the crimes merge for the purposes of sentencing. In these instances, the lower sentence of the two crimes is applied so as to not unfairly punish the defendant for legislative ambiguity. The General Assembly has identified several areas of criminal law that do not necessarily require sentences to merge, including child abuse and rape. In these instances where two crimes are being charged and convicted for, the sentences imposed are not always merged and can be served consecutively or concurrently. The court is granted discretion to determine what the appropriate sentence should be and is not constrained by the merger doctrine. Currently in Maryland, if a defendant has violated a protective order by physically assaulting an individual, the law is ambiguous and the sentences are merged. A violation of a protective order carries a sentence of up to 90 days incarceration for a first offense or up to 1 year for a second or subsequent offense. But a second-degree assault carries a penalty of up to 10 years incarceration, a fine of up to $2,500 or potentially higher, depending on the victim or both. When the two are merged, a defendant that is convicted of both is only required to serve the lower sentence of 90 days to 1 year. HB 817 would correct this to allow for courts to sentence an individual convicted of both to an appropriate sentence based on the unique facts of the case and the defendant's criminal history. This bill will effectively ensure that those who are under a protective order are sentenced appropriately for committing an act of violence that is also a violation of that protective order. I respectfully request a favorable report on HB 817. Thank you.
All right, we'll go to Melanie Shapiro now for 2 minutes, please. Melanie Shapiro.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. Melanie Shapiro with the Maryland Network Against Domestic Violence, testifying in support of House Bill 817. I will take my time and try and explain, although Delegate Shetty did an excellent job, of the rules we're talking about. The circumstance that it is addressing is that there's an individual that has a protective order, and that protective order has been violated by somebody being found guilty of committing another criminal act. And under the doctrine of merger, which is rooted in actually the double jeopardy clause of the Fifth Amendment, it states that multiple punishments can't stem from the same offense. So the intention is not to have multiple sentences for somebody committing the same thing. Maryland uses what's called the required evidence test. And I did write a fairly lengthy written testimony that explains all of this in more detail. But so if the doctrine, if the merger doctrine applies, we're using the required evidence test. So do the offenses require the same things? So in this case, in assault, you have an assault in the first degree and assault in the second degree. All of the elements are the same, except for an assault in the first degree. You also need to have either a weapon or a higher level of physical injury. So the assault 2 merges into the first degree assault, and you're only sentenced for the assault in the first degree. Now, if there was a theft that was committed as well, the elements of that offense are different and do not merge. So then you have the rule of lenity that says that if the legislature, if the law is unclear whether or not the sentences merge, it's ruled into favor of the defendant. What the court decided in this particular case was that there was, in fact, the required evidence test, the offenses did not merge, but the legislative intent was unclear. So therefore, under the rule of lenity, the individual was sentenced was only eligible under that rule for the up to 90 days. The Court of Special Appeals ultimately dismissed the violation of the protective order, so the individual could be sentenced. But in the case, it made clear that this is an issue for the legislature to address and to make clear whether or not it is the intention that a violation of that is the result of another criminal act for which a person has been tried and found guilty should merge with the protective order. So for all of those reasons, we urge a favorable report on House Bill 817.
All right, thank you. Laurie Ruth, please, for 2 minutes.
Good afternoon, Mr. Chair, members of the committee. My name is Laurie Ruth. I'm the legal director at the Women's Law Center of Maryland. I want to thank Delegate Shetty for bringing this bill. It's really a small technical fix, but the Court of Special Appeals panel was very clear that this is very clearly the legislature's province, and all they have to do is what this bill does, which is say that a violation of protective order will not merge with another sentence. I described this to somebody when I read the Morgan case as, for the low price of a 90-day sentence, he gets to assault his victim and not be subject to that potential 10-year sentence. And what the Morgan court did was, and he ended up vacating the violation of the protective order. The issue with that is that the violation of the protective order sentence has an enhanced sentence for a second violation of the protective order. So this defendant, Mr. Morgan, because they vacated his violation of the protective order in order to give him the higher sentence of second-degree assault, he now, if he violates again, doesn't have that first violation of protective order sentence. So it really eviscerates the validity of a violation of protective order sentence when it happens. And we in the domestic violence field want that violation of protective order to still carry some meat and not be used as a shield when they are violating an existing order to commit a crime. So these are not the small violations like he comes 30 minutes late to bring the child back to me from the child, the court-ordered child access. This is when a crime is committed in the face of an already existing protective order saying, leave this person alone. These tend to be our most dangerous respondents. And that's why we really would like the legislature to make it clear that a violation of protective order does not merge with any other sentence. It's not going to be a huge number of cases, but the cases where they commit the crime that violates the protective order, they're the bad ones. They're the ones who aren't listening to what the law has told them to do. So for those reasons, I also wanted to say the Family Violence Council, the Governor's Family Violence Council also supports this bill. I think they were late getting their testimony in, but for all these reasons, we urge a favorable report. Thank you.
Thank you. Jessica Garth, please, for 2 minutes.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee.
My name is Jessica Garth, and I am the Chief of the Special Victims and Family Violence Unit at the State's Attorney's Office for Prince George's County. I'm here on behalf of the Maryland State's Attorneys Association and State's Attorney Aisha Braveboy to urge a favorable report on House Bill 817. This legislature has recognized the importance of protective orders, both by granting the courts the authority to issue the orders and by providing criminal accountability when those orders are violated. This legislature has further provided that violating a protective order is a distinct and separate charge from any criminal act that also applies to the underlying conduct. For example, an assault may be the conduct that violates the order, but the offender could be charged with both the assault and the violation of that protective order. However, as my colleagues have pointed out, in the recent opinion of Morgan v. State, the Court of Special Appeals held that due to the rule of lenity, a conviction for violation of a protective order and a conviction for the underlying offense must merge. In the case of Morgan, the violation merged with a conviction for second-degree assault. The court held that due to statutory ambiguity, the rule of lenity required this outcome. And House Bill 817 is a simple and straightforward way to resolve that ambiguity by specifically disallowing these convictions to merge. The bill still allows the sentence imposed to be consecutive or concurrent to the underlying offense, which allows the court to have discretion as to sentencing. House Bill 817 is a simple and straightforward way to reduce ambiguity in the law, to ensure that victims of intimate partner violence remain protected, and to ensure that offenders know the penalties that they face. Thank you again for your attention, and I again urge a favorable report.
Questions for the panel? All right, seeing none, we thank you all very much for your testimony today, and that concludes the testimony on House Bill 817. Moving right along. I believe we're going now to House Bill 604. 604. This is Delegate Davis's bill. This is a reintroduction. So 2 minutes for Delegate Davis, 1 minute for the witnesses. There are, let's try and do one full panel. So Linda Moyd, Alexandra Bailey, Nicole Hanson-Mundell, Lucia Reese, Kim Haven, Melissa Rothstein. We'll hear from Delegate Davis for 2 minutes and from everybody else for 1 minute, and we'll go from there. All right. So Delegate Davis, if you'd like to begin, please, for 2 minutes.
Thank you, Mr. Chair. Colleagues, my name is Deborah Davis from District 28 in Charles County. I'm here to present HB 604. It's cross-filed. It's Senate Bill 512 with Senator Hedelman. It was brought last year by Delegate Sidnor, now Senator Sidnor, so I didn't have it last year. But the bill essentially would establish a correctional ombudsman at the Attorney General's office. And for most of my judiciary people, you probably already understand why that's necessary. But let me talk about the Maryland Correctional Enterprises being over a $55 million enterprise. And currently, the Department of Corrections oversees 13 correctional facilities, including the Baltimore Pretrial Unit. Inmates are discouraged from sharing information from behind the walls, from letting us know what's happening. There's no way to know what's happening. COVID has pointed to several things like COVID outbreaks in the institution and things like that are happening. We don't know what's happening behind the wall. And it's incumbent upon family members who call us, who want to know what's happening. It's incumbent for there to be some centralized database or some centralized person who's responsible. I believe, I know there's little or no opposition to this bill, and an ombudsman could make a tremendous difference in the lives of thousands of Marylanders if we could just get the ombudsman in place. I asked you for a favorable report, and I'm excited about you guys hearing from the advocates. Thank you.
Okay. We'll hear from Olinda Moyd, please, for 1 minute.
Good afternoon, everyone. I'm Olinda Moyd. I'm representing the Maryland Alliance for Justice Reform. I'd like to begin by just stating that our organization is made up of individuals who are formerly incarcerated, currently volunteers with the Department of Corrections, and some former staff members of the Department of Corrections. And so as we speak about the issues that are happening as men and women are experiencing behind the walls, we have firsthand information. And so we believe that transparency and accountability are critical, especially in the operation of such a large administration in caring for the men and women behind bars. We believe that the Correctional Ombudsman Office would serve as an early warning system to curb systemic abuses, which really do undermine the goal of rehabilitation. The inmate grievance process does not work. You will hear from others who know that firsthand. We know that litigation is costly and time-consuming, but we also know that regular monitoring and reporting will help to address problems as they occur. We also want you to know that we have received information that Attorney General Frosch supports this bill, and I believe that he has put that information in writing and submitted it to you all. Maryland should join other states who have come to realize and appreciate the value that an ombudsman brings to the table as it relates to correctional oversight. And external oversight is critical because it really does shed light on what happens behind the walls when the light is not shining, and we have to rely on information getting out to know what's really happening. So we urge a favorable report for this bill. Thank you.
Thank you very much. Alexandra Bailey, please, for 1 minute. No Alexandra Bailey. Okay. Nicole Hansen Mundell. Not here.
Good afternoon, Nicole Hansen Mundell, Executive Director of Out for Justice. We are here to wholeheartedly support this bill. Long history of DPS-CS saying one thing verbally and then in their reports doing another. While DPS-CS purports to provide extensive vocational training and reentry support, too many individuals tell us that they are not given access to very limited selection of training opportunities behind the walls, and too often released with no clear plan or support. We see all of the most glaring with women behind the walls. We also know that we hear from our people behind the walls persistently that contradicts what DPS-CS states about individuals' access to basic needs and reentry support. And I know we'll have some colleagues come behind us and, give these stories after stories about we need someone behind those walls that is independent, that can record what is really happening and what isn't happening. And for all those reasons, thank you, Mr. Chair, for allowing me to speak.
Thank you. We'll go now to Kim Haven, please, for 1 minute.
Good afternoon, Mr. Chair, members of the committee. My name is Kimberly Haven. I'm the Executive Director of Forward Justice Maryland and the Policy Liaison for Interfaith Action for Human Rights, here in support of HB 604. I thank Delegate for bringing this to the committee. You've heard me testify many times about you can't fight what you can't see, and you can't see what they don't show you. And that's what this bill will do, will provide a bright light. It also provides a mechanism for individuals who are incarcerated to seek relief from their grievances without any sort of retaliation and reprisal. And this does go on, and it is severe. It is often, and reports have a way of disappearing. I know this firsthand. But one of the other aspects to this, and I want to kind of play the opposite side, is that it also kind of protects from frivolous lawsuits. This person, based on the qualifications that are laid out in this legislation, is someone who would be completely impartial. This is someone who can shine a bright light on what's happening behind our correctional walls. This person would be the voice for the entire system. We need strength. We need understanding. We have no idea. As Nicole said, we see the people when they come out. We hear their stories. We take their phone calls. We get their letters. And it's in opposition to what the department says. And so there has to be a middle ground. This individual would be able to find that middle ground. Would be able. Yes.
You have to begin to wrap up, please.
Okay, this is an important piece of legislation. It is good policy. I urge a favorable report on House Bill 604. Thank you very much, and you'll be hearing from me again shortly. Thank you.
Thank you. Melissa Rothstein, please, for 1 minute.
Okay. Good afternoon. My name is Melissa Rothstein. I'm the Director of Policy and Development at the Maryland Office of the Public Defender. My written testimony provided examples of the wide range of complaints that we receive from clients every day. Our attorneys are very concerned for the health, safety, and well-being of our clients, but we lack the capacity, statutory authority, and expertise to address these issues. The Juvenile Justice Monitoring Unit shows how valuable and effective such an entity can be. OPD's juvenile defenders have provided information to the JJMU with assurance that issues will receive prompt and sufficient attention to encourage positive change without waiting for conditions and their resulting harms to exacerbate. Similar to children in juvenile facilities, people incarcerated in adult facilities have numerous vulnerabilities. The constraints of incarceration, disproportionate poverty, and limited access to community services, and heightened risk factors due to age, medical and or mental health conditions, and demographic factors such as LGBT status or limited English proficiency underscore the need for an independent oversight agency. An independent correctional ombudsman to oversee and investigate systemic problems within Maryland's correctional system is long overdue. So I urge this committee to issue a favorable report on HB 604.
Thank you very much. Are there questions for this panel? I looked up and Delegate Davis shook her head no, so I assume that's for everybody. So that's fine. So seeing no questions, thank you all very much for your testimony today. We have representatives from the Department of Public Safety and Correctional Services who are here to provide testimony in an informational capacity. So we'll hear from them next, each for a minute. Stuart Nathan, Wayne Hill, Annie Harvey, and Jennifer Beskid. Only Wayne and Jen. All right. Well, if Wayne Hill is here, we'll hear from Wayne. Oh, Deputy Secretary. Happens to the best of us, Deputy Secretary. But,
good morning, Chair.
All right. We're going to hear from you for a minute. And then I believe we have Jen Beskid as well. So we'll hear from you and then Ms. Beskid. So go ahead for 1 minute.
Thank you. Good afternoon, Chair Clippinger, Vice Chair Moon, and members of the Judiciary Committee. My name is Wayne Hill. I'm the Deputy Secretary of Operations for the Department of Public Safety and Correctional Services. The Maryland Commission on Correctional Standards was established by the General Assembly. The Commission staff audits correctional facilities to determine levels of compliance, develop audit reports, and provide technical assistance to correct areas of noncompliance and deficiencies. The department is also seeking accreditation for each of its correctional facilities by the American Correctional Association, which is a national entity who ensures each facility they accredit is following the national best practices and standards. 7 of the Division of Corrections' 13 facilities are accredited. In addition to the 2 examples provided, one that was created by the General Assembly and one that the department voluntarily sought to improve standards and training within the profession, the department is also subject to at least 3 other external audits. Realizing the intent of House Bill 604 is to ensure the safety of individuals in the care and custody of the department. The department also has an extensive administrative remedy process, also known as the ARP, and this process will be discussed in more detail. Thank you for your consideration, and I am available for any questions.
All right. Jennifer Beskid, please.
Thank you, Chair Clippinger. I also believe that we signed up Commissioner of Correction Annie Harvey.
We do have Annie Harvey, and Annie Harvey now is in the room, so we'll go to Annie Harvey now. We also have Stuart Nathan signed up as Stuart.
He was only to be available for questions, and something's come up. He's not going to be on.
All right, that's fine. So we'll hear from Annie Harvey. Ms. Beskid, are you going to want to testify after this or no?
Yes, please.
All right, that's fine. Annie Harvey, then please for 1 minute. Go ahead.
Good afternoon, Chair Clippinger and Vice Chair Moon, and members of the Judiciary and Health and Government Operations Committee. My name is Annie Harvey, and I'm the Commissioner of Corrections for the department. The incarcerated population has methods that they may utilize to address concerns about their treatment, including offices dedicated to investigating, responding to, and correcting areas of noncompliance and concerns involving inmate grievances, criminal and administrative allegations of serious misconduct, management and accountability and adherence to medical treatment contracts. The department also has a robust internal investigative division who detectives conduct welfare checks and investigate complaints brought forward through an anonymous tip line. The department also utilizes an administrative remedies procedure, which is governed by COMAR 120228. These regulations establish procedures for an inmate to seek resolution of a complaint through informal resolution with facility staff. In 2021, the department implemented an Office of Constituent Services. This office responds to public information at request, as well as inquiries from family members, loved ones, and other concerned persons. The Department of Public Safety and Correctional Services respectfully requests the committee consider these concerns when deliberating House Bill 604. Thank you.
Thank you very much. I'm going to step away from the chair here for a moment. Jennifer Beskid is next for 1 minute. We'll hear from her, and then there'll be questions after that. So the vice chair will be stepping in now. But for now, 1 minute to Jennifer Beskid, please.
Thank you, and good afternoon, Chair Clippinger, Vice Chairman, and members of the Judiciary Committee. My name is Dr. Jennifer Beskid, and I am the Director of the Office of Government and Legislative Affairs for the department. I'm here today regarding House Bill 604, which would create a correctional ombudsman, a position for which the duties are already being met. The department is already subject to thorough and routine internal and external audits conducted by the Maryland Commission on Correctional Standards, the American Correctional Association, the Office of Legislative Audits, and the Office of Performance Evaluation and Government Accountability. The department is also subject to thorough federal audits and reporting requirements as stipulated by federal law through the Prison Rape Elimination Act. The department has a contract with the Prisoner Rights Information Systems of Maryland, PRISM. PRISM is required to provide legal assistance to individuals incarcerated in state prisons on matters concerning conditions of confinement, sentence calculation, constitutional rights, and claims that affect a serious health, life, or safety concern of an inmate. In 2021, PRISM worked on 6,348 inquiries or complaints. I would like to ask the committee to consider the existing internal and external resources that are already in place for the incarcerated population when deliberating House Bill 604. Thank you.
All right, thank you. It looks like we've got one hand up, Delegate Shetty.
Thank you, Mr. Vice Chair. And thank you to our witnesses for sharing information today about some of the systems currently in place within the department. Many, many years ago, when I first graduated from law school, I worked on Capitol Hill. And among the many issues that I dealt with was actually the criminal justice portfolio. And my boss had me tasked with handling all constituent casework requests that came from the Federal Bureau of Prisons. So we actually had a lot of constituents who were behind the walls who would reach out to my former boss's office and ask, for support dealing with challenges that they were facing within the system. Not everybody got to us, and obviously, not everybody knew to do that. So I'm just curious, within the state system, I know you all have done a great job of outlining a lot of the different resources that exist, but I see this particular ombudsman program is serving a similar role for those who are behind the walls, who are having challenges, who need access, who may be having trouble accessing healthcare, or some, we used to get all kinds of questions asked and service and just needs that we were able to meet just by serving as a liaison in my past capacity. So I'm just curious if you can share a little bit about the constituent services that you all are offering to individuals in your care and custody, and what's a typical turnaround time for responses to requests? Does it vary by facility? Who are people within asked to contact if they're having a problem? Like, what's the system currently in place? And just kind of curious how you think you guys are already handling this. Just helps me understand whether this bill is really needed, which I do, by the way, support. Thank you.
Thank you, Delegate Shetty. I'm actually going to ask Deputy Secretary of Operations Wayne Hill to respond to your question, but just it was a long question, so I just want to make sure that we have what you're asking for. I understand the position of the ombudsman would be to come in and handle again the inquiries that are coming through a variety of ways. So I think at this point, the first step in the process for anyone internally is our administrative remedy process. And I'm going to ask the Deputy Secretary if he'll respond to that, if that's okay.
Thank you, Delegate, for that question. Yes, the first level of that the offender or inmate would have for any problems or issues that they have within the facility is our administrative remedy process. And depending upon what it is, we do normally try to start, as always, at the lowest level possible, which would be an informal complaint. But if the concern is of such that it needs to be brought directly as an administrative remedy request, that is, it goes to the warden of that facility. That request is received, it is logged, it is documented, and it goes out for investigation. The warden has a time frame, and we can get you those time frames. But there is a specific time frame by which the warden must respond to the concern or issue. If the offender is not satisfied with the response that he or she gets from the warden's office, there is an appeal process by which he or she can then appeal to the Commissioner of Correction. That request again is brought to the Commissioner's office, it is logged, and it is investigated, again with a specific time frame according to our policy. If the offender is not then satisfied with that, it goes to before the administrative law judge, and it is again addressed, and a decision is made, and then they can go from there to circuit court if they're not satisfied up to that point.
And just by way of quick follow-up, sir, thank you for that very thorough answer. I know you don't have all the timelines memorized, but just kind of curious, start to finish, what are we talking? Are we talking like years? Are we talking weeks, months for, for the whole process?
No, ma'am. Normally, it's hard to say because it all depends upon when he or she goes to the next level. So right. So I can't give a specific time frame, but it is all dependent upon, and there are extensions that can be given that if the agency says we need more time, they put that request to the inmate, he or she will either agree or not agree to that extension. And so the timeframes may differ.
Okay, thank you. Appreciate it.
All right, next we've got Delegate Crutchfield.
Thank you, Mr. Vice Chair. I wanted to just talk a little bit more to what Delegate Shetty was just mentioning, and that is, are there, kind of walk me through exactly the process. I mean, if the inmate has a concern, how are they getting it to you? Is it written? Is there a form that they use? Do they have to contact outside people to do it? And then is there a limitation on the type of complaints? Can they complain about the temperature, anything? And are those complaints sort of put together, or how is this really done? I want to get to the weeds a little bit. Can you please do that for me, either Ms. Harvey or Deputy Secretary Hill, please?
Thank you, Delegate, for that question. So the first part, there are forms. The administrative remedy is a form that the inmate can fill out to voice his or her complaint. And they are found in the library, they are found in housing units. They can request one from the officer on the unit or in the housing unit. So they are available to all of the inmates in our facilities. So this is just these are the types of things that they can write an ARP about. Correctional facility policy and procedure. They can write on medical and mental health services, access to court, religious liberties, inmate property, to include lost, damaged, stolen, destroyed, or confiscated, complaints against staff, use of force, sentence computation and diminution of confinement, correctional facility conditions, to include health, safety, and welfare, retaliation, commissary, and even our inmate telephone system. So basically anything within the walls of that facility, they have the right to write a complaint about. And again, that complaint will be logged, numbered, and kept at the institution for record.
Vice Chair, may I ask one further question?
Go ahead.
You know, and Deputy Secretary Hill, are those complaints then prioritized? I want to get an understanding of, as Delegate Shetty was earlier mentioning, how long is the complaint process? How, from beginning to ending, are we talking 30 days, 45 days? So if you can take something typically that you guys would receive as a complaint and kind of walk us through how long that complaint process would be until resolution.
Okay, so typically at the institution level, there is a time frame of 30 to 60 days, approximately. And we will get you the exact time frames later. And then that goes to the appeal process. And depending upon the severity, again, there may be extensions asked on behalf of the agency, because we do want to do a thorough investigation. And if we find that we cannot complete that investigation by the timelines that are in our administrative remedy policy, we will ask for an extension so that we can conduct a thorough investigation. And once the investigation is done at the commissioner's level, it then goes before the administrative law judge. That process is then taken out of our hands and is dealt with at that level. So you probably can get a resolution to an initial complaint within 3 months.
Thank you very much, sir.
All right, next we've got Delegate Cham.
Thank you, Vice Chair. I was following along with Mr. Hill's response, and you may have answered it already. It's good to see you, Mr. Hill. So I had a situation to occur over the during the interim where someone reached out to me, an incarcerated individual, and the complaint entailed what he felt was inadequate medical attention. So with regard to this ombudsman that's spelled out in the bill, what would be the role of the ombudsman as far as receiving complaint from the person incarcerated and kind of making its way and seeking some resolution? Did you, I think you may have already spelled that out in your response to Delegate Crutchfield's question. Is it the same process?
You're breaking up, Delegate.
All right, I'll ask again. I'll switch myself to my hotspot. Thank you, Chair. Come back to me later if you can.
Okay, let Delegate Davis, why don't you go, and then we'll flip back to Delegate Cham.
Thank you. Thank you, Mr. Chair. I have a question based upon my own experience. And at the end of this scenario, I'm going to say, is this acceptable to you? And what should have been the solution? Well, I got a call that someone had from the Women's Institute had slipped a note from behind the walls to one of our connections, and they said that it's 95 degrees outside, it's 100+ degrees inside. Because we haven't been able to work in the middle of COVID, we can't buy fans, and the ice machine is down. And so I called the boss, the big boss, because I have influence. I called the big boss, and he says that doesn't exist. And I'm like, I'm talking to somebody who pointed to the fans and said the fans are almost within arm's reach. All they wanted was fans as hot as heck. I said heck, hot as heck in the facility. How do we get to the ice machine? How do we get because there's a standard for how much ice you get a day. How do we get more ice? And how do we get fans? And I had Secretary Green, he says, no, it's not happening. No. He finally got to the facility and identified that it was right there, that it was true. You could touch the fans, and that they should have increased the intake of ice so that people could be at least treated like humans in the facility. And I'm going to tell you, it took 4 days. The heat wave was almost over. My question, is that acceptable? And what can we do about it?
No, ma'am, that is not acceptable. And when we find situations, thank you for that, first of all, Delegate. But when we do find that, we did take away the ice limit during the summer. We did take away that limit because, as you know, it produces more. We took away the limit. And we also purchased individual fans for each offender in our facilities across the state, not only in the women's facility, but in every facility across the state, at no cost to them.
Thank you.
All right, let's flip back to Delegate Cham.
Thanks again, Vice Chair. Can you hear me okay? Am I breaking up? Am I all right? Okay, thank you. So my question was, I received a letter during the interim from an inmate who's incarcerated, and his complaint entailed his, I guess, understanding that he wasn't receiving adequate medical care for a medical condition that he had. So the role of the ombudsman in just that little snippet, not to talk too much about it, but what would be the role of the ombudsman as far as seeking resolution for inmates who are incarcerated, who want to make a complaint about inadequate medical care?
Thank you for that question, Delegate. I'm not sure the role of the ombudsman would be, but for us, that complaint would go directly to a administrative remedy if they wanted to do it in writing. We also, the inmate has the availability to talk directly to our correctional staff, and they can be intercessors if there are, emergencies going on. We do not want an emergency to go by route of an administrative remedy. But for us, during a normal procedure, it would be the administrative remedy process so that we can accurately document times, places, events, so that it can be properly investigated. And that would be one that would go directly to our medical unit at that facility, and they would investigate it. It would not be done by correctional staff.
Vice Chair, if I may.
Go ahead.
In answer to your, also in thank you, and in building on what Deputy Secretary Hill has stated, in answer to your question regarding the role of the ombudsman, that would be something that we need to go back to the sponsor. And I'm sorry, I just lost my thought, so I will leave it at that.
Great. And I believe that without any further questions, that is the end of the testimony on House Bill 604. No one else has signed up, in which case we can shift over to House Bill 756 if we've got Delegate Shalega with us.
I'm here.
Okay, we do have Delegate Shalega, and there are 4 witnesses signed up on this bill: Bridget O'Mullican, Sherry Rendell, Margaret Montori, and Amy Wakehoff. This is a new bill, so there's 3 minutes for the sponsor and 2 minutes for witnesses. So Delegate Shalega, you have 3 minutes whenever you're ready.
Okay, thank you so much, Mr. Chairman. As Maryland continues to struggle to bring our violent crime crisis under control, citizens in Maryland are counting on our public safety professionals to have every tool and all the information possible to keep our communities safe. In our state, with expanding sanctuary policies that protect illegal aliens or undocumented immigrants, whichever term you prefer, the Protecting Marylanders from Violent Crime Act of 2022 requires state and local correctional facilities to comply with ICE detainers for those convicted of violent crimes, terrorism, and participation in criminal gangs. Why do we need this law? Two fairly recent cases in Prince George's County where they ignored ICE detainers on a known MS-13 gang member, Jose Gomez, who had been arrested several times in Prince George's County, yet they released him despite having 5 ICE detainers. The man continued to commit crimes, including assault of a government official in the community, and then he was arrested and released. David Ritana is a convicted sex offender and illegal immigrant with a detainer from ICE. He was arrested again in Prince George's County for failure to register as a sex offender. ICE lodged an immigration detainer with the Prince George's County Detention Center, but they didn't honor that detainer and released him back into the community. Gang members and sex offenders with ICE detainers should be turned over to ICE and not put back into the community. States with these dangerous sanctuary policies are finding themselves subjected to federal subpoenas for information they should readily provide to immigration officials. This lack of cooperation with ICE blocks federal investigations and takes up resources that could be better spent getting violent criminals off our streets. More importantly, releasing violent criminals into the community when they're wanted by ICE endangers the public. On the other hand, North Carolina Mecklenburg County Detention Center, in cooperation with ICE, was able to detain and hold accountable Alfred Lopez, a Maryland fugitive wanted on multiple charges of rape and sexual assault, including sexual abuse of a minor. He was extradited back to Maryland. Victims deserve justice, and cooperation with ICE made that happen. Right now in Anne Arundel County, 6 MS-13 gang members from the Baltimore, Washington area, who call their gang the Fulton Locos, are being held for 2 gruesome murders, including a beheading and gang activities. ICE has detainers on them and will deport them once they're released. Anne Arundel County must cooperate with ICE to protect the public from these dangerous criminals. We really need House Bill 756. Public safety should not be dependent on the political agendas of elected officials. It is narrowly crafted to require cooperating with ICE with regards to terrorism, gang activities, and violent crimes. To be clear, this legislation only impacts people who are in our country illegally and who are being held in jail or detention center for committing a violent crime. No one should want to protect violent criminals, gang members, or terrorists wanted by ICE. This should be an area where we find common ground. Thank you, Mr. Chair.
Thank you very much. So we've got 4 witnesses. We'll take them in this order. Bridget Mulliken, Sherry Rendell, Margaret Montori, and Amy Wakehoff. 2 minutes each. So we can start with Bridget Mulliken when you're ready.
Thank you, Vice Chair and committee members, for allowing me to speak in favor of this House Bill 756. I'm Brigida Mulliken, a naturalized citizen of Rockville, Maryland for over 56 years. I want to thank Delegate Kathy Shalala for sponsoring this bill. This bill will ensure cooperation between the United States Immigration and Customs Enforcement Agency and local law enforcement. It will make our state safer by removing undocumented immigrants convicted of serious crimes or who participated in criminal street gangs, allowing criminal aliens to continue to be a danger to our community is a safety concern to our whole community in all of Maryland. There are many examples of where egregious crimes were committed over and over by illegals who should have been deported by ICE. Citizens are required to follow all laws. Why does the state of Maryland not follow federal immigration laws? Please support this bill to keep Maryland safe from criminal illegals, and thank you.
All right, next we'll hear from Sherry Rundle for 2 minutes.
Vice Chair and other distinguished members of the committee, thanks for allowing me to testify. I am FAIR's Director of State and Local Engagement. We are a nonpartisan, nonprofit organization that advocates for immigration policies that reduce the harmful impact of illegal immigration. We were founded in 1979. We have about 12,300 members in Maryland. I'm testifying in support of this bill, and I want to thank Delegate Shalega for introducing it. It ensures that the well-being and safety of citizens and legal immigrants in their own communities by handing over dangerous criminal aliens to the Department of Homeland Security's ICE for removal instead of releasing them back into the communities. We have seen communities that shield criminal aliens from removal experience more crimes. For example, in Orange County, California, after the sanctuary bill was passed, the Orange County Sheriff's Office was forced to release more than 1,500 aliens with ICE detainers back onto Orange County streets. More than 400 of these aliens were rearrested on serious charges, including rape, assault with deadly weapons, child sex offenders, domestic violence, and driving under the influence. Every one of these crimes was preventable because none of these criminals should have still been in the United States. Moreover, HB 756 ensures that criminal aliens will not be shielded from removal needlessly to harm innocent lives. There are roughly 3 million criminal aliens living in this country, and nearly 1 million of them already have final orders of removal. Further, it's not a secret that Americans face serious threats from terrorist organizations, with FBI's pursuing hundreds of activist, extremist investigations. The federal agents are stretched thin and depend heavily on intelligence provided by state and local law enforcement. By cooperating with federal immigration officials, this bill will create an environment where terrorists and other criminal aliens will not go undetected or unundetected.
You're about at time.
I thank you for this, and I urge a favorable report.
Thank you. We'll now take Margaret Montori for 2 minutes.
I have participated in city, county, and state forums in which Democrat representatives have defined federal immigration detainers as requests for detention. Detainers are, in fact, federal red flags signaling local jurisdictions that persons involved in criminal, often violent criminal activity, terrorism, and espionage are present in their judicial systems. Delegate Zalega's bill is an effort to stem the coddling of illegal alien criminals by the state of Maryland. This bill requires state and local law enforcement to relinquish custody of the undocumented criminal upon request by Homeland Security. This bill addresses those who have already been convicted of criminal activity. They have already been convicted and may be in custody. When Maryland law enforcement is legislatively prohibited from honoring federal detainers, the Maryland representative's duty to protect Maryland citizens is abandoned. Lack of cooperation with federal agencies defies logic. A Center for Immigration Studies 2019 statistic places Maryland second in MS-13 activity. Because of the Democratic policy of open borders, it is conceivable that Maryland may now surpass California and lead in MS-13 activity. As reported by Laura Ingram in her expose on the distribution of illegal aliens from the border to communities throughout the country, Maryland is a top destination. Because of the fact that none of the border crossers are vetted or detained, it follows that criminal activity will only increase in Maryland. Unless we cooperate with Homeland Security, Maryland will not be ready to handle this new influx of illegal alien criminal activity. Thank you.
All right, and thank you. Next, we'll hear from Amy Wakehoff for 2 minutes.
Thank you for this opportunity to testify. My name is Amy Wyckoff, and I've lived in Montgomery County for over 34 years. I've been fighting against sanctuary laws since 2017. Occasionally, someone in the General Assembly puts forward a bill to combat these terrible laws. HB 756, sponsored by Delegate Kathy Shalega, is one of these bills. The bill is simple. If a state or local correctional facility has custody of an illegal alien who has committed a crime such as terrorism, active participation in a criminal street gang, or has been convicted of an aggravated felony, that individual would be transferred to the Department of Homeland Security. Why would any sensible legislature object to such a bill? My only answer to that question is that Maryland legislators want to actively subvert the laws of this nation, or that Maryland legislatures care little about the safety of American citizens and legal immigrants residing in the state, or that they want Maryland laws to serve as a magnet for ever more illegal aliens to make the state their home. Why would a legislator possibly favor this course of action? My only answer to that question is that certain legislators want to be able to rely on these illegal alien immigrants to someday vote for them and thus solidify one-party rule. Kathy Shalega, on the other hand, makes fidelity to U.S. laws and the safety of her constituents the priority that they should be. I therefore wholeheartedly request that your committee give HB 756 a favorable report. Thank you.
All right, we got one hand up for Delegate McComas. If you want to direct a question at someone, go ahead.
This is for Delegate Shalega. Were you aware that the Mexican gangs, have you seen that, where they're eating human hearts as an initiation rite? They're taking over El Chapo's territory. It was on.
I have not, but I've certainly seen gang initiation activity in Baltimore City, and I'm from the Baltimore Harford County area, and we know it's a real problem. Whatever type of gang initiation or activities that are going on, they're very scary and certainly a public safety risk.
And let me ask you this. So do you feel that your bill is going to help stifle this kind of activity?
I certainly hope so.
How do you think it will? In other words,
it's clearly
the community.
Yeah, it's well known that MS-13 and this Fulton Locos gang, other gangs are predominantly made up of illegal immigrants or undocumented immigrants, whichever term people prefer. And when they're committing violent acts in our community, and then ICE wants to deport them, and instead of turning these violent criminals over to ICE and allowing them to deport them, the local law enforcement is letting them back in the very community that they're terrorizing. So I'm certain if we require this, it will get, certainly not solve the problem, but get some of these gangs, violent gang members off the streets and out of our country. Thank you, Delegate McComas.
All right, Delegate Lopez.
Delegate Lopez, your little one is adorable.
Thank you. Gracias. Buenos días a todos.
Sí. Hablo español también un poco.
Gracias. My question is for Ms. Wyckoff. I think I'm pronouncing that correctly. You made some claims about our support as Democratic legislators being incumbent upon this idea that we're going to try to legalize people and increase voter turnout for ourselves. I'm wondering if you have any information about voter turnout around immigrant communities.
No, I don't. It's just a question for you. Why? What is wrong with this bill? That's the question.
With all due respect, Ms. Wyckoff, if you need to familiarize yourself with the rules of this committee, you as someone who's providing testimony are not in a position to ask me questions.
Okay, fine.
So,
well, sorry, I don't have the answer to your question.
All right. I think that about wraps. Yeah. Oh, and Mr. Chair is back. Excellent timing, Mr. Chair. We are wrapping testimony on House Bill 756, and it'll be 8:10 next. Welcome back.
All right, thank you very much. That does conclude the testimony on House Bill 756. And we will go on now to House Bill 810, Delegate Kipke. There are people testifying on both sides. This is a new bill, 3 and 2. 3 minutes for the sponsor, 2 minutes for everybody else. We'll hear from Delegate Kipke, then Rebecca Snyder and Nicholas DiTello. We'll then hear from the opponents. All right, so Delegate Kipke for 3 minutes. There you are. Good. Let's hear from you.
Thank you, Mr. Chairman. Great to be with you all today. I think we did slip one past you, as this bill is a reintroduction. Delegate Shalega and I have put this bill in 3 years in a row. I do think it's important, though, and here I am before you, hopeful that we can make some progress on this again this year. What this bill seeks to resolve is the fact that in Maryland, we are one of a few states that has a prohibition on journalists being allowed in the courtroom, specifically during a sentencing phase of a criminal case. This bill is not a O.J. Simpson sensationalism opportunity where you videotape and journalize an entire case. This bill would just seek to legalize a journalist's camera to be in a courtroom during just the sentencing phase of a case. The bill goes to great lengths to protect things that should be protected. For example, the bill allows a judge to deny a request by a media organization for a whole number of reasons, most importantly, at the request of the victim, to protect witnesses or jurors, and frankly, for any other reason that the judge believes is appropriate. Limiting the coverage can only be done, though, obviously, within a reason that protects the public good. So, Thomas Jefferson once said, information is the currency of democracy. I believe that this is an opportunity for the public to see some transparency as to what's happening in our courtrooms, especially as it relates to crime. And I hope that you'll take this into consideration when you adjudicate whether or not to bring this up for a vote this year. So members, I thank you for your time and encourage you to consider this favorably.
All right, we don't yet see Rebecca Snyder here, so we'll go to Nicholas Titello, please, for 2 minutes. We'll let it slide. Mr. Titello?
Can you see me?
We can hear you.
Okay, well.
Go ahead and we'll let you go for 2 minutes, please.
Yep. Well, I just wanted to keep it short and sweet. Thanks again for your time. I just wanted to state that just eyeballing this bill, that looking through it, it does appear to add to freedom of the press, which I strongly believe in. I think we don't get enough coverage of what's going on in the courtrooms around the country, and having small changes here and there to put the media in the courtrooms will bring more freedoms and liberties to the people. And yeah, thank you for your time.
All right. Thank you very much. Still looking for Rebecca Snyder. And we don't have Rebecca Snyder. So we're just going to go ahead and see if there are panels or if there are questions for this initial panel of the sponsor and the witnesses. If Ms. Snyder should happen to come in, then that'd be fine, but it doesn't look like we have any questions. We'll give her a chance if she if we have to after the oh wait, we have a question. There you go. Delegate Bartlett has a question. Go ahead.
Thank you, Mr. Chair. And Delegate Kipke, I just have a quick question. What is the benefit of having, other than transparency and the media news reporting, why on the sentencing are cameras needed? I'm not quite sure on that one itself. Are the cameras allowed at any other time?
In some places around the country, they are. Maryland has one of the most restrictive laws as it relates to this. My goal truly is, there is a distrust among many people in the public of government today at all levels of government. And this includes the judiciary. I mean, there's other bills being introduced that go much further as it relates to judicial transparency. I think this is one small but important step when you see some of these really salacious, terrible things that happen to Marylanders. And, you know, I believe generally judges are doing a good job and the system is doing a good job, the judicial system. But I don't think many people in the public know that and believe that. And so certainly as it relates to, very difficult, very sad crimes, I think the public would appreciate being able to see how it's being treated in our courtrooms, and know, building a greater sense that justice does take place.
Would you, Mr. Chair, can I ask one other quick question? Would you, Delegate Kipke, support the cameras in the courtroom throughout the entire trial?
I haven't thought that through. I'm very comfortable with this piece of it, which is why I have that before you today.
Okay, thank you. Good answer.
All right. We'll go to Delegate Carden next. Delegate Carden.
Thank you, Mr. Chairman. Thank you, Delegate Kipke, for bringing this legislation to us. And we've heard this this testimony before, and I'll ask a similar question to what I asked last year, I believe, and that is, are we not getting, is there some added value to having the cameras in versus just reporting it? Are people not reading and they need to see it? Is that one of the issues, number one? Number two is, in some of it, I'll let you comment on the testimony unfavorable by the judiciary, which basically said they brought together back about 5 years ago, they brought together, actually it was about 10 years ago, I apologize, a group of people, prosecutors, defense bar, victims, rights advocates, and the judiciary together to talk about the idea of cameras in the courtroom. And one of the conclusions they came up with together as a group was that these intimate details of humiliation and suffering have no educational value, and televising them can serve only to satisfy a prurient interest in the misfortune of others for the commercial benefit of broadcast media organizations. So it seems as if, going back to what Delegate Bartlett had asked, it seems as if there might be other parts of the process that might be even a little bit less more approved by the judiciary. But in this case, I think that the sentencing aspect is probably the one that is the most concerning to them. So maybe you can comment on that.
I would disagree with your assertion, and instead I will say this. Well, first of all, the one issue that you raised, that as it relates to the content and the victims, a victim can just say no under this bill. So I understand that perhaps some people in the judiciary don't want to have to deal with this, but we have a very real and salient problem in our country where many Americans, including Marylanders, do not trust this legislature, do not trust the government, do not trust the judiciary system, and they feel that different aspects of government is failing them. And it's my opinion that we need more transparency, just like we've done here in the General Assembly, where we're live streaming. There were people who fought back against that for many years, and it's finally here and it's live. And I think these are all things that we can do to improve transparency. People believe that our courts are too lenient on violent criminals, and I think it would be a service to provide an opportunity for these types of cases, which are the ones that are going to get the most attention, to be seen and witnessed by the public. The second part of your question is as to whether or not video is necessary, and perhaps it should just be written reports. Of course, we have that today, and I think a picture tells 1,000 words, and it certainly would provide a much more poignant opportunity for people to witness with their eyes what is going on in our courtroom.
All right. just one more time here. We've got Rebecca Snyder now here, and we're going to let her testify for 2 minutes, and then one more chance for questions, and then we're going to move on. Rebecca Snyder now for 2 minutes, please.
Thank you, committee. My name is Rebecca Snyder. I'm the executive director of the Maryland Delaware DC Press Association, and we do testify in support of House Bill 810. This is a bill you've heard in the past, and we supported it last year and we support it again. We do believe that the public needs to be able to see more of the court system. It certainly is, we need to have more openness to the process and allow the public to better understand what's happening. This legislation is important to our members specifically because they're able to cover proceedings more easily and thoroughly without the burdens of proximity. There's been a significant amount of research done on this. In my written testimony, I cite a 2016 report by the Federal Judicial Center that examined video in courtrooms and found that there was no a significant effect on the proceedings. It wasn't that the world ended. It wasn't that it was a sideshow. And this is a very specific bill that talks only about criminal sentencing hearings. So we do believe that it is a necessary change. It would help journalists report on cases more easily, and it allows the public to become more engaged with the court system. We urge a favorable report. Thank you.
All right. Are there questions for this panel generally? Any further questions? All right, seeing none, we thank you all very much for testifying, and now we'll hear from opponents to the bill. We'll hear from John Cox, Judge Braverman, Stephen Kroll, and Judge Morrissey. They'll each get 2 minutes to testify, and then there will be time for questions after that. And so with that, we'll look up and see, is John Cox here? John Cox? There he is. You're muted, John Cox. All right.
Thank you, Thank you, Mr. Chair, and I apologize for the little glitch just getting in here. I'm speaking on behalf of the Maryland State Attorneys Association. We are opposed to this legislation. We have genuine concerns for the effect that it's going to have on our ability to continue to successfully prosecute cases. I can tell you that I've been doing this for a long time. I guess Mr. Kroll always says his number of years. I'm not going to say mine. But I can also tell you in my experience, the anxiety and the lack of cooperation of victims and witnesses has been increasing exponentially over all the years I've been doing this. And one example is, people then say to me, well, who's going to be in the courtroom to see me come in here? And they want to see if they can keep people out, gang cases, other cases of that nature. And then what you end up hearing is that what I have to tell them is I can't keep people out of the courtroom. But now we're going to say, let's open it up to the world. And then the victims and the witnesses are going to see circumstances in which other cases have been broadcast, even if it's just the sentencings, and they're going to know that this is going to be somewhere out there. It's going to increase the anxiety of those people. It's going to increase the times when they're not going to be willing to come in at all. It will have an adverse effect on our ability to continue to successfully prosecute cases. And then we have the exposure of others to the circumstances. And we urge an unfavorable report.
All right, Judge Braverman, please. Judge Braverman for 2 minutes.
Got it. Thank you, Mr. Chair, Vice Chair Moen, members of the committee. I am Senior Judge Nathan Braverman. It's my privilege to appear before you on behalf of Chief Judge Joseph Getty and the Maryland Judiciary in opposition to House Bill 810. Let's just be clear. There was a couple of statements made that our courtrooms are closed to journalists. That's not at all true. They're closed to cameras. Print journalists, television journalists can come in. They just can't bring their cameras with them. Chief Judge Getty is the third chief judge in the Maryland Court of Appeals that sent me here to testify in opposition to a bill that would allow commercial television broadcasting from our criminal courts. Each of these chiefs understands two things that all participants in the process also understand, as we just heard from Mr. Cox. Broadcast coverage of criminal proceedings discourages victims and witnesses from cooperating with law enforcement, plain and simple. This is not the General Assembly. Everybody that's here today, broadcast, live stream, we choose to be here. Criminal victims, witnesses in criminal cases do not. Second, television coverage distorts rather than accurately reports what happens in our courts, and often does so at the expense of minorities. Citations to the research that bears this out is in our written testimony. I urge you all to take a close look at it before taking action on this bill. But if you are inclined to disagree with the Maryland Crime Victims Resource Center, the Maryland States Attorneys Association, the Office of the Public Defender, and the Judiciary, and want to open up our courtrooms to media exploitation, then we urge you to take a close look at this bill itself, which is simply unworkable as written. I have time only to cite a few of its practical defects. It requires only 24 hours notice. It imposes a disruptive and expensive burden on everyone in the process. It requires the clerks, the court, and the attorneys to drop everything, complete 8 separate tasks. All of them are listed in our written testimony. Identify the parties, get notice to them, which is still usually done by mail, particularly in our largest jurisdictions. Provide security for setting up the equipment, filing and hearing objections, and then ruling on objections. This can't be done in 24 hours. It just can't be done, even if everybody in the process cancels everything else they have scheduled for the day. The bill purports to give victims rights, and some say in the matter, but doesn't require anybody to notify the victim that when you come to court 24 hours from now, you're going to be on TV. It doesn't exist in the bill. It also purports to protect minors and witnesses, but those protections do not apply to the privacy rights of victims. It includes an exception for sex crimes, but not domestic violence crimes, not child abuse, not human trafficking offenses. Respectfully,
Your Honor, I'm sorry, we'll have to ask you to begin to wrap up, please.
thank you. I am respectfully, the bill needs work before it can be expected to work. If you want to see how it might work, look at what we do in civil cases when television coverage is requested, and look at Maryland Rule 16-601 that governs use of cameras for civil proceedings, which don't include victims of crimes, and in our appellate courts as well. Thank you.
Thank you. Stephen Kroll for 2 minutes, please. He's here.
Mr. Chairman, members of the committee, good afternoon. I'm Stephen Kroll, the Executive Director of the Maryland States Attorneys Association and the State's Attorney Coordinator. And yes, I've been doing prosecution work since 1984. I want to agree with Mr. Cox. I want to agree with Judge Braverman. And I know I'm going to agree with Judge Morrissey in the future. So with those 3 things said, would ask for an unfavorable report as to House Bill 810. Thank you very much.
All right, let's hear from Judge Morrissey then, please, for 2 minutes.
Good afternoon, Chairman Clippinger, Vice Chair Moon, members of the committee. Shockingly, I'm in agreement with the other 3, and I have no further comments. I'm just here to answer any questions that the committee may have. Thank you, Chair.
All right. Then we'll go to questions. We'll go to Delegate Erican, then Delegate McComas.
Thank you, Mr. Chair, and thanks to everybody who came today to testify. So I guess I'm hearing your concerns, and it's the concerns that we've heard, a couple years now. But the bill does allow for the judge to decide whether or not it's going to be streamed, correct?
I don't know if anybody wants to jump in. Yes, it does.
And if I can jump in, under limited circumstances and requiring specific findings that it's going to do certain things, but it's not an absolute discretion. And it doesn't protect some of the people in the process, as I mentioned.
Yeah, and I think, maybe some of the concerns that those of us who think this is a good idea are having is that victims are kind of losing their voice right now. And I've been particularly disturbed by it since I've been down here, and allowing the public to see people who are willing to be seen really humanizes victims again in a way that we've sort of lost because we've been desensitized to it in our communities because it's just so common. So would you say that in the states where this policy is already in place, that somehow it's had a negative impact on victims in any way?
If I can jump in, the polling that's been done, I know New York experimented with cameras in its criminal courts a number of years ago, and then the legislature stopped it because the data was showing that people were unwilling to come forward. 60% of women said they were less likely to testify in court if television was a possibility. More than 50% of all people. I think that research is cited in our written testimony, as Mr. Cox pointed out on behalf of him. He's a career prosecutor, Maryland States Attorneys Association. They are the voice of victims, and they are telling you, in their opinion, that this is not a good idea. There's the Fox News report from a couple of years ago said Baltimore City's dropped 300 cases, almost all crimes of violence, because witnesses will not cooperate. And one of the reasons they want to cooperate is they don't want to be seen. And that's just live and in court. As Mr. Cox said, people want to know, how can we protect them? Well, we can't protect them if we put them on the stand with an opportunity to go video viral instantly.
What about like SCOTUS, where it was just audio?
There are similar problems. It's certainly less so. Obviously, if their pictures are not there, that's a sort of hard distinction, I think, for victims to make, and perhaps our prosecutors can address whether that would be better. This bill, as written, still does present some of the technical challenges that I've indicated. But obviously, audio is not perhaps as intrusive on victims. And remember, we're talking sentencing hearings, and still, right, audio or video, we're still talking about the salacious was the word that Delegate Kipke used. Sentencing hearings are emotional affairs, and they talk about details of victim suffering or families. When it's a homicide, for example, there's no victim to testify. The impact on the families, also, frankly, and the impact on defendants.
Yeah, I just worry
well.
that if we sanitize what's really happening in our communities too much, we're really doing a disservice to the victims and the entire community. And that's my main worry. And I think that's probably part of Delegate Kipke's. But thank you so much for the answers.
Delegate McComas.
Thank you, Mr. Chair. Just briefly, what have we ever tried just a pilot program, and just to see how it went, and maybe scrub it so we don't deal with the more salacious cases, but we deal with maybe theft, DWIs, drug dealing, something where we don't have necessarily a victim issue, and just see how it went, and just, pick a jurisdiction and where the judges are kind of amenable to it, and then just try it on some cases that aren't so sensational and see how it works. I mean, and see, maybe design something with the university or some of the folks that do a lot of criminal justice work, and just see if it helps, because obviously if it doesn't help the community, doesn't kind of tamp down some of the crime, then maybe it's not such a good idea. But I think to just say no, because we have heard this bill time in, time out, and it just seems like, why don't we just try a pilot program and see how it goes? I mean, it may go well, it may not, but I think we need to try. If other states can do it, why can't Maryland do it? So does anybody have a response to that?
If I can, Delegate McComas, just quickly, this is a broadcast media bill. This is not a live streaming bill. I kind of doubt that Channel 11 or Channel 45 is going to want to show up for a shoplifting case or a DUI. This is setting up individually on cases, as opposed to, I'm gathering that your question may be more directed towards a live stream.
Well, I just think maybe it possibly has some good benefit, but I also understand the concern for the victims and the salaciousness of the charge, and also retribution if it's a gang, a gang sentencing. So anyway, thank you, gentlemen.
Delegate Cardin, then Cox. Delegate Cardin.
Thank you, Mr. Chairman. To Judge Morrissey and Judge Braverman, Judge Morrissey, you served on the bench in Prince George's County for most of your career, correct?
That's correct.
And Judge Braverman, you were in Baltimore City for most of your career, right?
Yes, and since then, 28 of the 33 district courts since my retirement.
So you're all over the state now as a retired judge, right? And in your experience, have you had reporters come into your courtrooms and report on cases?
I don't know if I should jump over my chief, but since I have more recent experience, yes, all the time. And I can tell you, as you know, and you probably know this as legislators, they're not there to make judges look good, but that's nearly not our concern. Yes, on many cases, and frankly, I had the honor of sentencing Michael Phelps So I presided over that media circus, and that did not involve cameras. So yes, even in the district court, reporters there all the time, and obviously reporters, print and broadcast, are in the circuit courts on the more serious offenses all the time.
And there are times when you would prefer not to have them, but you have to permit them into your courtroom. Is there any reason that you can deny them access?
There are limited circumstances under which a judge can close a hearing, but they are very, very rare. And I would say, frankly, I don't mind the media personally in the courtroom. Everything I say and do is recorded. I've learned in now 21 years on the bench that recording is my friend. But again, like members of the General Assembly, I choose to be there.
Delegate Card and I also have had multiple experiences with reporters in the courtroom, and we also work with reporters and create on the more high profile cases. The administrative office of the courts gets involved and helps coordinate all the press requests and access to the courts, and it's pretty routine.
Great. So it seems to me that the system's working pretty well. Thank you.
I would just add one thing, and that is the court's website always advertises cases and notifies the media. So the media gets a good idea of what's going on just from the Maryland Judiciary Court site.
Delegate Cox.
Thank you, Mr. Chair, and thank you, panelists. Real quickly, how would this bill differ from the current practice with Zoom? For instance, right now, proceedings are Zoomed to the public. They're Zoomed for witnesses. They're Zoomed for argument. They're Zoomed for cross-examination. Everyone can watch them. And the judge can allow for a closed camera on a particular witness. I'm trying to figure out what the difference would be in terms of the concern.
Well, Delegate Cox, I'd be happy to answer that. I don't think you're correct in stating that we're Zooming everything all over the place. We do allow remote proceedings in certain case types. As the pandemic has ebbed and flowed, we go more to remote when we absolutely need to and less at times. Chief Judge Getty about 3 months ago created a subcommittee of both the Major Projects Committee, which I co-chair with the State Court Administrator, Ms. Harris, as well as the Technology Committee, which I'm also on. So both of those committees put work group members on a subcommittee who's designed to make recommendations to the Judicial Council, and we're in the process of doing that. We hope to have a product to the Judicial Council come March that would indicate as part of this subcommittee, we've done surveys both internally and externally to the judiciary. We've also had listening sessions, both internal and external to the judiciary on multiple occasions to try to get the maximum input as to what's working, what's worked during the pandemic, what's currently working right now, and what's not working so much. And we'll make recommendations to the Judicial Council, hopefully in March, kind of on the lines of recommendations for what should keep going forward and what shouldn't keep going forward. And there's some things that it works great on. Scheduling conferences by remote are great. They save everyone a lot of time. Trying to conduct a criminal trial remotely is next to impossible. And it also implicates due process and confrontation clause issues. So we're trying to work the universe of those issues and come up with a plan as to how we're going to proceed forward. Hopefully with this pandemic ebbing right now, I believe that's the right word, receding, we're going to be in a position to open back up more fully and really get back to business.
Well, thank you. And I would agree with you about the frustrations of trying to do cross-examinations and the frustrations of cameras not working and testimony not being properly worked through. And so I agree with that. I'm just talking about the fact that for 2 years, we've been doing similar things, and it seems like it would be a good time as ever to examine how to do that in an appropriate way that would protect everyone. And I noticed, here's my second and final part of the question. Page 4 of the bill gives the judge not only the option, as was discussed earlier, but actually mandates that the judge shall make a finding of fact after notifying all the parties to limit in any way necessary to limit the broadcast. So It seems to me that all of the concerns that were raised are addressed in that amendment. And maybe there would be one additional amendment that could be required, and that is to notify the witnesses to give them standing to file a motion or something, but it actually includes witnesses on line 12. So is there another way is there an additional amendment that would address your concerns? Because it seems to me the concerns are all addressed on page 4.
Well, yeah, if I could, there are limited circumstances on the current draft when a judge can intervene. But the problem is it doesn't give notice, for example, to the victim who might be able to object, and the victim may not know when they arrive at court, as I said. Maryland Rule 16601, which was rules adopted in civil cases, and really when Maryland was toying with the idea of doing criminal cases back in 1980, allowing broadcast coverage, gives I would look there if you're looking to
Could I just jump in?
Bill.
Could I just jump in though? Line 16 says, on request of the victim, the judge shall deny the immediate coverage.
But the bill provides no notice to the victim.
So it's a notice. Okay. So that would
notice to the victim.
So add the notice and then you'd be okay with it?
Well, that would certainly help, and if you're sentencing a capital case where there's no victim, or if you're sentencing a case that involved a child victim and the family wants to give testimony, that does not give the parent of a child who was abused, for example, the opportunity of explaining to the sentencing judge the impact it had on the family, on the child, without going on television. So this bill does purport to give the judge some authority, and it does give the judge some authority to limit, but it's very narrow. And again, I would refer you to the current rules in effect for civil cases that give everybody in the process a little bit more leeway, frankly, including the media. That's where I would look first.
Thank you, gentlemen.
All right, as the sun comes straight through to my new seating location here in the Judiciary Committee. Sorry about that. That appears to conclude the testimony to House Bill 810. We thank you all very much for your testimony today, and we will be moving forward here. Thank you all very much. Going now to House Bill 785, and this is Delegate Robin Lewis. There are 5 people, I think, testifying in favor. 7 people testifying in favor. So we're just going to hear from all of them. So that'll be Delegate Lewis for 3 minutes, Sophia Baraloni, Obi Shinamir, Chief Judge Morrissey, Marcia Nettis, Nicole, Judge Pastori, sorry, and Veronica Bido. We're going to hear from everybody. Delegate Lewis will get 3 minutes. Everybody else will get 2 minutes, and we'll go from there. All right. So Delegate Lewis, please, for 3 minutes.
Thank you, Mr. Chair. Hopefully my audio is on.
Obi, here.
Yes, yes, sir. Okay.
Marcia,
Delegate
Nicole, Judge Pastori, sorry, and Veronica. Delegate Lewis, you're going to need to turn off the live stream. Delegate Lewis will get 3 minutes. Everybody else will. Judge Pastori will also need to turn off the live stream. And then you should be able to hear us through the Zoom. How about now, Delegate Lewis?
Okay, I'm in the Zoom, Mr.
You are.
Chair.
Great. Go ahead.
Great.
Testify for 3 minutes.
Thank you so much. Delegate Robin Lewis, on behalf of House Bill 785, the bill entitled Baltimore City District Court Job Courts Pilot Program. Chairman Clippinger, esteemed members of the House Judiciary Committee, House Bill 785 is a local Baltimore bill. It will help make our city healthier and safer. This bill creates a pilot diversion program in the Baltimore City District Court that will train and guarantee placement for eligible defendants into gainful employment. Eligible defendants includes low-level, non-violent defendants. This quote jobs court unquote program is modeled on other rehabilitative diversion programs that have demonstrably reduced recidivism, increased public safety, and given folks the tools they need to get their lives on track. This program is modeled on the drug court, mental health court, both of which I'm sure members of Judiciary are familiar with. These diversion programs offer targeted services and supervision as alternatives to incarceration. The principle of diversion, as you all know well, is pretty straightforward. A person charged with a low-level nonviolent crime fulfills certain requirements like completing mental health treatment, paying restitution, performing community service instead of being incarcerated. Given the close association between unemployment and the commission of low-level nonviolent crimes, it makes intuitive sense that a defendant with a decent job is less likely to reoffend. Unfortunately, many of the folks lack the skills they need to get and keep a decent job without help. Like they can't do it on their own. Having a good job is a kind of crime prevention. And as a public health professional, bravely standing up in judiciary, I would even refer to employment as a kind of vaccine against crime. That's why job training and placement should be prioritized as a common sense preventive measure for reducing recidivism. Job training linked with a guaranteed promise of job placement as prescribed under this bill can prevent many of the harms associated with incarceration. This bill does have a fiscal note. It mandates a $500,000 appropriation in the annual state budget starting in fiscal 24. The funds will be administered by the Baltimore Workforce Development Board, which is part of the structure of the mayor's office. And that board will then distribute the funds to local nonprofits and other entities that implement the diversion. Important before I close to make note of this bill's history. It has its origins in a recidivism effort started by the Honorable Nicole Pastore-Klein, who is also testifying today. Judge Klein is a Baltimore City Court judge. Am I out of time?
Yeah, you're out of time, delegate.
Okay, well, the Honorable Judge Klein will tell you more about the history of the program. I will end by urging a favorable report for this bill. Thank you.
Thank you very much. We'll go now to Sophia Baraloni for 2 minutes, please.
Thank you. Good afternoon, Mr. Chairman, Vice Chair, and Delegate Lewis, and members of the committee. My name is Sophia Baraloni, and I'm an assistant public defender in Baltimore City. I've been a public defender since 2019, and throughout my time with the agency, I've been referring my clients to the District Court Reentry Program known as DCREP. And DCREP is a successful program offering job training and employment educational components for degrees as well as certificates. And with this bill, this program will pretty much be formalized. DCREP will just be expanded and it will be statewide. It's an awesome program. I've been referring many of my clients into DCREP, and they have chosen to do DCREP as a program, as a condition of probation, as a condition for pretrial release, or in the alternative to incarceration. And as a result, many of them have graduated from DCREP and secured great jobs, certificates, ultimately financial security for themselves and their families. Many of my clients complained about job scarcity in the city because they are ex-offenders. However, this program will enable ex-offenders with an opportunity to have immediate access to jobs and job security rather than limit them. And in sum, everyone, this bill is based on already a successful program, the DCREP program, the initiative that we've been doing in Baltimore City, which is amazing. And this bill will allow people to break the cycle of joblessness, poverty, and crime. The program will reduce recidivism rate because it will also save Maryland taxpayers. As we know, it costs over $40,000 to incarcerate someone in the state of Maryland. And this program has kept a lot of folks out of jail. And so I would ask that we would have a favorable report for this bill. Thank you.
All right, thank you very much. Obi Chinamir.
Thank you, and good evening, Mr. Chairman, Vice Chair, and committee members. My name is Obi Chinamir on behalf of Rifkin Wiener Livingston, representing America Works of Maryland Incorporated, urging you today to have a favorable report on House Bill 785. And obviously, I appreciate the support of our sponsor, Delegate Robin Lewis. The Job Courts program is an innovative program that helps people who have come in contact with the criminal justice system have a better outcome. The legislation reduces the burden on our criminal justice system. It puts offenders on a path to success, helps our local businesses, and makes our community safer. It provides a way to keep people out of jail and on the right path towards opportunity. There's a very big connection between the economic issues that people face and a lot of the criminal situations that we see, specifically when it comes to lower level offenses. And by partnering with the judicial system and participating organizations that focus on preparing ex-offenders for the workforce, this bill helps us address the backlog in our court system, help people find jobs, and also provide employers with the capacity to find employees. There's more that I could say, but I know that there are people here who are ready to testify. I want to close by saying that, at the end of the day, our biggest concern is making sure that people who want to find work can find work. And this is even more true when you see what's happened over the COVID-19 pandemic, where we've seen a lot of people who do not have that access and that ability. So with that, I urge the committee to deliver a favorable report on House Bill 785.
Chief Judge Morrissey, please, for 2 minutes.
Good afternoon again, Chairman Clippinger, Vice Chair Moon, members of the committee. For the record, my name is John Morrissey, and I'm Chief Judge of the District Court of Maryland. I will defer to Judge Pastore about the more details of DCREP, but I can tell you that I'm very proud of the program that she put together. It's part of a larger and continuing recognition by the judiciary of the need to take a holistic approach to individuals that come before us. And much the way that our specialty courts, our drug courts, mental health courts, and veterans courts were created to better serve the individuals that come before this, the DCREP program matches services such as housing, employment, opportunities, and extended training programs with those individuals that may just need a little help to start over. It's also a recognition that collectively we cannot expect someone to change their path without addressing the underlying issues and helping them get back onto their feet. By addressing needs that are fundamental to everyone, the program has already demonstrated its value. Some of the graduates of this program have never held a job before in their lives. In fact, at one graduation that I attended, and I'd invite everyone on this Zoom meeting to come when we are able to do live graduations again, he indicated that this was the first time he ever had a job where he was required to pay taxes. I kind of put my earphones on when I heard that, but it was significant, and he was very proud of that fact. Now these individuals have full-time jobs that can lead them to higher paying careers because the jobs that are involved are really good jobs. There's a palpable sense of pride and accomplishment that I see on each of the graduates' faces, and the graduations are one of the few times that it's truly heartwarming and wonderful to come to court. This bill would further advance the great work already being done. And in conclusion, I'd like to thank Judge Pastore for her leadership, Administrative Judge Weinstein, the DCREP staff, the public defenders, and the state's attorneys, and that whole team that put it all together. So thank you, Chair.
Go now to Marcia Nettis, please.
Thank you, committee members. It's an honor to testify on the behalf of our partnership with the Workforce Foundation and the Jobs Pilot Program. I am Marcia Nettis, Vice President and Regional Director for America Works of Maryland, Incorporated. America Works of Maryland is a subsidiary of the America Works network of companies founded in 1984 by Dr. Lee Bowes and Peter Cove, with the core value that work should be the foundation for upward mobility. In June of 2017, America Works and the Workforce Foundation partnered with Baltimore City District Court Judge Nicole Pastore on a bail diversion initiative. The goal was to refer individuals to our program to receive job training, but most important, to be able to receive employment supporting long-term employment. The program has, and also as an alternative to incarceration for cash bail. As of January 2022, we are proud to share we have placed 140 participants into full-time employment, but most importantly, 67% of those participants have retained employment for at least 180 days. We have full support by employers who are also willing to give individuals a second chance despite having open cases. And this is well before the labor shortage that we are experiencing right now. Employers are willing to give a person a second chance as long as they're willing to show that they are interested in that support. Not to mention the long-term impact this program will have on the state by cutting the cost of imprisonment. So I want to thank you for hearing my testimony. We urge the committee to please support House Bill 785.
All right, let's go down to Veronica Bido, please, for 2 minutes, and then we'll let Judge Pastori Klein wrap it up. Veronica Bido, please, for 2 minutes.
Thank you. Good afternoon. My name is Veronica Bido, and I am a fellow through the Workforce Foundation, working with America Works of Maryland. I assist in managing and supporting the bail diversion program put forth by the Workforce Foundation and its partnership with the Baltimore City District Court Project. Our bail diversion program plays a critical part in helping the participants on a path to stability and by providing resources and support. It's important to understand that our program does not absolve accountability. The program is unique as it utilizes employment and economic empowerment as an alternative to bail. Our program is more than keeping people out of detention. Our program, we're partners alongside the participants and helping them to realize their own potential and apply themselves to find purposeful employment. The Workforce Foundation's bail diversion program, in partnership with the District Court Reentry Project, has proven to be successful and impactful. And I see it every day with the clients that I work with. So I just wanted to take this opportunity to urge you to please be in favor of this bill. Thank you for your time and your consideration.
Thank you very much. And now we'll go to Judge Pastori Klein, please, for 2 minutes. But she has to unmute herself first.
There you go.
That's better.
Yes, thank you. I appreciate being here and having the opportunity to testify on a matter that's near and dear to my heart, the Baltimore City District Court Reentry Project. I'm here to sort of give the background of the organization, for lack of a better word, but basically it was something that was started after the unrest of April 2015, when people were coming into my courtroom, Baltimore City courtrooms every day, saying that they're leading a life of crime or resulting to this type of behavior of selling drugs on the streets or whatever it may be, because there are no opportunities for individuals to get jobs. And I'm not saying just individuals in general, but individuals with criminal records. And you have to remember, in Baltimore City, we have many with records that are lengthy, not just 3 and 4 convictions. We have some that have 10, 15, 20 convictions. This project, the Baltimore City District Court Reentry Project, started with myself and 2 interns working with the State's Attorney's Office, the Public Defender's Office, Department of Parole and Probation, and Pretrial Services to see if we could all come to a consensus as to work together to provide alternatives for incarceration, as well as to become a condition of probation and or what Ms. Nettis talked about, a part of pretrial supervision. So when someone appears in our courtroom, if the State's Attorney's Office is asking for 30 days or 60 days incarceration, the plea deal may be to go into the jobs entry program with 17 different nonprofits, things like Strive, America Works, Maryland New Directions, ROCA, all different agencies that provide forklift certification, port administration jobs, TWIC cards, to direct job placement in McCormick or Under Armour or Amazon factories. These individuals will be basically sentenced to work. However, they're backing up their time. So it is a condition of that probation, so that if they don't complete the program, then they will have to serve out their sentence. But it's also an incentive, because if they do complete the project and graduate is 90 days consecutive employment, full-time in the same position, then they may have the opportunity to get their probation fees waived or their sentence changed from supervised probation to unsupervised probation. We think it's really important not just to make this a condition, but to incentivize for people to want to work and get that economic empowerment.
Your
I think
Honor.
I heard the public defender earlier say that it costs over $40,000 to incarcerate someone. It's actually $43,893 as of 3 years ago. And I always say it costs nothing to give them a
Right.
job.
All
Sorry.
right. No, you're fine, but I have to stop you there.
Mhm.
We thank you very much. I suspect there might be a question from the committee if people have more information, and lo and behold, there is. So we'll take questions now. We'll go to Delegate Bartlett.
Thank you, Mr. Chair. I wanted to ask Your Honor if she had anything else she wanted to say about the bill.
So I will, let me try. I appreciate you. So I could talk all day long, but one thing I didn't get out that I did want to say is
Don't
that.
talk all day long. We're
I'm
only
not.
halfway through right now.
For the
Don't
4 to 5 years that we've been in place, we've had 7 graduation ceremonies and 165 graduates. The goal of the program is to reduce recidivism in Baltimore City, as well as have tax-paying citizens. And we've been able to accomplish that. So I have to say, prior to COVID, we've had some great numbers, some great statistics, and we have great wraparound services. You've heard, I think, Ms. Nettis talk a little bit, and Chief Morrissey, that we're able to get housing or drug treatment or mental health treatment before or prior to getting the jobs. Because if someone doesn't have something to wake up to every day, despite the fact that they just went through a halfway house or graduated from the mental health program, more likely than not, they're going to reuse. So it really does blend well with the other programs that we already have in place. We've worked with Baltimore Ravens. Every year they give us a speaker for this graduation. Under Armour provides gifts to the graduates. We make it about pomp and circumstance. A lot of our individuals have only had GEDs. They've never had a high school diploma. So we want to have people come through our courtroom and have a positive, uplifting experience after they already paid their dues. Remember, they are taking responsibility for the crime that has been committed, but this is now just another option for them to move on successfully after they've done that.
All right. Are there further questions for this panel?
Chair Clippinger, could you please tell Delegate Atterbury that we supported a bill this session?
She's, I don't know. She's very fragile. That might cause her great, anxiety. I don't know if I want to do that. Can't be responsible for that. But
Thank you, Mr.
I may pass that on. I may pass that on if it's not too shocking. All right. Now that we've done that, that appears to conclude the testimony for House Bill 785. Thank you all very much. And Delegate Lewis, my seatmate, managed to make it out of here in one piece. So that's just fine.
Thank you.
All right. Thank you, committee, for not terrifying Judge
Thank
or
you.
Delegate Lewis. All right, good. Thank you all very much. Thank you very much, Your Honors.
Thank you.
All right, we're going to hear now, I think. Look, everybody, we're on page 2 of the list. House Bill 655, and Delegate Boyce is here. Great. And what we'll do is we'll hear, I see. Okay, so we'll hear from a panel of people testifying in favor. Some of them are also testifying favorable with amendments, so that's probably not right. So let's just stick with this first panel for a minute. It's a new bill, 3 minutes for Delegate Boyce, 2 minutes for everybody else. We'll hear from Christopher Dews, Nicole Hanson-Mundell, Lucia Reese, Kim Haven, and Antoine Quarles. So Delegate Boyce, if you'd like to begin for 3 minutes, that would be fine.
Thank you, Mr. Chair, and thank you to the committee. I will be probably 2 minutes so that I can give most of my time to the panel to go into further detail. Chair, Vice Chair, and members of the House Judiciary Committee, for the record, I am Delegate Regina T. Boyce here with testimony for HB 655, Driving Without Required Security, Repeal of Incarceration Penalties. HB 655 repeals the incarceration penalty for driving uninsured in Maryland. The fine for driving uninsured remains at a cost not exceeding $1,000. The Insurance Information Institute stats in 2019 lists Maryland as the 16th state in the country for uninsured motorists. Maryland has 14.1% of motorists who are uninsured. Maryland requires some of the highest coverage rates in the country. The Maryland Insurance Administration allows insurance companies to use geographical area, sex, age, marital status, occupation, education, homeownership, and credit history to set insurance rates. The Maryland Consumer Rights Coalition states that most Maryland drivers with perfect records pay more than $500 a year for the required minimum liability insurance coverage. Maryland insurance premiums are the 6th highest in the nation, averaging over $1,000 a year. The ability to use personal, non-driving related factors of the insured to determine insurance rates are disproportionately higher for those who are low income, working class residents. These discriminatory factors for insurance rates paired with the state's incarceration laws for not having auto insurance is criminal. The policy is an example of a poverty trap, mechanisms, systems, and policies that keep poor people poor. It is for this reason that I urge a favorable report of HB 655, and we will hear from my panelists to go into more details. Thank you, Mr. Chair, Vice Chair, and committee.
Christopher Dews, please, for 2 minutes.
Fantastic. My name is Christopher Dews, and I'm the Senior Policy Advocate of the Job Opportunities Task Force, where our mission, as always, is to help lower-wage workers advance to higher-wage jobs. We are, of course, supporting in strong support of House Bill 655 as a means to ensure that we are not criminalizing poor communities of color for attempting to maintain employment. Maryland is a very regional economy. Census Bureau reported about 4 years ago that almost half of Marylanders drive to a different county for employment. When it comes to teleworking, only 45% of Marylanders can telework, but 55% are going to have to go in person. That being said, when you look at lower income communities, specifically regions like Baltimore City, known as Baltimore, 9% of the jobs in the Baltimore region can be reached within 1 hour, one way by public transit. In a nutshell, if you're going to make it in the state of Maryland, specifically in Baltimore City, you need a car and you need affordable auto insurance. But as a delegate mentioned, 1 in 8 Marylanders, 602,000 Marylanders drive uninsured because they can't afford it. Factors like credit history, like zip code, more than double the monthly cost primarily for lower income workers of color. JOTF, NCRC, Consumer Auto, Consumer Federation of America, we've worked for years to reduce the cost of auto insurance by eliminating those factors, putting us in favor, like Michigan, like California, but we've been blocked, just to be blunt, by the auto insurance lobby. And that's an issue for finance and economic matters. But the reason why it affects us here is because the cost of auto insurance has basically put hundreds of thousands of Marylanders out of compliance with the law. MAIF can't even cover the cost because it's also too expensive for lower income workers. So just a little bit of stats here. Since 2015, 47,000 people have been fined statewide as violations for driving uninsured. And in Baltimore City alone, 24 individuals have been incarcerated since 2017, simply because they could not afford the insurance. We're working to get more data on this, but in a nutshell, we believe that your poverty should not determine your mobility, especially when it comes to employment. And we do not want lower income individuals incarcerated because they can't afford to comply with the law. For those reasons, we urge a favorable report, and I'm open to any questions you may have on this bill.
Nicole Hanson-Mundell, please.
Good afternoon, Nicole Hanson-Mundell, Executive Director of Out for Justice. Excuse my background because in the Senate, we can testify in person, and over here we can't. So if we really aim to continue Maryland's progress in reducing incarceration numbers associated with costs to all Maryland citizens, we must look closely at the reasons we are locking people up: poverty and addiction. We must respond to these issues very differently. As Mr. Christopher Dews stated, people driving without adequate documentation or often experiencing a myriad of economic challenges and life barriers that are preventing them from having insurance. Maryland is a regional economy requiring affordable auto insurance to sustain employment. Yet 602,000 Marylanders, which is 14.1%, drive uninsured due to the cost of auto insurance, specifically in lower income communities of color. The Baltimore-Towson metropolitan area had the worst racial disparities in the nation, with average premiums for African American zip codes being almost double, or 94% higher than the average premiums in its predominantly white communities. This is primarily due to the use of zip codes and credit history and other non-driving factors being used setting these rates. And so when lower income workers can't afford it, they drive without it, risking $1,000 fine and up to 1 year in jail time, or both, for the first offense. This is the criminalization of poverty. And it's time, these laws that we're introducing or even asking to repeal, it's timely. Driving without required license. So we have to repeal these ways in which we keep funneling our people into the criminal legal system. So we urge your favorable support for HB 655. Thank you.
All right. Kim Haven, please, for 2 minutes.
Good afternoon again, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Kimberly Haven here on behalf of Forward Justice Maryland. I will not repeat the same stats that Mr. Dews and Ms. Hanson-Mundell said. What I want to talk about is the impact of people that are being released from prison, and they're returning to a series of zip codes. These are the zip codes that are primarily targeted by insurance companies for higher rates. And we know that somebody has to choose between getting insurance, getting a car, getting a job, being in compliance with parole and probation. From day one at parole and probation, you are, I want to say, extorted to get a job. In order for you to get a job, if it's not something that you're able to get on public transportation, or even if you started and you build up a bank of savings and you get a car, you can't afford the insurance because you live in one of these zip codes. It's where you live. Your credit history should not apply to how you get insurance. I just changed insurance companies. My zip code was used, but my credit rating wasn't. Why is it used in these neighborhoods? And yet you hear how much disparity there is in the premiums that are being paid. And now we're talking about criminalizing somebody who may be on paper, who is trying to do the right thing and get a job and meet all of his requirements, but he's driving without insurance. And don't get me wrong, I don't want people driving without insurance, but we have to work on reforming the rates and how the insurance industry allocates the rates. But right now, someone's driving and there's the fear, I'm going to go back to prison. We're criminalizing, as Chris and as Nicole said, we're criminalizing poverty. These policies are racist. They are at its core wrong. I am in support of this bill, and I appreciate the delegate for bringing it up. We need to remove the decarceration fine for driving without insurance. And don't worry, we're going to come back and work on that $1,000 fine because that's also unattainable for our people. And I thank the committee for giving me this time, and I'm here in support of this bill. And again, thank you, delegate, for bringing this to the forefront. And I'm open to any questions.
Antoine Quarles. Mr. Quarles? All right. Is Kiana Johnson on the line? Kiana Johnson was not in the waiting room. That appears to be the only other person testifying for the bill. We're just going to try and fold her in, but neither. Okay, so Mr. Quarles is here. And Anton Quarles. He's got to unmute. Still got to unmute. Antoine Quarles.
Mr. Chairman, he just texted me and said it won't unmute me. Not sure what that means.
No, the committee sent him a message to unmute himself, or to give him it just basically shows up as a button. Yeah, it won't change on our end either. All right, we'll try and get him back in. We'll take questions right now, and then we'll see if we can get him in the room. Are there questions for this panel? Delegate Bartlett.
I have a question for the bill sponsor. So given the testimony, especially the testimony from Ms. Haven, should we be looking at a $500 fine instead of a $1,000 fine?
Thank you, Delegate. I would leave that up to the subcommittee, and that's because I don't know, and maybe this is a question council can answer. Does that $1,000 already include the fees that the MBA would charge at $150 and then $7 a day per every day that you don't have auto insurance? And so I would leave that up to the subcommittee. I think to Ms. Haven's point, people need to have insurance to not only protect themselves and their families, but of course others in the time of an accident. And so we want to figure out how to make sure, of course, as you heard, that it is affordable. But I think for the purposes of this bill, we definitely want to start with just removing the incarceration. And if the subcommittee decides that they want to lower that $1,000, I think I would leave it up to them to do so.
Delegate Juanita Fisher.
Thanks, Mr. Chair. I was trying not to ask questions today, which is why I was going back and forth. Delegate Boyce, thank you so much for bringing this legislation forward. And I do support the heart and the sentiment to where you're trying to go. And I think a lot of this bill belongs in ECM and kind of insurance fraud in our communities and that part. But I will question, when someone is pulled over, there's a motor violation, correct? There is either speeding or reckless driving or something before an officer then knows you do not have insurance when he or she asks for your license and insurance, correct?
I would say that it would come up on the MBA records. I mean, the way I know it to work for MBA, when you don't, you are, flagged. And so I know the way it currently works is you can have your loss of a license plate and vehicle registration, of course, privileges, sure, the inability not to re-register if it's actually been that long. Payment of restoration fees are up to, of course, $25 for vehicles, an inability to register. So there are, I would say, penalties in place. And if I get pulled over without having insurance, if someone else wants to answer that, I'm sure I have to probably either get a warning and go home and told I can't drive my car, or I could be, I think to your point, I think where you're trying to go, Delegate Fisher, is that I could potentially be taken to jail per that. Is that what I'm hearing you say?
Well, I guess what I was trying to answer is most people that are charged that I know of, and maybe you've pulled the numbers and maybe Mr. Dews can answer this. Most people that are charged with driving out insurance, the predicated reason, the reason why you've been charged for driving out insurance is a actual moving violation.
I understood. Yes.
Right. And so something that I just bring to you as a question and in the committee, and we struggle with the economic issues of over policing and then the reality of a traffic infraction and people getting hurt is if you don't leave it to a must appear, if you don't have the incarceration time and people are just with a ticket or a citation and they never pay it and then their points go, they end up in a more economic actually downturn than going to court and working it out. And so my question is two parts is, are people getting charged for driving without insurance without the violation? Because I only know it of you would have a moving violation to then be charged. And then number two, how do you deal with the fact if you do repeal any sort of incarceration on this charge, and people in our community, again, a lot of these issues are not in judiciary. People are transient, people are this and are, have a lot of other issues, and they never go to court or they never fix it, and it keeps adding and hurting them economically. So how do you deal with those two parts? One, like I said, do you get charged with this with the predication of you had a moving violation? Someone pulled you over for violating speed or something. And number two, if you have no must appear, if you have no incarceration on the insurance, are you concerned that having it as a pending citation and keeps accruing money or other issues, points are accrued, will hurt the same community you're trying to help?
This is an excellent question, and it is a question that I've had with people just in the same sense of like utility bills, like how far do you let it go before you put someone in a financial strait? I do understand, and I'm hoping the subcommittee could help figure this out, that without the incarceration, there is no requirement to go to court. And so I am not sure about how to work that out, but I do understand that sometimes the deterrent is to be able to show up to court, and then things are usually settled out. So I would leave that up to the committee. I don't know about the being first pulled over because you don't have insurance, which I think, to your point, is that more than likely you will be pulled over for a moving violation, as in I ran a red light, I'm being pulled over. And then once the license is pulled, you can see that the person would otherwise, on top of running the red light, also doesn't have insurance. And so I would if Christopher wants to answer that question, let him answer that.
Thank you, Delegate. I really want to focus on the second part of that question. The thing is, and I want to be very clear, as was mentioned before, we don't want people driving uninsured. I want to be very clear about that. The issue is that we have people that cannot afford to be in compliance. Other legislation has been passed. I know Delegate, or now I guess Vice Chairman Moon passed legislation in 2017 that decarcerated driving on a license suspended for child support. That was, of course, huge news for us, and it was a really good bill. And remember, the reason why that had to happen was because individuals could not afford, they just couldn't afford their child support payments. Now, I only mention that to say, this is not, I understand that, there's just separate moving violations and things of that nature, but the issue is that if people could afford to comply, I firmly believe that they would comply. Unfortunately, they cannot afford it. For example, I think there was I don't think there was a study. I know there was a study in bank rate that was just released about, I want to say 2 months ago, that talked about the fact that if just for credit history alone, if you have poor credit, you're paying double in the state of Maryland, literally double, up from $15,000 to $3,000 in auto insurance. And when an individual cannot afford that, then forget about their actual driving record, their driving ability, or what they're getting pulled over for. It's just unaffordable. So they're not, I just want to be clear that this is decarceration, not because we, are trying to risk more individuals harming the community in that sense. This is more decarceration simply because people cannot afford to comply with with the current state law. So we would love, once again, if there was a way that, for example, the fine could be changed to just be some form of makeshift auto insurance itself. That would be absolutely fantastic, because if an individual can't afford auto insurance, the fact that they can't afford the fine is not going to help them, because the point is that they can't afford the auto insurance in the first place. I feel like that was a long answer to a very short question, but I hope that did something to move us in the right direction.
Okay, I'm sorry.
Mr. Chair, can I just quickly add, and these are the things that I'm hoping the subcommittee can help us work through.
We're going to try again with Antoine Quarles, please. Mr. Quarles. All right. He can't unmute. We're not sure what the problem is there. We will certainly note him as being in support of the legislation. And we apologize for whatever technical issues that he's having. Those are the people who are here to testify on the bill. We thank you all very much for your testimony. That concludes the testimony for House Bill 655 and Delegate Boyce.
Thank you so much.
Thank you. We'll go now to House Bill 481. Vice Chair, and several people to testify. Okay, so we'll hear from the Vice Chair, Christine Dufour, Rajani Gudla-Valetti, Laura Garcia. We'll hear from that panel first, and then we'll hear from other panels beyond that. So we'll go now to the Vice Chair for 2 minutes. It's a reintroduction of a bill from last year. Thank you very much.
Thank you, Mr. Chair. Colleagues, I'll be brief. House Bill 481. This is a third shot at this bill. We actually passed it 95-38 last year, so an overwhelming supermajority. It had a bipartisan vote here in the Judiciary Committee, but it faced a misguided veto by the governor. As you'll recall, this bill would reform paraphernalia crimes in Maryland. We have a real disconnect right now where syringes in particular come with a 4-year prison penalty in Maryland, whereas the heroin or drugs in the syringe only has a 1-year prison penalty. And so this high risk for those carrying syringes leads to what we've heard was police complaining about the risk of pricks from people hiding them when they're being searched, from people sharing dirty needles because they're now a scarce resource, and people dumping them in public places because they don't want to get caught with them and risk 4 years. The bill would have stripped those 4 years out. And it also would have generally reformed the paraphernalia laws in the state. There was some confusion about, oh my God, is this allowing paraphernalia distributors to get off the hook? Let me be very clear. The purpose of the bill was the paraphernalia distributors, the public health folks who are trying to engage in harm reduction strategies and get people to stop engaging in dangerous practices in the middle of an overdose epidemic and huge drug problems during the pandemic. That's why MedChi and a number of public health professionals passed the bill. So I would hope for your support once again, and maybe we can get people to think straight this time. Thank you, Mr. Chair.
All right, let's hear from Christine Dufour, please, for 1 minute, please.
Good afternoon, Chairman Clippinger, Vice Chairman Moon. Thank you, members of the committee. It's good to see a lot of familiar faces. I'm Christine Dufour. I'm a supervising attorney with the Office of the Public Defender. I do both district court work and major felony work. When I do my district court dockets, I see routinely police charge the 4-year penalty, yet as was just stated, the substance itself is a 1-year, and they use the 4-year as leverage. I think we overlooked it when we worked on the JRA in 2016, and I know my friend and your former colleague, President Judge Dumais, tried several times to get this remedied so that the syringe, or now the syringe in this bill, would be repealed completely, which I think is beneficial for all the types of exchange programs, et cetera, and the reasons that Delegate Vice Chairman Moon set forth. But I think getting the rest of the paraphernalia on parity with the actual substance just makes sense. And finally, I would say the provision which would reduce the subsequent paraphernalia offense that goes from a $500 fine for first offense to 2 years for a second. I actually had a client who had a trial on a possession of a syringe in his car. He was convicted and he was given 2 years in DOC because he was a subsequent offender. He got out, used again, and overdosed and died. I don't know that that sentence really helped in any way him, his daughter, or his community. He had a very, very bad addiction.
Ms. Dufour.
Finally, I think this is a good bill and I urge a favorable report.
Thank you very much. We'll go now to Rajani Gudla-Valetti, and then we are going to go to Laura Garcia. So Rajani Gudla-Valetti.
Hello. Hi, everyone. I am Rajani Gudla-Valetti, Director of Mobilization with Baltimore Harm Reduction Coalition. Our organization has been operating for over 10 years, primarily as a premier state-certified overdose response program and syringe service program. To echo Delegate Moon, criminalizing drug paraphernalia is a modern-day war on drugs strategy. We urge you to vote favorably on HB 481 with Delegate Moon's sponsor amendment to match the version of this bill that this committee passed last year. This amendment includes protections of sales and delivery, otherwise known as secondary distribution. Secondary distribution is primary health care, which my colleagues and other advocates will speak to during this hearing. Decriminalization of paraphernalia reduces risk of overdose for myriad health and justice reasons. Maryland is primed to join a cohort of 12 other states plus DC in which paraphernalia is not criminalized. If passed, HB 481 with the sponsor amendment will reduce legal barriers to syringe access to align criminal law with widely accepted public health practice, saving costs, stopping unnecessary arrests, and improving the collective impact of drug treatment outcomes. Happy to answer any questions when we get there. Thank you.
Okay, thank you very much. Now we'll go to Laura Garcia now for 1 minute.
Good afternoon, Chair Clippinger, Vice Chair Moon, and committee members. My name is Laura Garcia, and I speak with you today in favor of House Bill 481 with sponsor amendments. I work at Healthcare for the Homeless in Baltimore as a primary care provider and medical director. I oversee our medication for opioid use disorder and syringe services program, in which patients receive life-saving medicine and clean supplies. We aim to keep people healthy and alive and work with them to change. Clean supplies are a crucial tool in helping patients with addiction survive the ravages of this deadly disease. The threat of prosecution interferes with patients making responsible health choices by participating in these types of programs. In order to avoid prosecution and jail time, my patients must keep a small program participant card easily accessible at all times, but my patients do not have a safe place to keep their birth certificate. We should be making it easier to manage your health, not harder. Clean syringes are often the first step taken on a journey to reclaim your health, and the law should never prevent someone from taking that first step. I urge a favorable report for House Bill 481 with sponsor amendments. Thank you for your time.
Thank you very much. Are there questions for this panel, please? All right. Seeing none, thank you all very much for testifying. We'll go now to the further witnesses for Delegate or the Vice Chair's bill. Nicole Hanson-Mundell, Michael Collins, Nicholas Ditello, Mike Hilliard, Nancy Rosen-Cohen, David Fell, Harriet Smith, and Ricky Morris Sr. Let's see if Nicole Hanson-Mundell is ready to go.
I'm ready to go.
All right, 1 minute. 1 minute, please.
All right, 1 minute. Good afternoon. My name is Nicole Hanson, Executive Director of Out for Justice. I'm here in support of, I'm in support of Delegate Moon's bill, but I don't have my notes.
House Bill 481. Keep going.
481. Okay, here we go. Again, if we aim to continue with the progress of Maryland and reducing incarceration numbers and associated costs to all Maryland citizens, we must look really closely at the reasons we are locking people up. Again, poverty and addiction. We must respond to these issues in a different way. If someone is found with drug paraphernalia, we should be offering supportive services and social connections that will allow the person to connect with life without drugs. Incarcerating them where they may have access to drugs and likely not even receive adequate treatment and then come out with the added burden of incarceration record will reduce these chances of being able to build a life that feels worth living without drugs. In a nutshell, we should not continuously think that we can incarcerate our way out of addiction and out of these social problems. Let's be creative. Let's come up with meaningful ways to get folks connected to resources that they need. Let's make sure that these state agencies are connecting the dots and keeping each other.
Please.
Thank you, Mr. Speaker, but we can't keep trying to incarcerate our way out of this thing. We got to be creative here.
Thank you very much. I won't tell Speaker Jones about the promotion. Michael Collins now for 1 minute, please.
Hi there, my name is Michael Collins. I represent the Baltimore City State's Attorney's Office, and we support this drug paraphernalia decrim bill. As many of you know, the State's Attorney's Office has stopped prosecuting drug paraphernalia. We've stopped doing that for a number of years. And, you know, the results we have seen in Baltimore City is no negative impact on public safety. This came from a study that Johns Hopkins did recently. But we do know that, you know, state's attorneys can change. This is a policy. This is not a law. And that's why we're supporting this legislation. Criminalizing people for paraphernalia undercuts harm reduction programs, sends drug use further underground, and creates more unsafe practices. Distributing safe drug paraphernalia like syringe programs do is an important tool to encourage people to enter the public health system. It cannot and must not be a tool to enter the criminal justice system. I encourage you all to support this legislation.
Thank you very much. We'll go now to Nicholas DiTello for 1 minute. I'm going to step away just for a minute. We'll come right back. Vice Chair will take over for just a couple minutes. Nicholas DiTello, though, for 1 minute, please.
Thank you for your time. As someone with libertarian leanings, I'm in favor of decriminalizing victimless crimes. I have similar thoughts on this bill as I did on the decriminalization of cannabis. If there isn't a victim, there isn't a crime. My written testimony, like I said, mirrors my thoughts on the cannabis legalization. We have 18,000 people in Maryland prisons, many for drug-related charges. I'm against these laws that target objects instead of the acts of crime. We have these laws, and they're simply used as yet another tool by law enforcement agencies to incarcerate your constituents. I had a family friend growing up who was a victim of laced drugs. And I honestly think punishing addicts for possessing paraphernalia pushes addicts into underground markets, scares them from seeking help, and it puts them into situations where they're alone and vulnerable. We don't have a black market for moonshine on street corners or the gang violence that comes with that.
You could wrap up, please.
Yep. I just wanted to say I support a focus on rehabilitation, legalization, and ending prohibitions on possession of naughty objects the state does not approve of. I urge you to vote favorably on House Bill 481. Thank you.
Thank you. Next, we'll hear from Nancy Rosen-Cohen.
Yes, good afternoon. Thank you. We wholeheartedly support this bill with the amendments that was written this last year. It should be noted that this COVID pandemic, the pre-existing death fatality crisis has worsened. In Maryland, the number of opioid-related deaths increased by 20% between 2019 and 2020. And this will continue to grow. And we do know that decriminalization will support people that are utilizing the growing number of syringe services across the state. Just as importantly, the bill you passed last year would also support and protect harm reduction workers who provide sterile syringes and other equipment. That is why we vote favorably, and we ask everyone to vote favorably on the bill as you did last year. Thank you.
Thank you. Next, we'll hear from Mike Hilliard.
Thank you, Mr. Chair. I'm testifying today as a resident of Towson and a retired major with the Baltimore City Police Department. Every time police make an arrest, we search the person before detaining them. As we pat them down, we ask the suspect if there's anything in their pockets or bags that could hurt us. Suspects will often lie if they're in possession of a syringe, hoping to avoid a paraphernalia charge. Researchers have found that 1 in 3 police officers are stuck with a needle on the job. When we punish people for syringe possession, they do not risk carrying a used syringe with them to dispose of it safely. Instead, they leave it wherever they use it, in a park, in an alley, or in a public restroom. We shouldn't have to worry about our children playing barefoot in the park or our custodians being stuck by needles at work. Thank you for considering this important issue today.
All right. Are there any questions for this panel? Thank you very much. We are going to call the next panel. I believe they're all together in the same room in one Zoom window. So that'll be Dave Fell, Harriet Smith, and Ricky Morris Sr. Is that okay? There you are. Dave Fell, whenever you are ready.
Sure.
One minute.
Great. Thank you, Vice Chair Moon. Hello, committee members. My name is Dave Fell. I do street outreach for Baltimore Harm Reduction Coalition. This involves distributing life-saving items like Narcan and clean sterile syringes to my Baltimore City neighbors. I just wanted to share a brief story about one of our participants who stockpiles syringes and other supplies. She is a weekly regular at one of our outreach sites. And over time, as we built a trusting relationship with each other, she started to request extra syringe kits, Narcan, hygiene supplies, and snacks to bring home with her and to give to some of her elderly neighbors who have limited mobility and can't really leave the house. One day, as she was making one of her deliveries, she encountered one of her neighbors experiencing an overdose alone in his home. Because she was there with supplies, she was able to intervene and save this man's life with intranasal Narcan. This is the reality of the secondary distributor. They care about their neighbors. They check on their neighbors. They care about the health and well-being of everyone in the community. We should not be making it harder for people to be there for each other. I urge you to all support this bill to decriminalize drug paraphernalia with the sponsor-supported amendment, including sales and delivery. Thank you.
All right, thank you very much. We'll have Harriet Smith next for 1 minute.
Sure. I'm Harriet Smith. I also work with BHRC as a service provider and educator. I want to speak about the sponsor amendment just for a moment. I know that you're going to hear about it from us a little bit more. To be completely candid, if we don't work to protect the secondary distributor, a vast network of caring neighbors will vanish. We will tell them through this act that we don't value the free public health service that they provide every week, sometimes every day, to their neighbors and to their loved ones. Just like I went to the store for my neighbor when he got COVID and I got him groceries, so do plenty of other neighbors go to a syringe service program and make sure that they have Narcan, make sure that they have sterile syringes for their drugs or for their insulin, for whatever it's for. We want to encourage neighbors to look out for each other. That's what we all do for each other, right? For one woman, the experience goes a little bit deeper. She has a very strained relationship with her uncle. She sees us every few weeks. She does not use drugs, but she gets supplies for him because he wants to have a relationship with her. And she also wants that, but it needs to be around something tangible so they can have some boundaries. And so she gives him these supplies as a loving act, and he receives them from her as a reciprocally loving act. And so we want to be able to keep people in connection with each other through these services. Thanks so much.
All right, next we'll have Ricky Morris Sr. for 1 minute.
Yes, my name is Ricky Morris. I also work for Baltimore Harm Reduction as an outreach coordinator. One of the things we do here at Baltimore Harm Reduction is we partner with different organizations such as Simmons Memorial and IBR Reach, which is a methadone distributor organization. We have made such a positive impact with outreach, distributing these supplies that we do. The stories I hear from people that take advantages of these programs are so positive, but I also see the other side where people, they're so ingratiated because they need these supplies and they come in handy and they cut down on a lot of things that could put their health at risk and their families and people on the street at risk. But the one thing that I do hear from them is the fear of having these products. They always ask about, well, I don't want to get arrested for having these products. And that's like something that we need to
time
change.
to wrap up, please.
Thank you. I'm done.
All right, thank you very much. Are there any questions for this panel? I believe that is all of the people who are signed up to testify on House Bill 481, and it looks like our chair might be back.
That's correct. I see that as well. And so that concludes the testimony for House Bill 481. And we will let the vice chair totally off the hook because now we're going to go to House Bill 600. House Bills, let me double check on. I don't believe there was anyone signed up to testify in opposition to that, but yeah, I was right. Okay, we are in House Bill 600 and we're going to hear from the vice chair. This is a new bill. The vice chair for 3 minutes, then Lila Meadows, Julie Magers, Shekinah Braveheart. If I mispronounce that, I apologize. We'll do that, and then we'll go through the rest of the list. So we'll hear from that group starting now with the vice chair on House Bill 600.
Thank you, Mr. Chair. House Bill 600 makes a series of reforms to the parole process, and really it's to account for the growing geriatric share of our prison population. We're not going to have time to go into all of the details of the bill because it's actually pretty meaty and makes a series of reforms. So I just want to focus you on the philosophical and policy questions that this bill is attempting to generate. And so I'll actually take you back 8 years ago to the year 2015 when I first got here. And the late Senate President Mike Miller actually recruited me onto a House cross file of a bill. And its purpose was to essentially take physically feeble, sick, or otherwise harmless geriatric inmates and to make them parole eligible if they were old and had served some number of years. And part of the reason was because, again, and this was even 8 years ago, the cost of incarcerating geriatric inmates was very high. You heard earlier today that the average cost today, pre-pandemic and pre all the inflation that we've been seeing, is $43,000 a year. But 8 years ago, that number for these geriatric inmates was over 80,000. And I have to imagine that's got to be much higher now. So part of the reason is because we have to provide healthcare, and it's a lot more complex and challenging to do that behind the prison walls. So this bill would do a few things. It would update parole eligibility to use more modern terminology and to really focus those considerations on the risk of public safety and recidivism, but factoring in age there. And we do know signs of people aging out of crime. It also asks to focus on the difficulty of healthcare behind walls, again, because without some public safety risk, we're talking about, taking maybe upwards of $100,000 or more a year in taxpayer burden for some of this geriatric care. It would also allow people to request a hearing and essentially have the corrections system set up a risk assessment tool to figure out how to score someone's various risks and to do an annual assessment of people when they hit that age. So again, the bill is going to need some discussion and some work, but conceptually it's trying to get at this problem of old people who are not that much of a risk, but cost a heck of a lot to incarcerate. So happy to turn it over to the panel.
All right, let's go to Lila Meadows, please, for 2 minutes.
Good evening. My name is Lila Meadows, and I'm a clinical faculty member at the University of Maryland School of Law. And for several years, I've represented individuals in the parole process, including medical parole. I want to thank the committee and especially my delegate, Chair Clippinger, for your leadership last legislative session in removing the governor from the parole process for lifers and moving Maryland towards a depoliticized parole process. I want to talk about how House Bill 600 makes several changes to Maryland's medical and geriatric parole schemes that strengthen these mechanisms for release for some of DOC's most vulnerable individuals. So I'll start first with geriatric parole, which is currently codified under section 14101 of the criminal law article, which in and of itself is really an anomaly. It's the only provision governing parole that's in the criminal law article as opposed to correctional services. And the result is that only individuals who not only are age 60 and over and have served 15 years, but who have been sentenced to a mandatory sentence for subsequent crimes of violence are eligible for geriatric parole. And I can't imagine that that's what the General Assembly intended when it conceptualized the geriatric parole scheme. And so that means that almost none of the approximately 650 people who fall into that category of being 60 and over and having served 15 years are actually eligible. And then finally, briefly on medical parole, 2 minutes really isn't enough time to go through the bill. But what I want to emphasize is that from my perspective as an attorney representing clients in the medical parole process, one of the most significant improvements the bill makes is really moving it away from the Maryland Parole Commission's reliance, almost sole reliance on the Karnofsky score to evaluate someone's medical condition. There's some good language in the bill that improves that. And so I'm happy to take questions about the language of the bill and what it's been like to move people through this process. Thank you.
All right, we will go now to Julie Magers, please, for 2 minutes. Ms. Magers? Ms. Magers? You're muted if you're speaking. Maryland Prisoners' Rights. There we go. Can't hear you. We'll bring her back in a moment. Let's go to Ms. Braveheart then, please.
Good afternoon. Thank you. I'm with the Justice Policy Institute, Shanika Braveheart. House, we support, JPI supports House Bill 0600, which will provide a fix to the technical errors contained within Maryland's current medical parole statute, as well as deliver enhanced compassionate release opportunities for infirm and or elderly persons in prison, despite posing zero risk to public safety and yet a significant cost to taxpayers. Maryland rarely relies on medical geriatric parole, especially for those with life without the possibility of parole sentences. So those folks are deemed ineligible, hence we have dilapidated conditions within prison, and then we have debilitated people living within them. We have stage 4 cancer patients, completely blind individuals languishing behind bars. House Bill 600 would remedy that. So despite the massive spending spent on correctional health care, they're ill-equipped to meet the needs of inmates such as these that I've mentioned. The accreditation only guarantees a minimum standard of care. So gravely ill individuals requiring treatment to, say, an off-site facility are often made to miss their appointments. Dietary needs aren't met. So the intent of medical geriatric parole was to create a release valve for populations such as these, but it falls short for quite a few reasons that were mentioned previously. So what we would like to see happen is meaningful standards of review put into place, which are developed in conjunction with medical community. Those must be adopted. More specifically, Maryland should move away from a blunt, imprecise instrument like the Karnofsky score, which was also mentioned, as the primary medical determination to assess impairment, and adopt a standard that considers illness and impairment more holistically, with an emphasis on the future risk to public safety and whether the correctional system can adequately provide necessary medical care and rehabilitation that people need, which it does not. So for these reasons, we do support House Bill 600 and ask for a favorable report.
All right, thank you very much. I think that we will try again for Julie Magers, but she is no longer in the room right now, so that's fine. We'll catch up with her if she tries to come back in. There are other witnesses set to testify. We'll start with questions now and go to Delegate Anderson, then Delegate McComas.
Yeah, thank you, Mr. Chairman, and thank you all for showing up this afternoon to help us with this bill. I guess I want to ask an obvious question: is if the state of Maryland is paying all this money for the medical attention for folks who've gotten older and have different kinds of health problems. If we do release them on geriatric parole, do we follow them? Do we help them get these continued healthcare that they need, as well as just follow up with them to make sure that they are able to find, if they can, jobs or get their IDs, things like that. Anybody in the panel, I guess, can answer that.
I'll just say briefly, this came up 8 years ago too, and you may have forgotten because we were on the committee together then, but it would have been under Valerio, and Geraldine was with us. But that question was asked, and you have to have a release plan, placement before you can. It's not just we're going to ditch you on the street in front of the hospital and go. So that is contemplated.
Okay, that's currently in this bill right here. Right.
Yeah, and there's existing practice on that. Yeah.
Well, yeah, that's what I was going to ask about. What is the existing practice of the folks who have been released recently on this geriatric parole?
Yeah, I was going to say I'll let someone else find that while I look for the page number here.
Yeah, so in terms of geriatric parole, no one's being released on geriatric parole. And the reason for that is virtually no one is eligible because of this sort of weird quirk in the law where it's under 14-101 in the criminal law section, which deals with mandatory sentences for crimes of violence. So essentially you have to be a subsequent violent offender to be sentenced under that subsection. And again, I have to think that that's a drafting error. I can't imagine that that's what the General Assembly intended, and it's completely inconsistent with how the rest of our parole law is codified in the state of Maryland. But what I can speak to, Delegate Anderson, is the process for medical parole. And I've mentioned I've represented several clients on medical parole, and what happens is on the front end, we have to put together a release plan for those individuals. And we're talking about people who are pretty sick. Every medical parole case that I've handled is somebody who requires extensive medical care and usually needs to be released to something like an assisted living facility, a nursing home.
And how is that paid for?
So I am not an expert in that. My guess is through Medicaid or Medicare for the vast majority of people, but I'd have to defer to other people who are on later panels who might be able to speak to that better. And Julie might also have.
And the Medicaid or Medicare wouldn't pay for them while they're in prison?
No, that's right.
Okay. All right. Thanks, Mr. Chairman.
Thank you. Delegate McComas, please.
Delegate Anderson did a great job, so I don't have any more questions.
Thank you.
Thank you very much, Delegate Anderson. All right, let's go to, nope, there are no further questions for this panel, I don't believe. So we will go now to the next panel. And one of the people who we're going to include on that panel, let's try again with Julie Magers. We'll hear from her first, but we'll also hear from Elise Desiderio, Camilla Blaha, Sarah Osborne, and Kim Haven. We'll stop there. And then we'll do another panel after that. So let's start for 2 minutes with Julie Magers, please.
Thank you so much, Chairman, Vice Chair, and members of the committee. Sorry for the technical difficulties. My name is Julie Magers. I'm the Director of the Prisoners' Rights Coalition, and I'm here today to testify in favor of House Bill 600. The MPRC is a directly impacted organization supported by advocacy partners to improve conditions of confinement. We have spent numerous years identifying and analyzing conditions of confinement in the state of Maryland, and consistently the reported, documented, and frankly, the most egregious and heinous condition of confinement is correctional health care, especially regarding those who are chronically and terminally ill and the aging population. The evidence that we've gathered and research compiled, including direct evidence from prisoner records, The correctional health care is proven to not only be subpar and inadequate, but also in violation of the Constitution. The majority of incarcerated individuals will never be able to obtain relief, and they languish behind the walls of our correctional system because the grievance process is faulted, it's laborious, and it prohibits any type of actual resolution. The healthcare provider, Corizon, has historically proven to lack the capacity to treat the chronically ill and provide long-term care. And that's the population for which we're talking about. This leads to disabilities, untreated chronic conditions.
Hey, Christine, Kurt Anderson.
And with our aging
Fine. How are you
population,
doing?
hello?
Delegate
With our
Anderson, you are unmuted. Please mute yourself. Thank you very
Sorry.
much. Ms. Magers, we'll give you another couple.
Okay.
A little
No,
more
no,
time.
no
Go
problem.
ahead.
With our aging population drastically increasing and the cost of that health care behind the wall drastically increasing, while the health care needs are continuing to not be met, this is costing the state unnecessarily to no avail, and it's causing more harm than good. This presses the need for the changes proposed in this bill. It's also been proven that people age out of crime, and it goes to somewhat reason that individuals who are so disabled by chronic conditions, they would likely be a low safety risk. Providing those terminal and debilitating health conditions, the opportunity for an opportunity at this type of parole and special parole is going to be a positive outcome. We strongly urge you to support and give a favorable report to HB 600. Thank you.
Thank you very much, despite everything. Thank you very much. All right, Elise Desiderio.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. I'm Elise Desiderio, an attorney with the Office of the Public Defender. I'll be talking about the geriatric parole aspect of HB 600 and urge a favorable report for 3 reasons. 1, seniors are far less likely to reoffend upon reentering the community than younger people. 2, incarcerating seniors is more expensive for the state and its taxpayers than incarcerating younger people. And 3, seniors have particular health and safety concerns that living in prison makes worse. On recidivism, the U.S. Sentencing Commission found that the rearrest rate of released persons was only 16.4% for those older than 59. Moreover, after age 50, released persons are most likely to be rearrested for a minor public order offense. And these are arrests, not convictions. On cost, nationally, taxpayers may pay more than twice as much every year to incarcerate an aging person than they do a younger one. And on health, older prisoners have on average 3 chronic medical conditions. Further, research suggests that prison makes a person age faster than they would living in the community. Seniors in prison are at a higher risk of experiencing physical or sexual assault, bullying, and extortion from other prisoners or staff compared to younger people in prison. The public policy interest in retribution has been satisfied by the many years most elderly persons have already spent in prison. And we know that from data shown from the Unger Group. Expanding options for parole release for seniors in prison is the right thing to do. And for those reasons, the Office of the Public Defender urges a favorable report on HB 600. And we thank you for your time.
Thank you very much. We'll go now to Camila Blaha, please, for 2 minutes.
Good afternoon, members of the Judiciary Committee. My name is Camila Blaha, and I'm a student attorney with the University of Maryland School of Law Gender Violence Clinic, where I help represent incarcerated clients convicted of crimes related to their own gender-based victimization. Currently, not one of our clients qualifies for geriatric parole in Maryland, and it's not because they're not old enough. Many of them are over 60. It's not because our clients aren't suffering from age-related medical impairments. Many of them are. Imagine going to visit your client and they use a walker to enter the room, or they're going blind, or they're in constant pain because of a degenerative age-related disease. Not one of them qualifies for geriatric parole right now. And it's not because they don't qualify for parole generally. Our clinic assists many of our clients in their applications for regular parole, where we emphasize their age, their reduced risk for recidivism, and their increasingly costly medical issues. And yet still not one of our clients is eligible for geriatric parole in Maryland. Why? That's because in Maryland, as written, Geriatric parole is found under Maryland criminal law, section 14101, requires that the person be, quote, sentenced under this section, which only imposes mandatory sentences for repeat violent offenders. That is why our clients are not eligible for geriatric parole in Maryland. Our clients are not repeat violent offenders sentenced as such. It makes no sense. Allowing geriatric parole for repeat violent offenders who are over the age of 60, but not first-time violent offenders who are over the age of 60 cannot be what the legislature intended. Not one of our clients qualifies for geriatric parole as of right now. This bill would change that. Thank you.
All right, thank you very much. We'll hear now from Sarah Osborne.
Good evening. My name is Sarah Osborne, and I'm a student attorney with the Gender Violence Clinic at the University of Maryland School of Law. I'm speaking on behalf of the clinic, and I am pleased to provide my testimony in support of HB 600. The Gender Violence Clinic represents incarcerated survivors of violence. Many of these clients have chronic illnesses and would benefit from changes in the standards for medical parole. One of our clients is a woman diagnosed with stage 4 metastatic breast cancer. Chemotherapy left her weak, unable to care for herself, and confined her to a wheelchair. Imagine being unable to care for yourself, sitting in your own urine for hours or days, enduring long, uncomfortable drives to outside resources and clinics, handcuffed and strip searched to and from every visit. You have little access to a second medical opinion and a limited opportunity to weigh your treatment options with healthcare professionals. You are experiencing these hardships with little access to your support system and family. This same client suffered from Parkinsonism and paranoid schizophrenia, yet all these infirmities were still not sufficient to qualify her for medical parole under the current standards. We have clients who have spent years in the infirmary with chronic illnesses, who are blind, who have undergone open heart surgery, who can barely walk. Imagine pain that is so debilitating that you are on your back all day long. You have limited access to physical therapy or pain management, treatment which would decrease the intensity of the everyday pain you are experiencing. In pain and unable to work, you're confined to your cell almost 24/7. You feel alone and helpless. The current standards for medical parole in Maryland keep all of these people suffering in prison because they are not imminently terminal. They are not on their deathbeds. Yet these people are suffering immensely. They would pose no risk to society if they were released. They would no longer be a burden to the state and taxpayers. The Department of Corrections wouldn't have to spend exorbitant amounts on healthcare services for these people. They could rejoin communities and families that are better suited to care for their illnesses. Thank you.
Thank you very much. If we could hear now from Kim Haven, please, for 2 minutes.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'm back. I'm here today in support of HB 600. I had a whole testimony that I was going to give, and now I'm going to pivot. I know who Sarah was talking about. I watched her. I've watched a woman be in the infirmary on dialysis every single day and then die. She died alone. There's no hospice. There is no compassion. There is no care. She simply died. I watched our older population be victimized by our younger population because they're easy targets for their commissary, for their property, for their getting to order something when we were still allowed to order through catalogs. And I don't remember who it was that said it. I think it was Elise who said that your age, your prison age is very different than what your actual age is. And we know that for a fact. A 50-year-old is actually 63 because of the health, the mental health that they are suffering and going through. The chronic care conditions within our prison walls are only expanding and getting worse. Left untreated, this will develop into conditions that are going to require a level of care that our state and our correctional healthcare providers are unable to meet. At the end of the day, you've heard the statistics, you've heard that this was not the intent of the General Assembly, and I believe that as well. I can tell you that I have watched people try to get out to be with their family in their last days and have it be denied. There's no dignity in this process. They just simply die. This is unacceptable. We know they age out of crime. We know they don't pose a threat. How is somebody in stage 4 cancer a risk to public safety? She's not. How is somebody who's getting dialysis every single day a threat to public safety? They're not. How is someone who is blind and on a walker, which by the way, I've also seen, how is this dignified? How is this treating the individual? And how are they a threat to public safety? I therefore urge a favorable report on HB 600, and I'm happy to answer any questions of the committee.
you.
I'm also happy to tell more stories of what I've seen. Thank you, Mr. Chair.
Thank you very much. Questions now, Delegate McComas.
Just, I guess, Ms. Haven or whoever has the figures, how many individuals fall within this category, men versus women, that are in bad physical shape and you know, like the dialysis or the walker? Do you have some idea?
Anecdotally, there are more men than there are women, but that's only reflective of the fact that our prison population is largely men and not women. It also doesn't take into account the releases that we did during COVID. Right now, trying to get that information out of DPSCS is like pulling teeth. We are working on it, and I know that the Student Law Center and I know that the OPD and Lila are trying to get that information so that we can get you accurate numbers, but those were not the people that we were releasing during COVID.
Just if I may, Mr. Chair, a brief follow-up. What type of crimes did they commit, the folks that are, you know, in serious shape right now, that there was like this reluctance to let them go out of the system?
In all truth, the one that I was talking about that was on the dialysis had committed a murder 35 years ago.
And then was it like her husband, or was it a close relationship, or just
yes.
somebody else? Okay.
Yes, it was a close relationship. And then she spent 7 years fighting and trying to get medical attention. And the last 2.5 years she spent living in the infirmary before she finally passed.
Okay. All right. Thank you, ma'am.
Right. Are there further questions for the panel? Seeing none, we thank you all very much. We're going to hear from another panel, including one person who's favorable with an amendment, but we're just going to keep rolling here. Rachel Kamens, Vivian Penda, Melinda Moyd, Molly Gill. Let's hear from Rachel Kamens. She is in the room. Rachel Kamens.
Yes, sir. I am here.
All right.
I am.
2 minutes.
Yes, thank you.
All right.
Good afternoon, Mr. Chairman and members of the committee. My name is Rachel Kamens, and I'm here on behalf of the Public Defender's Office to urge a favorable report on House Bill 600. I'm going to address the medical parole piece of legislation. Maryland's unduly restrictive and ambiguous medical parole statute allows for the continued imprisonment of people who are physically incapacitated and terminally ill, whose further incarceration serves no societal interest, burdens the taxpayer with exorbitant healthcare costs, and dooms even the most frail and debilitated inmates to spend their final days behind prison bars alone and suffering. Between 2015 and 2020, the Parole Commission granted a mere 1/3 of the 339 medical parole applications it received, and that is appalling. House Bill 600 expands eligibility, thus enabling the release of inmates whose medical needs exceed the capacity of the Division of Corrections. This is both humane and fiscally prudent. Under this bill, the inmate may ask for an independent medical examination to be performed, and the commission is required to give priority consideration to that examination. The bill also allows or mandates, a meeting among the parole commission, the inmate's family, or the inmate's representative. These two features of the bill enable a comprehensive and dynamic assessment of the inmate's medical needs, the risk to public safety if parole is granted, and the risk to the inmate if parole is denied. I want to tell you two quick stories. A 70-year-old client of mine who was incarcerated half his life, was wheelchair bound, suffering from Parkinson's and early dementia, was in congestive heart failure, and was urinary incontinent. Suffice it to say, this man presented no danger to society whatsoever, and his condition would only deteriorate. He had a sister willing to take him into her home and pay for full-time nursing care, and he was also entitled to VA benefits. Medical parole was denied. We weren't given any explanation why. Another client of mine just last year was 62 years old when diagnosed with stage 4 colon cancer and given 1 to 3 months left to live. He had tumors all over his abdomen. He was in constant pain, unable to walk, barely able to breathe. We filed a request for medical parole, and he had a loving wife who arranged for hospice care in her home at her expense. Unfortunately, this client died before we even
Ms.
ever
Kamens?
heard back from the commission. Change to this broken system is needed, and House Bill 600 is that change.
Thank you very much. Olinda Moyd, please, for 2 minutes.
Good afternoon again. I'm Olinda Moyd, testifying on behalf of the Maryland Alliance for Justice Reform. Judge Karoom submitted written testimony on behalf of the committee, and I will focus just on the geriatric aspect of this bill. Specifically, Section 7-3055, which requires the commission to take into account the totality of the circumstances, including the age of the individual. When I began my career as a prisoners' rights and parole attorney more than 35 years ago, I had the pleasure of working with the NAACP. We opened one of the first prison chapters behind the walls at the Maryland State Penitentiary. It was there that I began to know many of the men and women at that time who were housed in Maryland's prisons for extremely long periods of time. And if anyone remembers the old giant structure of the Maryland Penitentiary in Baltimore, you know that it was an old building. It was eventually demolished. Unfortunately, over the years, what I've witnessed with people that I came to know during that time, I have come to see them also grow old and sickly during the time that they have spent decades behind bars. Even though they pose no risk to the community, the probability of them reoffending is quite low. The cost to house them is quite high. They remain in prison. One of these individuals is a person named Mr. T, who I've known for decades. I have watched his physical body deteriorate over the years. He graduated from using a cane to a walker, and now he's in a wheelchair at JCI. He's 74 years old. During my recent pro bono representation of him at his parole hearing, the focus was solely on his original offense, not his age, not his recent cancer diagnosis, but his offense. Medical parole was denied, no reason given. He is a veteran, would have access to veteran services. The passage of this bill, yes, the passage of this bill would mean for him and individuals like him that the parole commission would not be able to just brush aside his age, but enforce that everyone deserves a second chance. Thank you.
Thank you. Molly Gill now, favorable with amendments. Molly Gill for 2 minutes.
Thank you, Chair Clippinger and members of the committee. My name is Molly Gill. I'm FAM's Vice President of Policy. FAM is a national nonpartisan sentencing and prison reform advocacy organization in Washington, D.C., and we support HB 600 and are grateful for Vice Chair Moon for bringing this important bill forward. I'd like to talk about some of the work that we've done on this issue. We've been around 30 years and have always been interested in medical and geriatric release systems across the country. We analyzed these systems in all 50 states and the district, and unfortunately found that they are poor everywhere, including in Maryland. And particularly medical parole in Maryland is among the most poorly designed programs in the country. So we're very excited to see this opportunity to make some long-needed improvements to the law. Some of those improvements include creating and standardizing eligibility criteria, making sure that regulations at the Parole Commission line up with the law in the code. And we think adding terminal illness is an essential adjustment that needs to be made. We submitted a written statement that included our proposed friendly amendment. It adds terminal illness as a grounds for medical parole. And because neither the current statute nor the regulations address terminal illness in eligibility criteria. Only 3 other states do not provide release for the terminally ill, so it would be quite an exception to leave them out. The proposed amendment uses the language in the Federal First Step Act, which is the best compassionate release, medical and geriatric release law in the country. We use that language to define terminal illness. We also define people with a chronic debilitation or incapacitation using that federal language. And we would really encourage the commission to think less in terms of months left to live and more in terms of a terminal illness having an end of life trajectory. Doctors are very reluctant to diagnose people as having only a certain number of months left to live. The end of life trajectory opens that up and recognizes that terminal illnesses may take time to unravel. And while that is happening, someone does not need to be incarcerated in prison at twice or 3 times the cost.
All right, thank you very much.
Thank you.
That concludes the testimony from people in favor. We'll take questions to them now, please, if anyone has any questions. Right, seeing none. Thank you all very much for your testimony today, and we're now going to go to those testifying in opposition to the bill. We'll hear from David Law and Susan Barron. Both are from DPSCS. So we'll let them in. Either David Law or Susan Barron, please. See Susan Barron. We can start with you for 2 minutes then.
Hi. Good afternoon, Chair Clippinger, Vice Chair Moon, and members of the committee. My name is Susan Barron. I'm the Assistant Attorney General who represents the Parole Commission, and I'm here today only to answer any legal questions that you may have. I'm not here to take a position.
That's fine. All right, then let's hear from David Law then.
Hi, good afternoon, Chair Clippinger, Vice Chair Moon, and the members of the Judiciary Committee. My name is David Law. I'm a parole hearing officer from the Maryland Parole Commission. And while we greatly appreciate the intent of the bill sponsor, the Parole Commission respectfully opposes House Bill 600. This bill greatly expands the number of individuals who may be eligible for medical parole. Currently, there are 1,237 individuals over the age of 60 who are eligible for parole. 1,003 of these individuals are serving a sentence for a violent crime or a crime of violence. And 51% of those inmates have a victim notification requirement. In addition, 577 of the 1,003 inmates are serving life sentences. The bill would add subjective considerations to the parole process, such as the age of inmate. It would also require that the commission to consider whether the care of an incarcerated individual would be better from a community provider than from that of the department's medical providers. The parole commissioners and hearing officers are not medical professionals. House Bill 600 would require that they place priority considerations on the findings of the requested medical evaluation instead of the treatment recommendation of the department's medical providers. House Bill 600 would also allow the inmate, a family member, or representative to request a meeting with the Parole Commission, and it would require that the meeting shall be heard within 30 days of the request. This would conflict with victim notification requirements, which must be done 90 days prior to any parole release hearing. Requiring a meeting to be conducted within 30 days of the receipt of the request will place a burden on the members of the Parole Commission, as it is anticipated the volume of requests will increase. Finally, House Bill 600 would require the development of a dynamic risk assessment to include a strength-based needs assessment component to assist in determining the conditions of release. We are not aware of an existing instrument, and we project it could take several years to develop and validate an appropriate instrument at a cost that is not known to the department. For these reasons stated, we respectfully request an unfavorable vote on House Bill 600.
Thank you very much. Are there questions for this panel?
There I am.
Seeing none, we thank you both very much for your testimony today. And that will end the bill hearing on House Bill 600. Thank you all very much for that. Now on the last bill of the evening, there are quite a few witnesses for House Bill 559. So we will get underway. We'll hear from Delegate Fisher, Gabriella Carl, Janice Alonso, Judge Andre Davis, Carrie Williams. Carrie Williams listed as being favorable with an amendment. So, okay, Delegate Juanica Fisher, please, with House Bill 559. Thank you.
Good evening. The greatest working and hardest working committee of the Maryland General Assembly. My name is Delegate Juanica Fisher. Thank you, Chair Clippinger and Vice Chair Moon. I'm here to discuss my proposed legislation, HB 55, which is probation, not deportation. I want to thank this committee for standing with me in different iterations of this bill since 2018. And to say that this bill is not only a passion of mine, but something that I've been trying to champion here in the legislature for 4 years now. And not only because I think it's the right thing, but because it affects my family, my friends, my residents, and all Marylanders. This bill started in a different place. Today, you're going to hear testimony in support from the Maryland State Bar Association, from our state's attorneys associations, from the Office of the Attorney General. To say not a lot of hard work and compromise was put in would be an understatement from where we are today. This bill allows defendants to enter probation before judgment in a court on facts justifying a finding of guilt. This is important because our current probation before judgment language is all in effect a guilty finding in federal immigration law. That means for not every Marylander, a PBJ is not a second chance. It is a sentence to deportation, and it hurts Maryland families. You will hear from federal judges and so many experts, but what I will also say and want my committee to think about is a resident, a family member, a father, a mother in my community will get a traffic violation. And because they get a probation before judgment, you would think things are okay. But if they are not a US citizen status, if they have a legal status or undocumented, it will be seen as a violation of guilty in federal immigration law. And that means a family member, a provider, will leave this country. And there are economic also implications to that, as that family will now need the support that that person was bringing to that family, which means a breadwinner, which tends to be a male in certain communities, will then be leaving the home, and those children will be on different assistant programs because that person has now entered into deportation proceedings. I want to hold my time there, as I know there are so many passionate people set to testify, not only a panel of experts, but community members. Again, I want to thank this committee. It's been a long journey of 4 years, and I know we're going to see it through this year. Let's vote for, and I urge a favorable report on probation, not deportation.
Gabriella Carl, please, for 2 minutes.
Chair, Vice Chair, committee members, my name is Gabriela Kersia Carl, Associate Director of the Chacon Center for Immigrant Justice at Maryland Carey Law School, and I'm asking for a favorable report on HB 559. Because a PBJ plea is a conviction under federal immigration law, it can trigger detention and deportation for Maryland residents who are non-citizens, even people with lawful immigration status like permanent residents and DACA holders. This bill proposes an equitable solution. add an alternative additional process to Maryland's PBJ statute so that courts can find facts justifying a finding of guilt without requiring an admission of guilt from defendants. The disposition proposed is not new to Maryland law and procedure. Maryland courts already have the authority to enter into a probation agreement without a formal finding of guilt, such as in a nolo contendere plea. This bill protects due process and is structured to ensure constitutional authority to hold any defendant who violates their probation accountable immediately. Non-citizens will have a strong incentive to comply with the terms of their probation because if they do violate and the court finds them guilty, it can still lead to detention and deportation. There is broad recognition that this bill is necessary. It fills an important gap in Maryland law. This bill creates a disposition that is reliably immigration friendly, will ease the administration of justice, contribute to finality of judgments, and reduce post-convictions. In appropriate cases, this disposition is a valuable tool that obviates the need for complex immigration analysis and complicated plea structuring that is often necessary, but can still fail to prevent unintended immigration consequences. This disposition will therefore reduce the number of post-convictions and appeal filed to rectify unjust pleas. This bill also promotes racial justice. Because communities of color are over-policed and prosecuted, Black and brown people are more likely to face adverse and often severe immigration consequences as a result of low-level crimes where a PBJ is warranted. The bill before you today was developed with support from and in coalition with the Office of the Attorney General, the Maryland State's Attorney Association, and other criminal and immigration legal experts, many of whom you will hear from today. This bill enjoys broad support from various organizations like the MSBA, the Roundtable of Former Immigration Judges, AILA, United We Dream, and many more as reflected in the sign-on letter we filed and in the broad array of witnesses you will hear from today. The only opposition is from the Administrative Office of the Courts. We believe we have addressed their concerns as will be evident in the forthcoming testimony. This bill ensures fairness, promotes racial justice, and equal treatment under the law for all Maryland residents. I therefore urge a favorable report on HB 559, and I'm happy to answer any questions. Thank you.
Janice Alonso for 2 minutes, please.
Thank you, everyone. My name is Janice Alonso. I'm a senior academic advisor, adjunct faculty at the Community College of Baltimore County. I'm also a doctoral student at Morgan State University working on my dissertation for a degree in community college leadership. My bachelor's degree is in anthropology from Ithaca College and master's degrees in international affairs from Florida State. My experience in higher ed has spanned more than 20 years. I'm also fluent in Spanish and I've traveled to over 20 countries. I'm also a US citizen who was born in Syracuse, New York, and I've lived in 3 different states. I'm submitting this testimony in support of House Bill 559 because it needs to get passed so that everyone who has a PBJ is not deported. A close family member who has DACA received a DUI in 2020.
Ms. Alonso, if you'd like a moment, that would be fine.
Thank you. After he went to court, his charge was a PBJ. He completed alcohol counseling classes even before his court hearing and is working on paying the fine incurred by the court. He made a mistake that night in 2020, but he's taken full responsibility for what happened. This family member is also married and he has a small child. He owns his own business, owns his own home, and pays taxes loyally every year. His child is the most important thing in his life. And every day we worry that this PBJ could lead to deportation and not seeing his child grow up every day. He takes his child to sports activities, indoor playgrounds, and more, and he loves his daddy. The family member and the rest of our family treat every day as special in the case that his days in the US are limited. We've cried and are very worried about the fact that this family member could be sent back home because of this one night mistake. What happened almost 1.5 years ago was a wake-up call for him, and things truly got better for all of us after he realized what he had done. The fact that a PBJ could break apart our family and cause a little boy to lose his father has been very stressful and heart-wrenching for all of us. The family could lose their home as he's the main income source for the family, and his employees could lose their jobs since they work for his company. The family member has been in the US for 17 years, and this is the only incident on his record. It would be unjust for a family to suffer unnecessarily because of the PBJ. So I'm pleading our elected officials that House Bill 559 is passed so that no family is affected by PBJ and no one's subjected to deportation because of having the PBJ on their record. Thank you.
Thank you. Judge Andre Davis, please, for 2 minutes.
Mr. Chairman, members of the committee, thank you very much for this opportunity for me to add my voice to the wide array of advocates and experts supporting this bill, and I urge the committee to report favorably. Of my 30 years on the bench, the last 8, I was privileged to serve as a member of the United States Court of Appeals for the Fourth Circuit. During those 8 years, I heard scores and scores, if not hundreds, of immigration cases of all types. And so I bring to my advocacy in support of this bill really front row experience with the harshness of some of the outcomes that are visited on residents. I firmly believe that the General Assembly would never enact a statute that explicitly did what the current state of the law does. That is to say, the General Assembly would never enact a statute that afforded PBJ treatment to citizens, but not afford PBJ treatment to non-citizens. The General Assembly would never do it. And frankly, if the General Assembly somehow through a drafting error did it, I have no doubt that the Court of Appeals of Maryland in particular, would find that statute unconstitutional. So what we have in the operation of the PBJ statute unamended is an unconstitutional denial of the equal protection of the laws to some of our residents in Maryland. Earlier today, on another bill, you heard Chief Judge Morrissey celebrate how the courts of Maryland treat individuals holistically. And Chief Judge Morrissey is absolutely right about that. An important ingredient of the holistic treatment of individuals before the courts is to afford each and every one of them equal protection of the law. The General Assembly of Maryland did not break the PBJ statute, but it is broken. Fortunately, the General Assembly can fix it. And so I urge favorable report. Thank you very much.
Thank you very much. Carrie Williams for 2 minutes.
Thank you. Good afternoon, Chair Clippinger, Vice Chair Moon, and members of the committee. I could not articulate the need for this bill better than my fellow panelists, so I'm going to focus on the legal concerns that have been raised by the opposition to this bill. It's my understanding that 2 main concerns have been raised about the possible legality of this bill. One has to do with the ability of the court to find facts justifying a finding of guilt without an actual trial. And the other has to do with finding someone guilty beyond a reasonable doubt at a violation hearing when there hasn't been a trial. With regard to the first, courts already consider agreed statements of fact and find verdicts of guilty without a trial all the time. In a proceeding called a not guilty statement of facts, the defendant pleads not guilty, he waives his right to a trial, and the court hears proffered or agreed facts. If those facts are sufficient to support a verdict of guilty, the court then enters a verdict of guilty without ever having a trial. With regard to the ability to place someone on probation without a finding of guilt and then subsequently convict them at a violation hearing, that's very similar to what we already have in the form of a nolo contendere plea. Rule 4242E says that when a court accepts a plea of nolo contendere, which of course has to be put forward at the consent of the defendant, the court shall proceed to disposition as on a plea of guilty, but without finding a verdict of guilty. There is no verdict entered in a plea of nolo contendere, so it's not a conviction. However, the court can proceed to disposition just as though there were a conviction. That's what this bill does, but this bill actually does it even better. And that's because this bill has a specific provision that says, upon a violation of probation, the court can consider those facts that it already found justified guilt beyond a reasonable doubt, and then enter a verdict of guilty. Virginia has a very similar statute. It's at Virginia Code Annotated 18.2-251. It has been in effect since 1991, and both the Virginia courts and the Fourth Circuit have cases that opine favorably on that statute. That statute says that if the facts found by the court would justify a finding of guilt, a court may, without entering a judgment of guilt and with the consent of the accused, defer further proceedings and place the defendant on probation. Upon violation of a term or condition, the court may enter an adjudication of guilty and proceed as otherwise provided. If it works in Virginia, it can work here. I think that the legal objections to this bill are unfounded, and I'm happy to answer any questions. Thank you.
Thank you very much. All right, that's the end of this panel. Go to Delegate Nicole Williams to begin.
Yes, thank you, Mr. Chair. Ms. Carl, just a quick question. I had heard that there are amendments or changes addressing DV, domestic violence and violations of PBJ. I was wondering if you can expand upon those changes that are pending.
Oh yeah, thank you for your question, Delegate Williams. So what our partners wanted to make sure, and rightly so, was that the consequences that attach to the original PBJ would still attach if somebody used this new version of the PBJ. And we have made amendments to make sure that that is the case. To be clear, the original version, I think, already had envisioned that. We certainly wanted that, but we did add some amendments to clarify that all of the same consequences will attach regardless of which form of PBJ you get, and also so that all the same people would be ineligible for the PBJ. So this doesn't expand anything, and it ensures the consequences remain the same for everybody. So again, our objective here is equal treatment, equal justice under the law.
Okay, thank you.
Thank you.
Delegate Anderson.
Yeah, thanks, Mr. Chairman. I'd like to thank the panelists who testified so far on the bill. My question is going to be going to Judge Davis. Your Honor, the 8 years that you've served in federal court, thank you for your service. But what would a prosecutor or defense attorney have to show you in terms of the defendant's prior PBJ, which is now being changed? What kind of language do you have to see in order to say that this person is not eligible to be deported because this is not a conviction?
The procedure, thank you for the question, Delegate Anderson. The procedure embodied in the amended bill that's before the committee today absolutely takes care of that. The problem that the federal interpretation gave to our state's PBJ statute was in respect to the defendant's admission of guilt. And this amendment makes it unnecessary for the defendant to admit guilt. But as Ms. Williams just explained very carefully, it doesn't matter for purposes of punishment, for adjudication, for future probation violation proceedings. None of that will be adversely impacted by this change from an admission of guilt to facts sufficient to find guilt. They are in law exactly the same thing.
All right. And the transmission of that information to the courts, whether it's in his, I guess it's in his NCI, in his record or whatever, what does the court see that's different, that will be different now?
It will be in the record. It will be in the record of the case.
And what will the record say, Judge?
And the fact of the matter is, the feds will not seek to deport people who receive a PBJ under this amended statute. So it will never come before the federal courts in the first place because it won't advance that far.
Okay. Okay. All right. Thank you so much.
Thank you.
Are there further questions for this panel? Seeing none, thank you all very much. We'll hear from Lisa Dornell, Gary Bear, Jeremy Eldridge, Emily Johansson, Johanna Silver, Brian Savin, and Jacob Lichtenbaum. We'll hear from this group and then we'll take questions for that group. Ms. Dornell. Ms. Dornell. Lisa Dornell, please, for 2 minutes. Lisa Dornell. All right, we're going to go to Gary Bear and then we'll come back to Ms. Dornell. Gary Bear, please, for 2 minutes.
All right, thank you, Chair Clippinger, Vice Chair Moon, members of the committee, especially Delegate Shetty, District 18, my home district. I want to testify in favor of House Bill 559 for three
Ms.
main.
Carl, just a quick question.
Was somebody asking a question?
Try again, Mr. Bear. Go ahead and start again.
Okay. Basically, I'm testifying in favor of 559 for 3 reasons. One, as has already been mentioned, it's good public policy. Second, this bill as amended is clear and easy to apply. And third, this would actually lessen some of the post-conviction and appellate challenges that currently arise. I come to you as a recently retired circuit court judge. I served on the circuit court for Montgomery County for 9 years. I've been involved in many aspects of the criminal justice system as a prosecutor, defense attorney, law professor. And I've seen these cases and the draconian effects they have on immigrants. And I echo the panelists who have testified before me. So I'm asking that the court, or that the legislature really do what's happened in Virginia and some of the other states. But I want to address it also from the prospect of why this is a very clear and easy bill to apply. Trial judges already apply this PBJ statute in 4 contexts. It comes up after a trial, after a guilty plea, after a nolo contendere plea, and after a not guilty agreed statement of facts. All this bill does is add a 5th category, and that's where the court finds facts justifying a finding of guilt. Also, to echo what Kerry Williams said, what Judge Davis said, this is not different. This is what judges do all the time when there's a guilty plea. They have to make a finding there's a factual basis for the plea. This is really all that a judge would be doing in this context. And as has been mentioned, this has been upheld by the 4th Circuit in Virginia. And as I'm sure everyone knows, the 4th Circuit is also the circuit that covers Maryland. The other thing I want to emphasize is how this could actually benefit the courts by lessening post-conviction and appellate challenges, because currently, if a non-citizen gets the benefit of a probation before judgment, he or she often ends up in removal proceedings. At that point, defendants will file appeals, post-conviction petitions, quorum nobis petitions in a last-ditch effort to overturn the PBJ that's usually based on a guilty plea. These post-conviction quorum nobis proceedings are extremely time-consuming. They're expensive. They take up the time of prosecutors. They take up the time of the courts, appellate courts as well. And then sometimes if the defendant is successful, the thing that might have happened 5 years previously is overturned. That can lead to the prospect of a second trial, or the non-prospect of a second trial, because it's now too late to retry the case. This leads to injustice to the victims because the case may not be prosecuted at all. So really this.
And that's about time.
All right, well, again, I just want to add my name to all the other organizations that are in favor of it, and I'm happy to answer any questions. Thank you.
Thank you, Judge. Next, we'll hear from Jeremy Eldridge for 2 minutes.
Good evening, everybody. My name is Jeremy Eldridge. I'm a former Baltimore City prosecutor and a current trial attorney who specializes in criminal defense. We also handle immigration removal matters at our firm. This bill is undeniably important to reduce the inequities that Maryland non-residents and immigrants suffer However, I'd like to address it in a broader context. Having been a defense attorney, this bill can impact the 300,000 federal employees that we have in the state of Maryland, people with security clearances, people whose children may go to Merriweather Post Pavilion with a fake ID and then lose their future having any job with a fiduciary responsibility. This bill doesn't just reduce those inequities, but it saves the bright futures for a lot of our working men and women and children. As a former prosecutor and current defense attorney, I'm prepping one of these for tomorrow, a quorum nobis. I've handled hundreds of quorum nobis and post-conviction proceedings. Wouldn't we all enjoy a process that fosters efficiencies of not having to worry about reopening these probation before judgments? Wouldn't we like a process that offers a higher level of finality in these cases so that lawyers like me aren't telling people, well, I'm sure a lawyer told you 5 or 10 years ago that this was okay, but it wasn't. And this new brand of probation before judgment not only helps a lot of our children and our friends and family members, but the calculus is easy. The calculus is very simple. You're giving an amazing benefit to a lot of first-time offenders. You're reducing inequities. And frankly, if the individuals who benefit and stand to benefit from this new type of PBJ don't take advantage and choose to violate, all of the universe of consequences that already exist are still within the hands of the judiciary to impose. The math is easy. Do we want to stay different than Pennsylvania and Virginia? Or do we want to show the United States of America, who can't seem to get Congress in a situation to change the definition of a conviction? Let's do it for them and let's protect our residents. Thank you very much. I'm looking for a favorable vote.
Thank you. Next, we'll hear from Lisa Dornell for 2 minutes.
Thank you, Mr. Chairman, Vice Chair Moon, members of the committee. My name is Lisa Dornell, and as a retired United States immigration judge, I urge a favorable report on House Bill 559. 29 years ago, as a Justice Department lawyer advocating for the U.S. Attorney General's position in an immigration case, I stood before a distinguished panel of the Fourth Circuit Court of Appeals, and I argued in favor of a man's deportation. The man in that case was the recipient of a probation before judgment entered by a Maryland state court judge. Even though he was not considered to have a conviction under Maryland law, I persuaded the court that he still stood convicted under federal law because of a quirk in the language of the Maryland PBJ statute. Despite the fact that a state court judge had already deemed him to be both worthy of probation and a successful probationer without a conviction, my argument in that case resulted in a final order of deportation and in a binding decision that now affects every Maryland non-citizen with a PBJ who appears before an immigration court. Looking back on over an almost 36-year career in the immigration field, it's become clear to me that not every win on the law is a win for justice, because in order for justice to win, there has to be fundamental fairness for everyone who is subject to our laws, regardless of citizenship status. The current disconnect between our state PBJ statute and the federal immigration law results in a bait and switch, and that's profoundly unjust. As a sitting immigration judge, it was painful to issue a deportation order against a Marylander with a PBJ because they benefited from probation in Maryland, and not, for example, in Virginia, where the legislature has more precisely drafted its PBJ statute such that its non-citizens are not deportable under the federal law. The proposed revision of the Maryland PBJ statute would remove the grant of a Maryland PBJ from the federal definition of conviction and would result in fairness, consistency, and a win for justice. So I urge a favorable report on House Bill 559 to ensure justice for all of our Maryland residents. I thank you.
Thank you. We'll now hear for Emily Johansson for 2 minutes.
Chair, Vice Chair, and committee members. My name is Emily Johansson, and I'm an attorney on the Maryland team of the Capital Area Immigrants' Rights Coalition. We urge a favorable report on HB 559. Our organization represents immigrants who are detained, and our client data shows the harmful impact the existing PBJ system has on immigrants in Maryland, particularly immigrants of color. 99% of CARE Coalition clients with a Maryland PBJ were Black or Brown. Of those, at least 53% were detained by ICE after having contact with the criminal system. These numbers exemplify the ways that our criminal legal system and its racial discrimination have long served as a direct funnel to the immigration legal system. Black and brown immigrants are more likely to have encounters with law enforcement and to be charged and prosecuted for crimes which lead to deportation. And while in ICE detention, Black immigrants are 6 times more likely to be sent to solitary confinement. Overall, Black and brown immigrants are more likely to be detained and deported. But this bill will help to reduce the detention and deportation of immigrants who are disproportionately harmed by the criminal legal system. This legislation is more important than ever now in the context of our global pandemic and the high prevalence of COVID-19 in immigrant detention centers. HB 559 promotes racial equity, fairness, and safety for all Maryland residents. For these reasons, we respectfully request a favorable report. Thank you.
Thank you very much. Next, we'll hear from Joanna Silver for 2 minutes.
Thank you, Vice Chair Moon. My name is Joanna Silver, and I live in District 18 in Silver Spring. I advocate on behalf of several different organizations, and I work professionally as a federal public defender. Today, I am happy to be here testifying in favor of HB 559 on behalf of Jews United for Justice. One of the core concepts of Judaism is teshuvah, or repentance. Teshuvah recognizes that all people are capable of acknowledging mistakes they've made, of making those mistakes right, and through that work, earning a second chance. The Maryland General Assembly recognized the importance of second chances when it created a way for people to avoid the harsh consequences of a criminal conviction through a probation before judgment. But non-citizens of Maryland do not get the full benefit of a PBJ, and immigration consequences of criminal conduct, including deportation, remain a threat, even if someone has otherwise earned their second chance. Moreover, people who are deported because of a PBJ also face liability for the federal felony offense of illegal reentry into the United States if they return to be with their families or escape violence or other hardships in their home countries. HB 559 is an easy way to remedy this inequity, and it is consistent with steps the General Assembly has previously taken to recognize that citizenship status should not prevent people in Maryland from contributing to their fullest potential. It recognizes that our state has a stake in helping everyone who lives here thrive. As a former practitioner in Maryland state criminal courts, I also know that having this option available can benefit not only defendants, but also the state and victims, and it furthers the interests of judicial efficiency. Second chances for everyone, regardless of immigration status, benefit all of us. On behalf of Jews United for Justice, I urge a favorable report on HB 559.
All right, next we're going to hear from Brian Zavin for 2 minutes.
Good afternoon, Chair Clippinger, Vice Chair Moon, members of the committee. I'm Brian Zavin. I'm the Chief Attorney of the Office of the Public Defender's Appellate Division. The Public Defender supports HB 559, which would provide a much needed correction to Maryland's probation before judgment, or PBJ statute. The other witnesses you've heard from addressed why the law needs correcting. I'd like to address how the law will work if it's enacted. The key takeaway is that it will not upset the apple cart. This is an easy law for our courts to implement because they're doing similar things every day. The defendant begins the process by entering a plea of not guilty. As with PBJs currently, a court must then find that the PBJ is in the best interest of the defendant and the public. The defendant then consents in writing and provides an on-the-record waiver of trial and appellate rights. Next, the court hears a proffer of the facts and makes a finding that the facts would be sufficient to support a finding of guilt. The court then defers entering that finding of guilt in exchange for the defendant's agreement to complete probation or face entry of the finding of guilt and sentencing in the event of a violation. That's it. Courts already make findings based on proffers of fact in the context of guilty pleas and not guilty agreed statements of fact. And courts already impose probation and like consequences on pleas other than guilty in the context of NOLO pleas and no process in steps with a requirement of drug or alcohol treatment. What's needed? What ensures that the defendant's right to due process is protected is the requirement that the defendant consent and give a knowing and voluntary waiver. The only new thing about the law is the deferred finding of guilt, but this is a PBJ in all other respects. If a defendant is not currently eligible for PBJ due to the nature of the crime, the defendant remains ineligible. If the defendant is unable to obtain a certain type of license because of a PBJ, the defendant remains ineligible. HB 559 fixes what's broken, no more, no less. That's not to trivialize its importance. Current procedures, including the use of NOLO pleas and not guilty agreed statements of facts, all lead to a conviction for immigration purposes because they involve a finding of guilt or an admission of guilt. To avoid that consequence, right now, charges must be dropped. HB 559 fills in that gap by providing a way to hold defendants responsible, protect the public, and at the same time, avoid overly harsh and unintended collateral consequences. The Office of the Public Defender urges a favorable report on the bill. Thank you.
Thank you. We got one question from Delegate Cardin for a specific panelist.
Yes, thank you very much. Thank you, Delegate Fisher, for this great bill, which I'm a co-sponsor of, and for your very esteemed panel and the previous one as well. This is for Judge Dornell, which your testimony was very compelling. Thank you, as was everybody's. But I'm just curious. So it's very interesting to see you having argued one direction previous as a prosecutor and then another direction as a judge, or looking at the inconsistencies as a judge. Do other judges, are there inconsistencies in how judges rule in these types of things, or is it pretty much known that in Maryland, a PBJ is not going to get you what you need, is not going to get the defendant what they need in federal court?
Well, I think that's part of the problem. Thank you for your question, Delegate Cardin. Part of the problem is I think that there is a lack of awareness when defendants accept a PBJ that there's something bad that's going to happen down the road if they are non-citizens. And that's why I refer to the situation as a bait and switch. Everybody, all the parties, the state court judge, the defense, the prosecution, everyone agrees that this person is worthy of probation. But when they get into immigration court as a judge, I used to tell the advocates who frequently appeared in state court cases, when you step into federal immigration court, there's a little problem for you called the supremacy clause. This is an opportunity for the state to enact a measure that trumps what the federal government wants to do, because the problem is this was not, the federal interpretation completely undermines the intention of the state legislation. And yes, you know, as an advocate for the Attorney General of the United States, I advocated. But as a judge, I was in a far different position, and the gross disparity was just difficult to bear. Case number one comes in, a gentleman from Maryland with a PBJ, and he's got to go because he's got a conviction under federal law. Case number two walks in behind him, a gentleman with a PBJ from Virginia, and he's free to go because the Virginia legislature was able to craft its legislation in a manner that gives meaning to the intention behind a PBJ statute. And that's what we need in Maryland, and we can't wait any longer.
I think we feel, yeah.
All right, thank you all very much. I believe that's all the questions for this panel. We're going to call up the next panel, Suzanti Fallingstead, Kate Sugarman, John Gossert, Dana Boston, and Laura Atwood. Suzanti Fallingstead, I see you in here. You can begin for 2 minutes when you're ready.
Thank you, Vice Chair Moon and members of the House Judiciary Committee. My name is Suzanti Fallingstead. I live in Rockville, and I'm testifying in favor of HB 559 on behalf of Maryland Against ICE Detention, a statewide coalition of over 60 organizations and 200,000 individuals. I've taken a PBJ or probation before judgment plea in traffic court, and I benefited not having my insurance rates go up and simply paying a fine and not having and completing probation successfully. So I was appalled to learn that under federal law, a non-citizen, including green card holders, would face dire outcomes, including possible deportation for taking a PBJ plea when a judge had determined that it was an appropriate option. Furthermore, non-citizens are often led to believe by attorneys ignorant of how federal law views this, that a PBJ plea will not cause them a problem if they successfully complete probation. This has led to many being denied citizenship or being deported and separated from their families based on infractions for which they might not have even been convicted if it had gone to trial. Because of this inequity, attorneys who do understand the consequences advise clients to take the risk of a full trial rather than rely on a PBJ. In addition to the added risks and costs for these non-citizens, this burdens the Maryland courts and prosecutors with unnecessary trials for offenses that would otherwise be assigned a PBJ. HB 559 will make minor changes to the law that would ensure the PBJ will no longer be considered a conviction under federal law and thus reduce harm to our non-citizen neighbors while also reducing the costs and burdens on the criminal justice system. Maryland Against ICE Detention urges a favorable report on HB 559. Thank you.
Thank you. Next, we'll hear from Kate Sugarman.
Hi, good evening, Vice Chair Moon and Chair Clippinger and members of the Judiciary Committee. I was born and raised in Baltimore City. I'm now a practicing public health family doctor living in Potomac, Maryland. I am the co-chair of the Maryland chapter of Doctors for Camp Closure. The Maryland chapter of Doctors for Camp Closure strongly supports HB 559, and we urge the committee to report favorably on this legislation. We are part of the National Doctors for Camp Closure organization, which is a nonpartisan organization of over 2,000 physicians and healthcare professionals. We oppose all inhumane detention of migrants and refugees who are attempting to enter the United States. Currently, as you know, if a judge warrants it and the prosecution and defense agree, the judge can impose PBJ, and if the defendant completes the term imposed without problems, there's no conviction on their record. Unfortunately, under federal law, this is still considered a conviction, and thus for non-citizens, including green card holders, it can result in issues ranging from citizenship denial to detention, even deportation. We know this is clearly not the intent of the Maryland legislature. We know this is unjust. As physicians, we know as eyewitnesses that there is no healthy amount of time for an immigrant to be detained. We have been inside immigration detention centers, and we know how hazardous these places are, both to the immigrants and their families. COVID, Omicron variants, all the health hazards have only gotten worse over the past 2 years. Serious illnesses and death occur due to COVID, and we see this getting worse during the pandemic. In addition, family members suffer when their mothers and fathers, husbands and wives are deported. Families lose their wage earners, children lose their mothers and fathers. These children can no longer concentrate in school, and they suffer a host of psychological consequences. They have permanent scarring. The Maryland chapter of Doctors for Camp Closure urges a favorable report on HB 559. Thank you.
All right, thank you. Next, we're going to hear from John Gossard. You need to unmute yourself, Your Honor.
Can you hear me now?
Yes, yes.
Thank you, Vice Chair Moon, and thank you, delegates, for the opportunity to testify in support of House Bill 559. By way of introduction, I am a retired United States immigration judge. I served 31 years on the bench in Baltimore, and at the time of my retirement, I was the third most senior United States immigration judge in the country. Today, I urge you to do the right thing, the fair thing, the just thing, and move this bill favorably forward. The current Maryland probation before judgment statute is discriminatory, notwithstanding and albeit an unintended purpose. It is so because it does not protect all Maryland residents. It successfully protects Maryland residents who are U.S. citizens. It does not protect those who are permanent residents, green card holders, non-immigrants, students, employers, visitors. This is so because while its intent and purpose is to give an opportunity to an individual for a second chance, an opportunity to rehabilitate and go forward and not have a conviction, under federal immigration law, under the definition of conviction, it is a conviction. During my career, I have heard many cases of non-citizens who were given the benefit of Maryland's PBJ, where they believed they would have the opportunity of a second chance to rehabilitate, to make restitution, an opportunity to learn from their mistake and move forward. Unfortunately, the federal consequences for those individuals deemed worthy by Maryland prosecutors are devastating. No second chance, and in most circumstances, removal, deportation, a life of banishment, a loss of family, friends, community, livelihood, their home. This is the story of Daryl, a case that I heard. He was a permanent resident, married to a United States citizen with 2 U.S. citizen children. His family resided in the United States. He was gainfully employed. He owned a home. He paid taxes in Maryland. He made a mistake, a minor mistake. He was given the opportunity to have probation before judgment, something that he welcomed because it gave him the opportunity for a second chance. Unfortunately, under federal immigration law, he was subjected to mandatory detention and brought before me. The statute accorded him no second chance, no discretionary opportunity. The rigidity of the law precluded this, and I was forced to order him removed and deported. After his deportation, his wife wrote me a letter and said, "Judge Gossard, may God forgive you because I cannot. You have destroyed my family." That day I ruled correctly under the law, but I did not do justice. I ask you please to do the right thing, the fair thing, the just thing, so that there are no more Daryl stories, and so that we can have probation before judgment for all Maryland residents, whether citizen or not. I thank you for your attention.
Thank you very much. Next, we're going to hear Dana Boston for 2 minutes.
Thank you, Vice Chair Moon. My name is Dana Boston. I'm Assistant Public Defender in Caroline County, Maryland on the Eastern Shore. I've held this position for the last 10 years, representing indigent clients charged with crimes in both the district and the circuit courts. During my career as a public defender, I've represented thousands of individual clients. A sizable percentage of my clients are non-citizens, largely from Central America, who now call the Eastern Shore their home. These communities are made up of families that have set down roots. Many of these hardworking people are here as lawful permanent residents and are in the process of obtaining United States citizenship. As in any community, there are bound to be issues related to crime. Nonviolent misdemeanor offenses make up the bulk of these cases. However, due to the current wording of the probation before judgment statute, nonviolent first-time offenses often have disastrous consequences for non-citizen clients. As the statute is currently constructed, immigration judges are bound by federal law to consider a Maryland probation before judgment as a conviction for immigration purposes. Thus, even in cases where everyone on the front lines, i.e. the police, state's attorney, and the judge determined that a non-citizen defendant should be entitled to a second chance, federal immigration courts are forced to treat a PBJ as a conviction. This often results in my non-citizen clients being detained for lengthy periods, awaiting their hearing in federal courts, which are notoriously backed up even by the standards of the legal community. It can result in their applications to become United States citizens being delayed or outright denied, and in some cases mean mandatory deportation. I've seen families undergo extreme hardship and even torn apart as one of the primary breadwinners, dad, mom, brother, sister, are forcibly removed from the community and sent packing, leaving those who remain to pick up the pieces. It's fundamentally unjust when all of the parties to a criminal action reach a fair and equitable resolution, only to have this decision overridden by a distant federal court who are not permitted even to delve into the intricacies of the defendant's situation. It's time to remedy this glaring inconsistency in the law that so egregiously affects those in our Hispanic communities. Virginia and New York, amongst others, have already taken the steps to address this. They have modified their own PBJ statutes in a similar vein, and immigration courts have confirmed they will respect the changes that the new statutes have on how they're required to view probations before judgment.
We're about at time.
I just urge your support for House Bill 559. Thank you.
Thanks. Next, we'll hear from Laura Atwood for 2 minutes.
Hello, Chair Clippinger, Vice Chair Moon, and members of the House Judiciary Committee, and thank you for the opportunity to testify. My name is Laura Atwood. I've lived in Maryland since 1999, and I represent Tacoma Park Mobilization, a local grassroots organization of over 2,500 people. We are in support of HB 559. One of our organization's core values is to recognize and act on the fundamental humanity of our neighbors and community members. If we all look inward honestly, how many of us can say that we and our loved ones have lived 100% perfect lives versus How many of us have made some mistakes, genuinely learned from them and made appropriate amends and gotten to move forward? As others have described well, the PBJ system in Maryland is meant to be fundamentally constructive for individuals and pragmatic for the judicial system. HB 559 would correct a technicality that too often lets it be used against its intended spirit, a technicality that lets non-citizen Maryland residents suffer disproportionate consequences anyway. As we know and see, we can see the faces of individuals this has happened to. Deportation too often means family separation or even a death sentence. Please continue working toward constructive justice for Maryland residents, honor the spirit of PBJ as originally passed by the Maryland State Legislature, and amend this statute. Tacoma Park Mobilization urges a favorable report on HB 559. Thank you.
All right, thank you very much. And it does not look like there are questions for this panel, so thank you, everybody. Oh, wait, we got one from Delegate Cardin.
Just very quick, thank you, Mr. Chair. Just very quickly, if Judge Gossard's still on, yes, I see you. I just wanted to thank you all very much for your compelling testimony, all of you in this esteemed panel. But Judge Gossard,
yes.
Am I to understand when your specific example, because everybody has, Mr. Boston said this, a lot of people have said this, that your hands were tied, even though there was an agreement among all parties, there was no way for you to not deport this person who this example that you gave, or other people, that the law was clear that there's no way for you to do it unless we change the law here.
Absolutely correct. Had I had the opportunity to exercise discretion in Darrell's favor, I would have in a minute. He had so many things going for him. He made one mistake. We all make mistakes. Unfortunately, because he was a green card holder and not a citizen of the United States, there was no discretionary relief under the statute, no opportunity for a second chance under federal immigration law. And as a result, I had to have him removed and deported from the United States, something that continues to live with me.
All right, thank you very much. Now it looks like we have no further questions for this panel. Thank you all. We're going to call up the next panel. We got a couple more of these. Robert Hill, John McCarthy, Lila Meadows, Jessica Emerson, and Luz Chavez Gonzalez. We have Robert Hill.
I'm sorry. There we are. Vice Chairman Moon, Robert Hill with the State Attorney's Office for Montgomery County. Is John McCarthy actually is the person that you want to hear from? Do you have him on the list?
I do. I think I see he's here.
If we could get him on, I would rather not waste time. I'd like to let you talk
Sure.
instead of me. If we could,
Mr. McCarthy, if you are here, you can go ahead and unmute, and you've got a couple minutes.
Okay, thank you, Delegate Moon. Thank you very much. Thanks to Delegate Fisher, who is the sponsor of this bill. Look, I'm the state's attorney for Montgomery County, and my population, we're the largest population in the state, but probably more importantly for this particular bill, I represent the most people in the state affected by the consequence, which I think is manifestly unfair. And I'm here to speak strongly in favor of House Bill 559, because I have seen the collateral consequence of the federal government not recognizing PBJ the way Maryland has recognized it. There are many things that have been said by people that preceded me here tonight. We have a process in place. We in Marylanders have made a decision. These people deserve this particular break. I mean, to some extent, I think this is a states' rights issue that is ultimately frustrated by the federal government not recognizing what Maryland has chosen to do after a judicial decision has been made about a case. I will also tell you, as I listen to today's conversation, there's a lot of other benefits to this bill. Look, I will tell you, we've been tortured for many years, for the last 20 years, as the collateral consequences in terms of deportation have ratcheted up in criminal matters. We've made thousands of immigration-friendly pleas to make sure that the collateral consequence, such as the one you see when the PBJ is not recognized by the federal government, doesn't happen to someone who doesn't have citizenship here in Maryland. I think this will resolve criminal matters more quickly. It will reduce, I think, it might have been Judge Baer mentioned it, post-convictions. Look, I think this is just fair. The fact that as the consequence of a completely minor matter, someone would be separated from their family is an outrageous consequence. I would urge that the committee favorably vote out House Bill 559. And again, I say this on behalf of the thousands of individuals who live in my community that would greatly enjoy the protection of this bill. Thank you very much.
Thank you very much. Mr. Hill, did you want to testify too? You are signed up.
Actually, Mr. Vice Chair, I want to make sure that John was on, and so we're all set. Thank you. Have a good evening.
All right, great. Next, we'll go to Lila Meadows for 2 minutes.
Good evening. Once again, I'm Lila Meadows, and I'm a clinical faculty member here at the University of Maryland School of Law, and I'm testifying tonight in support of House Bill 559 on behalf of the Gender Violence Clinic. As other panelists have stated over and over and over again, the goal of House Bill 559 is to help ensure that a PBJ does not lead to a disastrous collateral immigration consequence, not only for the person who's subject to the PBJ, but also for their families who often depend on them for financial and other types of support. The only thing that I want to add to what you've already heard tonight is I just want to be clear that House Bill 559 does not eliminate accountability, including in cases of domestic violence. Under this bill, judges can still impose a PBJ where appropriate or pursue other types of dispositions where it's not, and they still have the power to place an individual under the court's supervision, to specify the conditions of that probation, and to sentence that person to a period of incarceration should they violate the terms of that probation. And so there's nothing in House Bill 559 that makes victims of domestic violence less safe in the state of Maryland. And in fact, it's the appropriate way to allow victims of domestic violence to engage with the criminal legal system without the fear that doing so will automatically lead to a deportation. And so for those reasons, the Gender Violence Clinic supports House Bill 559 and urges a favorable report. Thank you.
Thank you. Next, we'll hear from Jessica Emerson for 2 minutes.
Good evening, Vice Chair Moon, members of the committee. My name is Jessica Emerson, and I direct the Human Trafficking Prevention Project at the University of Baltimore School of Law. In partnership with the Maryland Volunteer Lawyer Service, the HTPP seeks to reduce the collateral consequences of criminal legal involvement for survivors of human trafficking and those populations put at highest risk of exploitation. I am also here in support of House Bill 559. Far too often in the rush to demonize undocumented criminal defendants, it is often forgotten that hidden among these individuals are foreign national victims of human trafficking who frequently have criminal records stemming from acts they were forced to commit by their trafficker. Arrest, detention, and even deportation of foreign national trafficking victims is not uncommon. Victims may be arrested for working without a visa, for prostitution-related charges, or for a range of other crimes, including theft and drug sales. National data bears out the regularity with which this occurs, as indicated by the 91% of sex and labor trafficking survivors, both domestic and foreign-born, who reported having been arrested at some point in their lives. However, while criminalized US-born victims are saddled with collateral consequences such as difficulties obtaining housing and employment, foreign national victims face the additional, far more severe consequence of deportation, allowing for some leniency in situations where a foreign national defendant is a first-time offender or where the crime is nonviolent, would reduce the risk of these life-altering collateral consequences, as well as allow for the possibility of connecting that victim with service providers who can assist them with pursuing the immigration relief they so rightly deserve as crime victims. As you've heard numerous times already tonight, House Bill 559 will reduce the risk of these harms by allowing a judge to grant a PBJ where the defendant would neither admit nor deny guilt, while at the same time not disputing the proposed facts of the case. While this bill may improve outcomes for foreign national defendants as a whole, as you've heard in the numerous testimonies before mine, for trafficking survivors, it contains the added benefit of avoiding the likelihood that they'll be deported as a direct result of a crime being committed against them, which is simply an inexcusable miscarriage of justice. For these reasons, the Human Trafficking Prevention Project at the University of Baltimore School of Law supports House Bill 559 and respectfully urges a favorable report. Thank you.
Thank you. We have one final person on this panel, Jacob Lickenbaum, who is someone we were having trouble with earlier. So Jacob, you got 2 minutes.
Apologies, Chairman and committee members. My name is Jacob Lichtenbaum. I'm an immigration staff attorney at CASA, which is the largest membership-based immigrant advocacy organization in the Mid-Atlantic region with more than 90,000 members in Maryland alone. CASA urges a favorable report for House Bill 559 because our members are routinely and significantly harmed by PBJ dispositions as a Maryland PBJ statute is currently structured. That Maryland PBJ is a conviction for federal immigration purposes hurts our DACA clients or young people who entered the U.S. unlawfully as children who stand to receive protection from deportation, permission to work in the United States. To qualify for DACA, a person must demonstrate, among other things, that they have not been convicted of a felony, a significant misdemeanor, or 3 or more other misdemeanors. In 2018, a DACA client of ours named Ryan, his name changed to protect his privacy, was charged with second-degree assault. The charge was ultimately no prost. Ryan pled guilty to disorderly conduct for which he received probation before judgment. By giving Ryan probation before judgment, the judge was likely sparing Ryan, who's only 19 at the time, from receiving a criminal conviction upon the completion of his probation. However, in the eyes of the immigration system, Ryan had been convicted of disorderly conduct. And so he will have to live with this guilty disposition, which could strip him of his DACA status and render him vulnerable to deportation for the rest of his life. So in the opinion of CASA, these minor but significant changes to the statute presented in House Bill 559 will allow our DACA clients and other members to live freer, safer, happier lives. Thank you very much for your time.
Thank you. And we've got one question from Delegate Shetty for a specific person.
Thank you, Mr. Vice Chair. I was not planning to speak anymore this evening. However, it's such a joy to see my Montgomery County State's Attorney friend, Mr. McCarthy, here with us this evening. So hello and welcome. I just wanted to ask, I know this bill has been introduced in the past. I don't recall if you or your office has weighed in the past, but I'm just curious. I know the bill sponsor has worked really hard on some amendments over the years to really make this a strong piece of legislation. Have there been any specific changes that have brought you out tonight to share with us your thoughts on the bill? It is a very important bill to my district. And
look, may I say, I strongly support the bill. My support was not sought in the past. That it was brought to my attention. When I read the bill, look, I've seen the consequences occur all too many times that just were no proportional relationship to the underlying crime. To me, this is really this is an easy call. This is not a complicated issue. And I think there's a lot of people that are disproportionately affected by this. Look, somebody asked a question earlier, said, and I think one of the judges commented about this. One of the things that is sad and frustrating, we have tried to make immigration friendly pleas for 2 decades in this office. And we'll make a plea today with an attorney who thinks they have given good advice to their client, only for them to come back to us on a reconsideration of post-conviction or quorum nobis, because the advice that they gave proved ultimately not to be satisfactory to the federal officials. And I think maybe Judge Baer said, then you have to come back and you're redoing the cases over and over again. Look, in terms of efficiency, in terms of fairness, in terms of the fact that I've been there for thousands of times when judges have made the analysis and the decision to give somebody a 641. They do it for good reasons, and they have to balance the interest of the community and the interest of the defendant at the same time. It makes no sense whatsoever to frustrate that policy and that process it's good law and it makes sense. And I think this is efficient and fair. And that's why I strongly support this bill as written. And I'm proud to be here.
All right. Oh, we got one more. Delegate Tolles, go ahead.
Thank you so much. I want to thank my good friend, Delegate Juanita Fisher. I know you've been working so hard on this legislation for many, many years. And I remember last year working in the State's Attorney's Office in Prince George's County, where you were working diligently with our office on this bill. So I just commend you for your work and your steadfastness on this. My question is for Ms. Emerson. I just had two questions, if it's okay, Mr. Chair, Mr. Vice Chair. The PBJs for human trafficking victims, how often do you see them in your line of work in the clinic? And then my next question is, how many residents of the state of Maryland do you assist with this type of issue in the clinic?
We see PBJs probably, honestly, a little bit less than we see stats and null process. Our clients are frequently picked up on survival-based and poverty-based crimes. We do see them fairly frequently, and actually we see them a lot with foreign national defendants, and kind of speaking for our partner organizations as well. And as far as the number of survivors or people put at highest risk that we serve, I think at last we're serving approximately between 50 and 60 per quarter.
In Maryland?
Yeah,
okay.
In Maryland. Well, just to kind of give you a little perspective, some are not necessarily Maryland residents, but have Maryland criminal legal issues. So we serve folks from around the country, essentially, if the nexus is Maryland or if they themselves are in Maryland, and we can be of assistance as local counsel.
Okay, so you feel this bill will be extremely helpful with your work in the clinic?
I think this would be incredibly helpful and incredibly just, because so many of the clients that we're working with, who are foreign nationals, are could essentially be deported and perhaps have been, and we don't know, for crimes that were committed against them, essentially. And so we work primarily with domestic survivors, but again, the collateral consequences for U.S. born survivors are housing and employment, not necessarily deportation and the dissolution of an entire family. I can't imagine anything less just than that, for deporting someone for a crime that's been committed against them.
Okay. Thank you, Ms. Emerson.
Thank you, Delegate. Good to see you.
Good to see you too. Thank you so much for that. Thank you. I think that was very helpful. So appreciate you for always being here. And thank you, Mr. Vice Chair. And again, thank you, Delegate Fisher, for your work. Thank you.
All right. Thank you, folks. I believe that's all the questions for this panel. Thank you, everybody. We are now going to bring on a couple favorable with amendments, Joe Riley and Carolyn Mills, if they are still with us. See Carolyn Mills. All right, and we got Joe Riley. All right, Joe Riley, whenever you're ready, you have 2 minutes.
Thank you, Vice Chair Moon. Distinguished members of the committee, my name is Joe Riley. I'm the elected state's attorney for Caroline County and the legislative chair for the Maryland States Attorneys Association. We are in support of this House bill with amendments. Most of the amendments are covered by Carrie Williams' testimony that has already gone on today. I would ask for another amendment in that the state join in this agreement. That's been the status of the bill the last 3 times I think it was proposed. It's not in there this time. The reason for that is while we've heard very compelling testimony from people talking about non-citizens that would benefit from this plea, I think you heard one of the proponents testify that it would benefit so many people as well. And I think this disposition is a very favorable disposition. It will become the new go-to disposition request for defense counsel. And while we're all in agreement that the federal government is not handling immigration as we would like to in Maryland, I'm not as comfortable saying that the federal government doesn't handle security clearances the way they should. As you heard the one proponent say that there's 300,000 Marylanders that have a security clearance. They would benefit from this. And that kind of puts me at pause. So I would ask that the amendment being that the state's attorney's office go along with this agreement, allow us to have some guardrails on this and act as a gatekeeper of such. Thank you.
All right.
All right.
Chair, are you back?
Yes, that's fine. And we'll hear from Carolyn Mills, please.
Good evening, Chairman Clippinger and members of the committee. My name is Carolyn Mills, and I am testifying today to show my support with a friendly amendment for House Bill 559 on behalf of State's Attorney Aisha Braveboy. We would urge a favorable report with consideration for that amendment. As a prosecutor in the Special Victims and Family Violence Unit in the State's Attorney's Office for Prince George's County, I'm very familiar with various trial outcomes, a probation before judgment being one of them. For many, the current probation before judgment statute has guaranteed a just result for victims while ensuring that criminal defendants remain employed, out of jail, and able to get necessary treatment without adverse effects. However, this just result is often not available for non-US citizens, as the current statute requires an admission and finding of guilt, which federal law deems a conviction and potentially leads to deportation. This new bill would allow the court to put a defendant on probation without a finding of guilt, given they comply with recommended services. My office supports this legislation's goal in expanding access to equal justice for all under the law, regardless of place of birth. We support with amendment because of our concern regarding individuals who are receiving a probation before judgment for crimes that are considered domestically related, which limits the ability of those offenders to own and possess firearms in the future, which we do feel is an important public safety consideration. The proposed friendly amendment satisfies this concern. Unfortunately, there's been a longstanding history in Maryland that does not afford many of our residents the opportunity to become whole without the threat of deportation. HB 559 corrects this injustice and extends protection under Maryland law to all defendants, regardless of where they were born. Again, this change will allow state's attorneys like myself an option they currently do not have, which is to hold someone accountable for their actions, knowing that the disposition, regardless of the person's immigration status and the nature of the charge, will not trigger detention or deportation. Currently, the only disposition that's safe or immigration friendly is a stead, and that's not always appropriate. That's not always an appropriate remedy because it does not make the individual accountable to the court. This new PBJ is a disposition that will allow the state to hold defendants accountable and ensure they're not placed in federal proceedings. For the foregoing reasons, I respectfully urge a favorable report on HB 559 with the proposed amendment.
Questions now, Delegate Fisher.
Thank you, Mr. Chair. Mr. Riley, it's good to see you as always. I just wanted to ask you, and thank you for coming to support with amendment this legislation. I just wanted to ask you quickly, when my office worked with Mr. Kroll on the amendments from MSAA, is the amendment you're talking about different from the ones we worked on and accepted from Mr. Kroll, or this is a new one?
Our committee, the legislative committee, voted to support with amendment that we be added in, as we have been on every version of this bill. I'm not familiar with what your conversations are with Mr. Kroll, but Mr. Kroll, as a person who was on that legislative committee, knows that that was the amendment that we were talking about, in addition to the amendments that both Ms. Braveboy's assistant has spoken to and Ms. Williams spoke about earlier, dealing with the domestic violence part.
Yeah, which we all took. I'll just make sure I follow up with you on those. Thank you so much, Mr. Riley.
Sure. Thank you for bringing House Bill 559.
Further questions? Seeing none, thank you all very much. We'll now go to the opponents. Sherry Rindall and Amy Wyckoff. Sherry Rindall for 2 minutes, please.
Good afternoon, Chairman Clippinger and other distinguished members of the committee. I'm Sherry Rindall, Affairs Director of State and Local Engagement. Founded in 1979, the Federation for American Immigration Reform has 12,300 supporters and members in Maryland. FAIR opposes House Bill 559 because it allows criminal aliens to avoid taking responsibility for their crime, as well as avoiding the immigration consequences that normally stem from conviction or sentence. Although immigration is the federal government's domain, the immigration consequences of criminal convictions are often reliant on state law definitions and procedures. Therefore, by eliminating both any admission by a criminal alien defendant and a formal conviction by the court, HB 559 would undermine federal law. Congress's intent in the Immigration and Nationality Act was for criminal convictions to have immigration consequences. Moreover, HB 559 could cause disparate outcomes for U.S. citizens and illegal aliens and legal immigrants. Both illegal aliens and legal immigrants, as you have heard, could be subject to ICE removal proceedings as a result of criminal convictions. Therefore, the courts may consider immigration consequences to illegal aliens and legal immigrants in determining their course of action, which would not happen necessarily with U.S. citizens. It's likely that U.S. citizens could receive harsher punishments for committing the same crimes, which would be patently unfair. Finally, eliminating or softening sentences for criminal aliens sends the wrong message. States should not be able to manipulate and subvert our immigration laws to keep criminal aliens in this country. For these reasons, FAIR opposes HB 559 and urges an unfavorable report. I thank you for your time.
Amy Wyckoff.
Thank you for this opportunity to testify. HB 559 is one of many bills this legislature has tried to pass that protects illegal aliens who commit crimes. Not only do the bill's authors want to allow more and more illegal aliens to make Maryland their home, but when they commit crimes, they want to prevent their deportation. This bill would change the probation before judgment, or PBJ, laws only for illegal aliens. Normally, offenders who use PBJ laws still have to admit guilt. But with HB 559, illegal aliens would go on probation without ever admitting guilt to a crime. Under federal law, PBJ is grounds for the deportation of illegal aliens. But if they do not have to admit guilt, they don't get deported. Senator Michael Huff believes this bill would be unconstitutional. Quote, constitutionally, you can't say, well, you committed a crime, but we're going to pretend it's not guilty. And that's what they're trying to do. They're trying to create a new fiction in the law where you committed a crime, you were found guilty, you were basically put on probation, and they're then going to pretend it didn't happen so you don't get deported. An illegal alien, that was end quote, an illegal alien in such a case has already violated the laws of the United States by entering the country illegally. Then the illegal alien committed a crime in Maryland. How many crimes do we allow illegal aliens to commit before deportation is deemed inappropriate? When do we enforce the laws of our country? Where is the commitment to the safety of American citizens and legal immigrants? I heard in some of the supporters for this bill, the idea that these illegal aliens made only one mistake. No, they made two mistakes. The first mistake was entering this country illegally. Anyway, please give HB 559 an unfavorable report. Thank you.
Questions to the panel, Delegate Fisher?
This is from either Mrs. Randall or Mrs. Wyckoff. Are either of you an attorney?
I'm not.
Okay, you're not, Miss Randall? No.
I am licensed in California, but I am not an attorney in either Maryland or in the district.
Okay, Miss Wyckoff, for an undocumented immigrant, that's another conversation. Do you believe someone here on a student visa or any certified immigration status is illegal?
40%, approximately 40%.
That's not my, I'm asking you, do you believe that someone here on a student visa or any legal form of entering our country is illegal?
No, if you can't
Okay,
enter the country
so
legally.
the bill applies to everyone that has an immigration status. Do you understand that in the bill?
Well, if that's the case, I mean, you can deal with that separately, but this bill, it's.
Do you
quite
understand
known
that
this
criminal
bill is
law applies
clearly
to
made-
all residents? You cannot codify criminal law to a certain person. Do you understand that a criminal law applies to all residents?
I care about how this bill applies to illegal aliens. Thank you.
Okay, undocumented individuals, okay.
Illegal aliens.
Delegate Cox?
Thank you, Mr. Chair. Ms. Rendell, are our immigration laws privileges or rights when we grant a student visa?
They are absolutely privileges, and our visas are for a certain reason. For example, the one that was the student visa, they're here to go to the school, but if they do something that violates the law, they are subject to deportation.
And thank you. And so the same would apply if an American, for instance, was in Cali, Colombia, where I was 2 years ago. If I did something wrong, they would pick me up and deport me back to America. Isn't that the way it generally works around the world?
Yes, every country has their own laws, and we are to respect them. What we're saying is that the state shouldn't subvert federal immigration laws to their whims.
Thank you. Thank you, Mr. Chair.
Are there further questions for this panel? I think I have too many questions for this panel. Yeah, but I'm going to hold my fire. Thank you very much. Seeing no further questions for this panel, that concludes the testimony on House Bill 559. That concludes the business of the House Judiciary Committee for today. So we will be back tomorrow again at 1 o'clock for a further set of bill hearings.